For the next speaker for the day, we have Ms. Hawa K. Usman. It's a privilege to welcome you, ma'am. She's a Registered General of Nigerian Chambers of Commerce Dispute Resolution Center and General Counsel to the Abuja Chamber of Commerce and Industry. With over 15 years of experience in litigation, ADR, corporate law, and legal advisory, she is a highly respected voice in Nigeria's legal and dispute resolution landscape. Ms. Hawa is a fellow of several prestigious institutions, including the Chartered Institute of Arbitrators UK and the Chartered Institute of Mediators and Conciliators Nigeria. Her dedication to access to justice, mentorship, and community empowerment through legal education and advocacy is truly inspiring. We invite you, ma'am, to share your insights on the area landscape in Nigeria and to contribute to today's dialogue. The floor is yours, ma'am.
Thank you very much for having me. Can I confirm that you can hear me very well?
Yes, ma'am, you're audible.
All right. Good morning, good afternoon, and good evening to everyone, depending on where you're joining from. It is my honor to be part of this gathering today and to thank the Global South ADR THIRUNAAL. I was also taken emotionally by what Mr. Sharukumar was saying earlier about institutional arbitration and the importance of recognizing it within a country's arbitration landscape. And I thank the organizers for the invitation and for creating this important platform for voices from the Global South to shape the future of international arbitration. As I have already been told, my remarks will explore Nigeria's positioning as a key stakeholder in international arbitration, highlighting both public and private sector engagement, recent development, and notable decisions that have shaped the arbitration landscape in Nigeria. As you are aware, Nigeria is Africa's largest economy and a major hub for international commercial arbitration, foreign direct investment, and cross-border projects, especially in the areas of energy, infrastructure, and telecoms. Consequently, disputes of international character are just inevitable within the Nigerian landscape. And over the years, both the public and private Nigerian parties have emerged as active users of international arbitration. Nigeria has never been a passive respondent in any arbitration proceeding that it is involved. And the trend is that I will now, can you move forward in my slides? I think you could go to the, thank you. Yes. So I would like to share Nigerians, both the government and the private sector involvement within the international arbitration landscape. And, you know, as I have given the background, Nigeria is a major player. And that has made, and this has been possible through Nigerian government increasingly use of arbitration clauses in contracts involving major project infrastructures, the private public partnerships, bilateral investment treaties that have been the result of some of the recent international arbitrations that Nigeria have been involved recently. And these also agencies like the Nigerian National Petroleum Corporation, which is the major stakeholder in the oil and gas industry in Nigeria, the Ministry of Finance and other state entities have frequently been parties to high-value arbitrations in international arena. Often, these arbitrations are seated either mostly abroad and governed by international rules. The Federal Ministry of Justice too in Nigeria have recently promoted a lot of policy initiatives to enhance arbitration use in Nigeria. Creation of specialized arbitration units within government organizations. So recently we have organizations like the NDIC, the Nigerian Deposit Insurance Corporation, the Nigerian Upstream Regulatory Commission, emphasizing the use of ADR and creating specialized ADR units within their organization to promote arbitration, mediation, and negotiation as the case may be. Also, in terms of the private sectors, a lot of organizations and companies, you can move to the next, please, the next. Yes, so I'll talk about the private sector, which has also been major actors through their use, increasingly use of arbitration to resolve disputes across borders, especially under, you see them use the arbitration rules under the ICC, the London Court of International Arbitration, and also the UNCITRAL and ICSID and other regional arbitration institutions. State entities I have already mentioned, like the National Petroleum Corporation, banks, telecommunication companies, and lots of other companies in the oil and gas industry have routinely opted for arbitration as a mechanism for resolving disputes within the Nigerian landscape. This has made Nigeria, it has shaped the significant trends of the Nigerian arbitration landscape. So the recent legislative reform, which is very key to us, in 2023, the arbitration or the ADR community in Nigeria rejoiced over the significant turnaround of the arbitration landscape. The Arbitration and Mediation Act 2023 was reenacted to go to the next. Yes, can I have the next slide, please? Yes. So the Arbitration and Mediation Act of 2023 became the most transformative development in the Nigerian arbitration landscape. It repealed the decade-used Arbitration and Conciliation Act of 1988, which was long overused and overdue for reenactment as at that time. And the key innovations that act actually outlined to make Nigeria a hub of arbitration and put on global landscape in terms of arbitration is the fact that the Act now aligns with the UNCITRAL model law of 2006, which reinforces Nigeria's credibility as a modern arbitration jurisdiction. Also, the recognition of third-party funding, which has previously not been the case, was made prominent by that 2023 Act. The provision for emergency arbitration, which enabled parties to obtain urgent relief before the constitution of a tribunal, is also a significant transformation in terms of the arbitration landscape in Nigeria. The Act also make clearer framework for arbitration-related court intervention, which is also key, as I have heard Mr. Sharukumar mention. The role of court is so essential in terms of promoting arbitration and a country's opportunity to be seen as a global hub for arbitration. And there is also the surge of domestic and regional arbitration center, such as our own dispute resolution center, which was inaugurated in 2017 as a major player in the commercial dispute resolution landscape within the country and also outside of the country. There is the Lagos Court of Arbitration is also a significant institution that promotes the use of arbitration. The Lagos and the Abuja multi-door court houses, most states within Nigeria have adopted the use of multi-door court houses in promoting ADR and arbitration in particular The Regional Center for International Arbitration is also a significant, I think it's one of the three most prominent regional arbitration centers within Africa. And Nigeria have seen have since seated the Regional Center for International Arbitration, which is a center that is recognized and also promoted by the Nigerian government. Uh, arbitration, sectoral arbitration also have gained traction. You could move to the next slide, which is also talking about emerging trends and development within the Nigerian arbitration landscape. We have seen sectoral arbitration practice, like I have mentioned, the oil and gas industry, the construction industry arbitration, telecommunications, and the banking sector, which has had the NDIC inaugurate its own ADR unit. And to talk about, yes, please move to 2 slides away from here. Yes. So Nigerian courts, like I said, have played a significant role in shaping arbitration jurisprudence particularly through the support that it had given arbitration in Nigeria, enforcing both arbitration agreements and also the enforcement of arbitration awards. And a notable feature of this journey is the increasingly supportive stance of the courts in Nigeria. Several court decisions have affirmed the sanctity of arbitration agreement and the finality of the arbitration awards, and have helped in enforcing and promoting arbitration as a viable means of dispute resolution. The case of Kano State's Urban Development Board versus Van Construction is a significant case in the arbitration landscape of Nigeria. That case has the Nigerian court observed that disputes or differences which the parties to an arbitration agreement agree to refer to arbitration must consist of justiciable issues that can be tried through civil law, and that cases like criminal cases, of course, cannot be offenses, or offenses cannot be subject matter of any arbitration and tribunal. This is to emphasize the public policy use of arbitration within the country. And we have cases like the Nigerian National Petroleum Corporation, NNPC, versus Fongtai Engineering Co. Limited. This is a landmark decision in Nigeria, which has the Nigerian Supreme Court reinforced the country's pro-arbitration stance. And it also underscores the finality of arbitration awards. And in that case, the dispute arose between the parties. And in the agreement of the parties, there was a recognition of arbitration as the mechanism for resolving dispute within the country. And in that case, it resulted to an award, in favor of the respondent company, which is for about $17 million and about over 22 million naira. And the NNPC initially offered to settle for a lesser amount, which the company initially accepted, but later retracted, insisting on full payments. And the company later sought to enforce the award in the Federal High Court of Nigeria. Initially, the NNPC, which is the organization against which that award was given, sought to set aside that award. But the Supreme Court upheld the award, and the decision underscores that Nigeria is actually been very supportive of arbitration, whether it involves states, individuals, or companies. And although that judgment was under the Arbitration and Conciliation Act, which is now been repealed, but it is important to note that regardless of the case, that arbitration and that the decision that from that case still stands as it is here in Nigeria. Move to the next slide. Yeah, so another significant case is also this Statoil Nigeria Limited versus NNPC, where the court was very instructive as it evidences whether courts are supposed to intervene or render more assistance to arbitration. And I think in that case, the courts reinforced the fact that the principle of arbitration must be upheld, and that the court emphasized that the enforcement of awards, even against state entities. It is important to note that there are several of such kind of cases within the Nigerian judiciary that have supported arbitration. And these decisions illustrate a gradual but definite evolution towards judicial deference to arbitration. It establishes the important principles that are critical factors in making Nigeria an arbitration-friendly jurisdiction and a hub within, not only in Africa, but globally. I have talked about the significance of the Arbitration and Mediation Act of 2023, which governs all domestic and international arbitration seated both in Nigeria and outside Nigeria. And to also note that Nigeria is a signatory to the New York Convention, and Nigeria have also signed various bilateral investment treaties which provide for investor-state arbitration. The growth of arbitration institutions, like for both public and private in the country, like I've mentioned, the GSADRT is one of such arbitration institutions, re-emphasize the fact that arbitration is being recognized in Nigeria and is being taken seriously, and Nigeria is doing a lot in that field to see that Nigeria becomes a global hub for arbitration. And inventions like this, recently the Federal Ministry of Justice in Nigeria also issued a national policy on ADR and arbitration. And that policy is to emphasize the use of arbitration and to create a standard. You know, Nigeria recently was involved in so many international arbitration, and significantly, the Nigerian case against the PNID is instrumental to the positioning of the national ADR policy, because it is important for Nigeria to place itself and to also create a standard within which all arbitration institutions can perform the functions of arbitration. You can go to the next slide. Yes, I've talked about the development in the institutional landscape of legal framework of Nigeria. The regional center, like I have mentioned earlier, is one of the oldest ancestral regional centers in Africa. We have the Lagos Court of Arbitration, which offers state-of-the-art hearing facilities and a user-friendly set of procedural rules. And the Nigerian Chambers of Commerce Dispute Resolution Center, with its comprehensive arbitration rules that encourage expedited proceedings for businesses within 90 days, is also significant in terms of the institutional landscape of arbitration in Nigeria. And the Chartered Institute of Arbitrators UK, the Nigerian branch, which is also a leading capacity building and training for advocacy in arbitration within Nigeria have gained significant milestones. I have become, I was trained under this institution to become a fellow, which is, and I know a lot of Nigerian lawyers and arbitration practitioners have been trained through this means too, in terms of promoting advocacy in the arbitration hall. And the Arbitration and Mediation Act, I've mentioned the arbitration policy, which is also a significant transformation in terms of arbitration used in Nigeria. I've spoken about the notable arbitration cases. There are lots of, so many arbitration cases that you could find that have the Nigerian judiciaries in supportive of arbitration and promote arbitration practice within the Nigerian landscape. We also just mentioned that despite all this significant progress that we have made in Nigeria, Nigeria still grapples with a lot of issues, which is the last leg of my presentation. You could move to the next. You can move to the next slide. Yes, I've spoken about this, which is that the Arbitration and Mediation Act of 2023 have sort of standardized the issue of party autonomy, which is in any case the most important part of arbitration as a private means of mechanism of dispute resolution. It provides for a lot of default provisions that reduce ambiguity and judicial recourse. So this is to see the judiciary play a supportive role rather than interference with the arbitration proceeding. And that act has also encouraged the use of mediation, which is the first time Nigeria is having a codified rule to support mediation within the ADR landscape in Nigeria. The government of Nigeria recently introduced the policy on ADR, which I have mentioned, and that's legal and institutional framework positions Nigeria to compete with emerging arbitration hubs globally. So significantly, Nigeria's institutional and legal framework, I think, have done well in terms of placing arbitration as a significant mechanism for dispute resolution globally. Just to state that despite all this progress that we have made, there are some issues. And just like Mr. Sharukumar have mentioned for India, it is also the issue here in Nigeria, the fact that for institutional arbitration, there is need for the legislation to also emphasize the use of institutional arbitration. That way, other emerging ADR centers like ours will be put into a significant use as it should be. We have a lot of other institutions, but for us under the Chamber of Commerce, it's the opportunity for businesses and small-scale industry businesses to use this arbitration center. It's also important because the center actually came out of need for SMEs and small scale businesses, which are the major part of the chambers of commerce. And the fact that for ad hoc arbitration, it might be too expensive for businesses that are just starting up to use the ad hoc arbitration proceedings. So so institutions like the NCCDRC becomes very significant as it's lessen the burden with a very the charges are a bit low for businesses to be able to to take advantage. So it's not costly. It's significantly low, and it's important for such kind of institutions to be promoted so that other businesses that cannot afford the service of bigger institutions can also take advantage of these institutions. Go down to the next. Yes, okay, so to talk about the current challenges, the fact that there is mostly enforcement delays in terms of both foreign and domestic arbitral awards. Sometimes it takes too long to 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 get these awards enforced in courts. And I think there was recently in 2021, a law firm carried out a review of how much time it takes to enforce this kind of awards. And I think between the High Court to the Supreme Court, it could take about 8 to 10 years, which is, I think, the most issue with judicial enforcement of the awards. And to also say that one of the difficulties that we find, which is also the problem that we must address, is the fact that while improving, the judiciary sometimes can overreach arbitration proceedings. There are occasional instances where courts intervene prematurely or even unnecessarily in arbitration matters. And the fact that there is limited understanding of the use of arbitration in the SME cycle. A lot of companies or organizations have not understood the significant value that arbitration brings to their businesses. The fact that despite the capacity that have been built in a lot of organizations, there is a greater need for awareness and technical capacity, even among lawyers, among judges, among institutions on complex arbitration issues, especially international investment law. And the fact that there could sometimes be political or bureaucratic resistance in terms of government agencies being reluctant to comply with awards, citing either public interest concerns and also the perception issues of cases like the P&ID case in Nigeria that have created reputational challenges for Nigeria. Although the Nigerian success in setting aside that award shows a commitment to due process in the Nigerian arbitration landscape. So I would say that Nigeria stands at a very transformative point in its arbitration journey, armed with modern legal framework like the Arbitration and Mediation Act, the Arbitration and ADR policy. Yet challenges will remain, especially in terms of enforcement and perception. So as arbitration stakeholders from Global South, I think that our collective focus should be on strengthening domestic institutions, especially like the NCCDRC, enhancing cross-border collaboration, which is one of the things that this tribunal is doing today, and the fact that ensuring that arbitration serves the ends of justice and economic development. So advocacy will have to continue in terms of what we're talking about. I think I'll just stop here before my time goes off. Thank you very much.
Thank you, Hawa. It was a very interesting input from the West African nation, and the way the new Arbitration and Mediation Act 2023 has come into force and how it's going to function. One interesting thing analyzing this development, or particularly when it comes to as a policy implementation and review,
Yes.
the provision in para 19 in the policy which establish a 5-year implementation timeline along
Yes.
with requirement for review to align with the existing trends of arbitration and ADR. I feel it is quite a proactive aspect of the policy. What is your thought
Yes.
on it?
Yes. It is a proactive, like you have rightly mentioned, it is a proactive development in terms of making sure that arbitration is used significantly. And I think this is where all the other arbitration centers and arbitration institutions now will have to take advantage of that section and make sure that in terms of implementation, it is strictly implemented. For us at this center, what we are doing now is to make sure that in fact we plan to have a roundtable in the first week of June. The roundtable is for arbitration centers within the country or within this Abuja that we are, to come together and see how we could come up with strategies for implementation of the policy. So it's one of the things that we're looking at. What are the strategies that we could put in place to make sure that every section of the policy is being implemented as it should be implemented? Because quite apart from having good laws, implementation is also a key part of having the laws, which is one of the things that we as institution must be doing.
Thank you, Hawa. And we are very, very happy to hear you. It's a wonderful presentation. And your continuous support for the Global South ADR is particularly expected, and hope it's already done. And we'll take it forward in the right path so that in the next edition, we'll be in a constructive role within this 2 years or 3 years of the implementation of the policy. Thank you.
Thank you for having me, and thank you for the opportunity to contribute to this.
Dear all, I'm happy to invite you all to this forum. As a founder of Kovise Foundation Conflict Resolution International, it's a very happy moment for me that we are bringing in an alliance of Global South arbitration institutions. When we started the Kovise Foundation Conflict Resolution International, our main objective, being an agricultural arbitration consultant, my main objective was to bring in these conflict resolution professionals into the grassroots level, mainly for the rural communities. Later stage, as young lawyers have joined hands with me, and we promote this as an arbitration center. So it's a very proud moment for us, because it took some 9 years to come to this stage, and we are very proud, and we are very happy that you all have joined hands with us for a type of reformation. We can tell that in that we are going to take it forward in future. So in this contest, I like to get your cooperation till we achieve our goals. Thank you.
Good afternoon, good evening, and good morning, depending upon the jurisdiction. There is some issue with the particular recorded presentation, which has been shared by Mr. Pascal. We are just working to fix it out. At the outset, when you're dealing with the jurisdiction, particularly Middle East, Dubai as such, it's a region where there were multiple arbitration institutions facilitating the dispute resolution mechanisms, the way how it has to be on multiple fronts, particularly on the civil law system. Subsequently, there were some arbitration institutions which were promoted by the Chamber of Commerce, initially by the Dubai Chamber of Commerce and Industry, then the Emirates Maritime Arbitration Center. All these institutions were created, and it also stretched to some sector-specific arbitration institution. Ultimately, by a royal decree, all the institutions were combined and a new institution in the titled Dubai International Arbitration Center came into force. This is what commonly we can understand from the institutional development in the Middle East region. Similar to any other jurisdiction, UAE arbitration law is also a pioneer in this. And based on that, there were multiple other opportunities being a financial hub. One such institution which was developed happened to be the Dubai International Financial Center. And in that center, they did have the courts as well as an arbitration, which was earlier in the cooperation or a joint venture with the London Court of International Arbitration. It was called DIFC LCAA Arbitration Center. All these set together, what we can understand is that in Dubai, particularly on the front of institutional arbitrations, it is kept to understand that it is based on a common law jurisdiction confined with one particular area, and all others working on the civil law system as traditionally. This development which happened in the Middle East region predominantly also facilitated the not only the domestic arbitration, but the international arbitration also as a whole. But this growth of the Dubai International Arbitration Center, which reported quite an increase in the caseloads, when we look on the DIAC's 2023 annual report, it shows a drastic growth, that is more than 10% jump in the number of arbitration cases administered by the center. Literally, the statistics was mentioning around almost some 300 cases to some 325 or 330 cases. All these makes this particular region to be quite a valuable region for arbitration. What are these to be taken into consideration? The first significant one happens to be Article 10. This Article 10 of the UAE arbitration law, which permits the appointment of arbitrator when it comes to certain specific conditions to be met, like the arbitrator is not the sole arbitrator, the president of the arbitral tribunal. The arbitral tribunal submits a written undertaking confirming that they will refrain from exploiting the role in a manner that creates a conflict of interest or leads to them obtaining pertaining advantage or interest or influencing the arbitration proceedings during the period of such appointment. Here, very specifically, it has been identified that any violation of this particular article, Article 10, will result in invalidating the arbitral award. An annulment of an arbitral award was quite evident. And the parties have the right to claim civil compensation from the competent institution or the arbitrator, subject to all these vulnerabilities when it comes to those arbitrators being appointed. There are multiple other amendments. There's a big list of amendments, but interestingly, the creation of all combined together, the arbitration institution, the DIAC, and the complementing institution which also coexists, that is Arbitrate AD, that is Abu Dhabi Arbitration Center, which provide default seats of the earlier DIFC LCA 1 and the ADGM, that is the Abu Dhabi Global Market, respectively. And these institutions have been or to be chosen, and only in the event that the parties have not specified the seat, these institutions literally have the default seat to be Dubai or Abu Dhabi. Here, there are some other value additions when you look on the UAE arbitration legislation. Failing to swear under oath. In the late 2022, the Dubai courts invalidated an arbitral award because the witnesses' testimony on which the arbitral tribunal relied was not given under oath. Very interesting thing. Normally, a witness swearing in under oath happens in the courts. And in this case, the Court of Cessation in UAE concluded that the applicable rules, that is the Dubai International Arbitration Center rules 2007, required witnesses to testify under oath, and that an award based on the testimony of witnesses who did not undertake an oath would be rendered invalid. And the Court of Cessation didn't stop there. The court further observed that although the tribunal confirmed in its procedural order, one of its procedural order, that witnesses make their testimony under oath, unfortunately, the minutes of the hearing did not contain a record of that particular witness taking an oath before testifying. This happens to be a reminder of the importance of taking of oath and ensuring that this is or this has to be recorded in both the award as well as in the minutes of the hearing. So much of significance is given to testimony under the oath. However, it remains to be understood or seen whether the courts will adopt the same approach in cases governed by institutional rules, and that too expressly stipulating the witness's testimony must be given under oath. Recently, when Dubai International Arbitration Center amended its rules in 2022, they tried to provide or included one article, if I'm not wrong, it is 27.6, that the tribunal may require any witnesses to swear an oath prior to giving oral evidence. Very, very important. These might be a small variant which we feel that it has to be neglected or it can be avoided, but it is not the same when it comes to the jurisdiction like United Arab Emirates. Further stretching into some cases, what's predominantly happening in UAE, the General Assembly of the Court of Cessation reversed a decision by the UAE courts and found that the Dubai International Arbitration Center's decision to close a particular case file because of parties' failure to pay the arbitration cost does not constitute a waiver of the party's right under the arbitration clause. I'll repeat, it's a very, very a special thing to understand. The institution decision to close a case file. The reason behind the party failing to pay the arbitration cost. In this, interestingly, the case was closed. Particularly the party is failing to pay the advance on cost, and that does not constitute a waiver of the rights under the arbitration clause. That clarity was given, and that cannot be or used as a carte blanche reason for bringing proceedings before the onshore courts in the alternative. It seems to be somewhat a complicated one, but still, it is the existing development, what we can see. But still, many of the interesting reports, literatures about this arbitration practice have to look upon development, what we have. Here, the Dubai International Arbitration Center, which is quite having a significant role in the development of arbitration in that particular jurisdiction. The long-awaited Federal Arbitration Law of UAE, which was in 2018, having the base of unsettled model law, and undoubtedly constitutes really a landmark development in the arbitration in this country. But as a review, what we can analyze looking into the UAE is that prima facie, there is continuous development of arbitral landscape of UAE. The UAE has seen tremendous change in its arbitration landscape after the abolition of the DIFC LCA arbitration to the amendments of the UAE Federal Arbitration Law and the announcement of the replacement of Abu Dhabi Commercial Conciliation and Arbitration Center to Arbitrate AD in 2023. Having a understanding of Arbitrate AD, particularly when it was announced in first quarter of 2024, 15 members of its inaugural court, having first a gender diversified leader to that court in the Middle East, came out with a model, and it also constituted multiple jurisdictional professionals coming from Singapore, Turkey, the United Kingdom, Indonesia, Nigeria, South Korea, predominantly the global South countries. The wealth of knowledge and experience were combinedly brought in. Then it was structured with the Arbitration Rules 2024. Based on these, the Court of Arbitration of Arbitrate AD was created. What is significant about the Arbitrate AD, which is also predominantly handling arbitrations now in United Arab Emirates? Expanded multi-party and multi-contract arbitration mechanism. The Arbitrate AD rules expressively allow for multi-party and multi-contract arbitrations, as well as joinder and consolidation. These are quite prominent provisions which you can see from the traditional arbitration institutions like ICC, as well as the London Court of International Arbitrations, the consolidations. Yeah, for a moment, moving in. Yeah, thank you. Thank you for the organizers. Even though I am part of it, I am informed that the technical glitch has been sorted out, and Mr. Pascal is kind enough to patiently wait and facilitate the presentation. What he has shared with us from his side, he is going to share. Thank you for hearing me regarding the inputs. What as a practitioner doing arbitrations in Dubai and Abu Dhabi, I could share.
Right. Moving further, we are pleased to welcome Miss Laura, and Mr. Pascal, two distinguished professionals from Blackpool Group, whose combined expertise spans decades in the field of contract management, dispute resolution, and international arbitration. Ms. Gray, a contract and commercial advisor, brings over a decade of experience across the construction and energy sector with a strong command in FIDIC, NEC, and bespoke contracts. Her work on major infrastructure and renewable energy projects across Europe, the Middle East, Africa, and along with her contributions to high profile arbitration cases, reflects a strategic acumen and global perspective. Complementing her expertise, Mr. Pascal, CEO and Managing Director of Blackpool Group, who internationally recognized for his leadership in conflict resolution and ADR. With over 30 years of experience, Mr. Pascal has led dispute resolution efforts on landmark projects such as HIA Airport in Qatar and Intel Infrastructure's facility in Ireland, and has provided expert testimony in judicial contexts, including Supreme Court of Western Australia. Together, their excellence in commercial and legal strategy, and we are honored to welcome them to share their insights on the evolving ADR landscape of Dubai and beyond, and to enrich today's proceedings with their invaluable experience. In the meantime, we would like to thank all the participants who are continuing to be engaged in today's virtual event. We'd like to inform you that the next speakers have shared their presentation in a form of video recording. We'll be playing the video in a short, and the speakers will also be joining us shortly. The video is playing now.
My name is Pascal. Position onto an building Supreme Court. And with me is Laura Georg.
Aspect of the modern land for which they will be sharing today.
Okay, we will start. It's really great to be here today, representing Dubai for this amazing Global South organization. And I'm very thankful to Mr. Inbavijayan and his team for inviting Blackpool to speak at this esteemed webinar. My name is Pascal Baugh, CEO of Blackpool Group. I'm a fellow of the Royal Institution of Chartered Surveyors and a member of the Chartered Institute of Arbitrators. I've been involved in countless arbitrations and also in the delivery of expert testimony in all judicial levels to and including the Supreme Court. And with me is Laura Geary.
Hi everyone, I'm Laura Gary and I'm an associate member of the Chartered Institute of Arbitrators. I have over 10 years of experience in contracts. I have a legal background with attending the BPB Law School in London, and I've also been involved in dispute resolution cases globally and in Dubai. We are delighted to be here to discuss an important and dynamic aspect of the modern legal landscape, arbitration. Today, we will be sharing insights into the involvement of public and private entities in the global arbitration, exploring key trends and developments within our jurisdiction, examining influential court rulings, and providing an overview of the institutional arbitration framework, and of course, discussing the current challenges and critical issues shaping arbitration today.
The involvement of public and private entities in global arbitration is the premise of the webinar today. A brief overview of arbitration. Arbitration is playing a critical role in global dispute resolution, especially in cross-border commercial activities.
The Middle East, and particularly the UAE, have positioned themselves as a key arbitral jurisdiction through reforms, institutional developments, and legal modernization, and this can now be seen in Saudi Arabia. So let's begin with the role of the public and private entities in the global arbitration.
An overview. Arbitration, as we know, serves as a preferred method of resolving disputes, particularly in international commerce and investment. The involvement of both public and private entities significantly shapes the arbitration landscape, bringing unique challenges and considerations.
So, public entities. Public entities include government and state-owned entities. Public authorities, many know them as. And these entities frequently engage in arbitration, especially in sectors like infrastructure, oil and gas, energy, and large-scale construction projects. But one of the primary drivers for public entity involvement in arbitration is the need for, firstly, neutrality and enforceability, especially when dealing with foreign private interests. For example, in the UAE, where I currently work, ministries and public entities commonly include arbitration in concession contracts. DIAC and ADCCAC, Abu Dhabi, have handled disputes involving semi-government bodies. An example of a state-owned dispute is in the case of Honeywell versus Maydan Group, LLC, UAE, where Honeywell instigated an arbitration against the Meydan Group, LLC, citing that there were contractual breaches related to the construction of the Meydan Racecourse.
Another significant case is the Nakheel Properties Arbitration, UAE, where Nakheel, a subsidiary of Dubai World, faced claims from contractors and investors over stalled real estate projects following the 2008 financial crisis. These cases highlight how public entities can be the respondents in arbitration, as well as being the usual claimants, emphasising the importance of having robust dispute resolution mechanisms in place.
It should be noted that due to the mass development in Saudi Arabia, which we're all seeing, and this particularly Vision 2023, has been encouraged for neutrality of arbitration on many contracts, including state-related contracts. This has seen such as NEOM and the Red Sea project using arbitration clauses to govern their contracts under SCCA rules, Saudi Arabia. The Royal Decree number M/34, 2012, you might want to note this down, allows the state entities to resort to arbitration with specific approvals. This sees Saudi Arabia following the successful formats in the UAE, which we all see today. Private entities. So, private entities, on the other hand, include multinational corporations, private businesses, and individual investors, construction and oil and gas, real estate, energy, finance, to emphasize some of the top sectors using arbitration today. These entities often turn to arbitration for resolving commercial disputes, contractual disagreements, or cross-border trade issues. Therefore, seeing arbitration clauses as the common place, particularly in JVC agreements, credit contracts, of course, and shareholder disputes.
An example of a private arbitration is the Raiffeisen Zentralbank Österreich AG versus 5-Star General Trading LLC. However, one party challenged the award in court. The case reached the Court of Appeal, where the party appealed the arbitrator's decision on a point of law. This case involves the financing and insurance of a vessel. Also, in another case, the Narciso versus Nash case, that's UAE DIFC Court of the first instance, addressed the enforceability of the DIFC/LCIA arbitration agreements, underscoring the jurisdictional complexities involved in cross-border disputes.
But it should be noted, which has been a course of discussion for the past 2 years at Dubai Arbitration Week, is the growing presence of regional family-owned conglomerates and SMEs using arbitration. Well, there's many reasons for this, but with the handover of family businesses to the next generation, this can cause different ideals on driving the business forward, and this can lead to disagreements over the business and the future of it, which sometimes needs to be sexually resolved with the intervention of an arbitrator.
It is essential to understand the distinctions in procedural approaches when handling disputes involving public versus private entities. For instance, in cases involving public entities, issues such as state immunity and enforcement against public assets often arise. As seen in cases like the Dubai Court of Cessation Judgment number 735, 2024 in the UAE, In contrast, private disputes typically focus on contractual interpretation and financial settlements, as demonstrated in the Raiffeisen Zentralbank Österreich AG versus Five Star General Trading, and that ended up in the UK Court of Appeal.
There has been great growth in the Middle East with regards to arbitration in the last 10 years or so, and therefore making a significant competitor with the traditional arbitrational houses of London, Paris, New York, Stockholm, and let's not forget Singapore. This can be seen with DIAC being restructured under Decree number T4 of 2021. It's consolidated the DIFC and LCIA in the UAE. Saudi is rapidly growing credibility with its rapid growth and its 2023 SCCA arbitrational rules. One of the most significant trends is the increasing use of hybrid arbitration models, combining institutional rules with ad hoc flexibility. This trend reflects the need for structured processes while allowing parties to tailor specific aspects of the arbitration to their needs.
Another key development is the focus on efficiency. Many arbitration institutions have introduced expedited procedures aimed at reducing the time and cost of dispute resolution. This is particularly beneficial in commercial cases, where prolonged arbitration can impact business operations.
Digital and remote hearings have become more common, particularly after COVID-19 pandemic. And these innovations improve accessibility, but also introduce challenges related to data security and procedural fairness. But let's remember that SCCA Saudi Arabia has launched the SCCA case management platform, engaging end-to-end digital arbitration.
Transparency is another critical area, especially in arbitrations involving public entities. As public funds or state assets are involved, there is a growing demand for more open and transparent arbitration processes.
Lastly, sustainability and ESG factors are increasingly considered in arbitration, and especially in Dubai, we're seeing sustainability coming to the forefront and an important part of the construction industry. As global awareness and around environmental and social government grows, arbitrators are being called to address disputes involving sustainability standards and corporate responsibility. As previously stated, there has been significant growth in the Middle East market with regards to arbitration. And this can be seen with the emergence of arbitration weeks in both Egypt and Lebanon. And Lebanon currently happening this week. With the focus on the UAE and Saudi Arabia, there has been some influential rulings by the local courts impacting arbitrations and ensuring the confidence that is given to arbitration in this region.
In the UAE, Dubai Court of Cassation judgment held that the Dubai courts had jurisdiction to hear a dispute despite one of the underlying contracts containing a valid arbitration agreement. DIFC courts recognised as seat neutral and arbitration friendly. allowed enforcement of non-DIFC seated awards. In Saudi Arabia, Enforcement Court in Riyadh 2020 recognized a US seated award under the New York Convention, confirming growing confidence in foreign arbitration.
It should be noted that Saudi courts have recently, first, dismissed objections based on Sharia non-compliance, provided commercial context is clear. Second, honoured arbitration clauses even when the government-related entities were involved, subject to cabinet approval.
Dubai's arbitration framework is governed by the UAE Federal Arbitration Law No. 6 of 2018, which aligns with UNCITRAL model law. The key institutions are, in Dubai, we have DIAC and DIFC. In Abu Dhabi, we have ADCCAC, where Saudi Arabia's institutions and law are based on the following: SCCA Rules 2023, based on UNCITRAL, but with local enhancements, all of which allows parties to choose foreign laws and seats.
These institutions offer well-defined procedural rules, including the ICC and LCIA standards, ensuring consistency in arbitration proceedings.
Furthermore, the New York Convention ensures that arbitral awards issued in Dubai are enforceable in over 160 countries, highlighting the global reach of the arbitration framework. And note to all, if you're going into arbitration with a foreign company, you need to be sure that the jurisdiction is signed up with the New York Convention, or the arbitration may be unenforceable. Arbitration continues to evolve as a fundamental method for resolving complex disputes, particularly where public and private interests intersect. The dynamic nature of SCCA and DIAC showcases the jurisdiction's commitment to maintaining a modern and robust legal framework. By adapting to new challenges and embracing hybrid models, digital innovations, and sustainable practices, arbitration remains relevant and effective. Practitioners must stay vigilant, informed, and proactive to navigate this evolving landscape. UAE and Saudi Arabia's proactive approach to maintaining a fair and efficient arbitration system underlines its status as a global hub for dispute resolution. Thank you for your time today, and we sincerely appreciate your questions and comments. We'll retrieve all contributions from the webinar chat. If you didn't have a chance to post your question, please feel free to email us at info@blackpolegroup.com and we'll get back to you promptly. If you'd like a copy of the slides or the full presentation, we'd be happy to share them upon request.
Thank you very much, Pascal, and it's been a pleasure to be part of this session. And I really appreciate your engagement throughout and everyone present here today.
I see we have some questions here. Will we go to the questions, or shall I answer them in the chat?
You should address them now.
So the role of the emergency arbitrator. Emergency arbitrator normally happens before a tribunal is formed, especially where speed, privacy, and neutrality is critical. So it's just a faster way of getting it done. Cases of freezing assets or preserving evidence. So it's a useful strategy when speed is of the essence.
I'll just jump in. So
Mr. Habib asked about technology, COVID, everything. So virtual hearings, digital platforms, we're seeing vast improvements and direction in that. Well, it's heading in that direction. But one thing I will say, as I said in the presentation, the SCCA, Saudi Arabia, is now created a digital platform, and that's really moving the space forward. So reducing costs, efficiency, and therefore we're seeing more cross-border arbitrations. So yeah, just to answer his question.
Very good. We have another question here from a student looking to specialize in arbitration, international arbitration, especially in the MENA energy sector. So competencies that you should be trying to build, you're going to understand the frameworks of the DIAC, the SCCA and the ICC. You're going to have knowledge of energy law, familiarity with the civil law systems, and you want to have cultural awareness, preferably be able to speak Arabic if you're going to be operating on legal matters here in the region. Yeah, the next one.
There was one just above.
Yes.
Yes, a lady or gentleman, excuse me, asked about arbitration clauses, enforcement in license agreements. I would advise you to look at the federal clause number 6. That details that in full. But yes, the answer is yes, they are.
Very good. We have another question here. Why is arbitration becoming more popular in the Middle East? So it is becoming more popular because governments are reforming their legal systems, trying to attract foreign investment and improve their dispute resolution mechanisms. So in the UAE and Saudi Arabia, for example, there are new laws and institutions like the DIAC and the SCCA and support of court rulings, making the arbitration faster and more reliable and internationally recognized. There's another one here. Can both public and private entities use the same arbitration rules and institutions in the UAE and Saudi? So yes, of course they can. Both public and private in Dubai can go to arbitration under the rules DIAC and ADCCSE, and in Saudi the SCCA can be used by both public and private, but in public usage, there are some requirements. There might be cabinet permissions or some modifications may be required just to accommodate the specific case at hand, depending on various factors.
And there is another one. Yeah. So the 2021 decision.
Okay.
So basically, it just reinforces the principle of arbitrator independence. Absolutely significant. And it just shows that, Dubai courts won't easily overthrow a decision on minor technicalities. And it just boosts confidence in arbitration. So yeah. And making it competitive with New York, London, Sweden, as I've really said already. So it's great for the region.
I think that concludes all the questions. Thank you very much for attending this webinar. And if you have any questions, please feel free to contact us either through the forum or just contact us at info@blackpolegroup.com. Thank you very much, everybody.
Thanks.
Yes, thank you. Thank you, Pascal and Laura, for narrating. I have to apologize for the technical glitch, what happened, but ultimately it came out with an excellent output. And thanks for answering all the aspects, particularly the questions on the court of cessation, the institutional arbitrations, and to what extent the private entities and the public entities getting involved in arbitration in UAE. This market, what practitioners, particularly from Global South, are significantly started using, and institution entity like yours would be a real asset and getting into the promotions of arbitration, particularly for the clients who wanted a solution which is obviously recognized across the jurisdiction. That's very important. And being part of this ecosystem, which is UAE and Saudi Arabia. The presentation was very significant when there was mentioning about SCCA, Saudi Center for Commercial Arbitration. I have to thank both of you to share this very significant institution in the Kingdom of Saudi Arabia, which is one of such institutions which started the meta to be used for resolving the dispute so effectively. Thank you. Thank you for the wonderful presentation. And in a traditional way of thanking from our jurisdiction, Nandri, Mikka Nandri.
Thank you very much.
Thank you.
Okay, bye.
Bye.
Moving on to the next session, we have Ms. Madeline Kimi from Tanzania. We are honored to welcome Ms. Madeline Kimi, a leading dispute resolution and arbitration practitioner based in Dar es Salaam, with over 15 years of experience in high-value commercial disputes. She's the founder of iResolve and currently serves her second term as president of the Tanzania Institute of Arbitrators. In 2025, she joined 3 Vernalam Buildings, UK, as an associate member and has been appointed to prestigious panels including ICSID, SIAC, LCIA, SHAAC, and ICANNS, our IRP panel. Expertise spans sectors such as construction, mining, telecom, and finance, and she's widely recognized for her contribution to ADR policy, training, and innovation. We are privileged to welcome Ms. Madeline Kimi to share her insights on the ADR landscape in Tanzania and to enrich today's proceeding with a global perspective and leadership. Over to you, madam.
Thank you so much, Kovise, and thank you to the Global South ADR Day. The entire team, this has been quite a wonderful day, and thank you for sharing all these insightful experiences from the different jurisdictions within the Global South and beyond. My name is Madeline, and thank you for introducing me once again. For this presentation, I will project my slide. I hope with the nod, you can see the presentation in front of you. Thank you. Now, I've been asked to speak about arbitration in Tanzania, and it's really at a pivotal time in Tanzania and for Tanzanian arbitration, for the arbitration landscape in Tanzania. Just as an outline, I will touch on with an overview of the legal framework on arbitration in Tanzania, and I'll swiftly move to speak about the different ADR institutions that have been accredited and currently having a major impact on the arbitration landscape. I will then also touch on a few prominent cases that have raised eyebrows within the arbitration community in Tanzania, and of course, within the neighboring region. And then, of course, item number 4 on my outline will touch on the future or predictions, I would say, on legal reforms within Tanzania. And then I will conclude on my presentation. Okay. On this next slide, I have attempted to give you a roadmap. And so within that roadmap, you would note that we had a prior enactment that was on arbitration. It was based on a very archaic law from the English Arbitration Act of about 1882, if I recall correctly. Now that 1887 it was, apologies, the Arbitration Act Ordinance of 1887. The first Arbitration Act in Tanzania was enacted in 1932 under Chapter 15 of the laws of the United Republic of Tanzania. That particular legislation had only 32 parts to it, 32 sections that were to guide in brief the arbitration process in the country. With those 32 sections, in 1957, we saw introduction to arbitration rules. And these rules were passed through Government Notice 427 in 1957, which somehow outlined further certain procedural rules on arbitration that supplemented the main legislative piece, which was enacted in 1932. That piece of legislation remained unchanged up until a few amendments were made in 1971. And prior to 1971, I think it's very notable to note that a few changes occurred on the Civil Procedure Code. Now, the Civil Procedure Code, through its Section 64, introduced the multi-door concept, the doors of the court being able to open up to other mechanisms that were being offered out of the court or within the court. And one of those mechanisms were arbitration and mediation. And this was not new during that time, due to the influence that we had from other common law jurisdictions, such as the United States. Now, moving on and jumping out of the CPC, which is the Civil Procedure Code, and it's pretty much modeled and mirrors that of the Indian CPC, save for a few tweaks here and there. I move on now to the amendments that were done in 1994, which really now cemented the concept of a multi-door courthouse within our judiciary. And this was the entire judiciary having to have a mandatory court-annexed mediation program under that GN, which is the Government Notice 422. Along with this amendment in 1994, interestingly, there was a schedule stuck at the very back of the CPC that spoke on arbitration and provided for a much more lucid sort of approach on assisting parties in arbitral matters on that era. And in 2000, our constitution, although it had already embedded a mandatory provision on our judiciary to ensure that they promote the use of dispute resolution, was enhanced through Article 107, subsection 2, D and E of the United Republic of Tanzania Constitution. And so our foundation to ADR is found within the constitution of the country. Now, throughout that period, and this is a very interesting time for arbitration in the country, because during that time, from the 1932 enactment of the mother law of arbitration in the country up to the end of 2019, there had been no changes to the Arbitration Act at all, no major changes at all. It remained with its 32 parts and the rules that were supplemental rules. And so much of the work was done by the courts. The courts of law were pro-arbitration and very proactive in applying the foundational principles of arbitration throughout this journey that we've had to go through with a very archaic, very rigid Arbitration Act. And so during that time as well, I think it's something interesting to note that there was efforts by the Law Reform Commission since 2012 under a BEST program, and this is doing business program that was funded by, I think it was World Bank, if I'm not mistaken, to conduct a study on the usage of this mechanism in the country. And through that program, there was a report, there was a need for a new bill. And through the Tanganyika Law Society, we did see a draft arbitration bill that was modeled along the lines of the UNICITRAL model law on international arbitration. But we didn't see this coming up. It was lying somewhere on someone's desk for quite a while, up until 2017, late 2017, when we started seeing that the legislature was now interested in putting up a draft that was going to be called Arbitration and Conciliation Act, and called for stakeholder comments. However, in 2017, nothing happened. Then in 2019, we had a second round of Bango Kitita, which is the stakeholder comments. We call it Bango Kitita. Now, that Bango Kitita resulted to the 2020 Arbitration Act. And you can see through that roadmap that we had another amendment after the enactment of the first version of the 2020 Act, an updated version in April 2021, which is now the one that is currently in play in the country. Now, throughout this legislative reform, seeing this new enactment, which has provided the country with a much more coherent arbitration framework, we also saw some changes around international arbitration or investor-state arbitration policies within the country. We saw the enactment of the Natural Wealth and Resources Contracts, which was the Review and Renegotiation of Unconscionable Terms Act 2017, telling us whenever there is a dispute, let's look into what means is best to resolve that dispute that involves natural wealth and resources. Should we keep it in country, or should we have it resolved in foreign tribunals? And so the first enactment in 2017 restricted access to foreign tribunals when it was dealing with disputes arising from natural wealth and resources. However, there was a little bit of a backstepping in 2020, where we saw that particular legislative piece revisit that provision and reintroduce the fact that arbitral tribunals or tribunals that are foreign tribunals can still be approached in terms of administration of those matters. And so therefore we've done a 360 there, and we are at a good standing. In the Public-Private Partnership Act, we also saw a similar provision in 2018, and that was also amended in 2023, recirculating back and recognizing that there are these tribunals such as the ICSID and tribunals recognized under different PITs and MITs that the country has signed up to. Now, the confusion comes back then in the most recent changes to the Tanzania Investment Act. Now, the Tanzania Investment Act in 2022 was amended and refurbished in a way that it included the provisions of resolving the dispute and referring a matter to the ICSID. However, we've seen the new act that deals and regulates investments, FTIs and the rest investment coming into the country, and special economic zones, now it's called TISEZA, sort of go away from that particular framework and has introduced other tiered processes such as negotiation, and failing such negotiation, arbitration, yes, but arbitration in accordance to the agreement that the parties, the state, have between each other, and not specifically mentioning the ICSID or any other recognized foreign tribunal that would handle such cases. And so we've seen a shift away in that 2025 legislation. If I move on to the next slide, and I'll speak much more on the Arbitration Act and the great innovations that parties are afforded under this particular act. This act was really done in a way that it somehow mirrors, to a certain extent, the UK Arbitration Act of 1996. And so we did not go the the purely sort of pure approach to the unicitral model law. We borrowed leaf from the innovations of the UK Arbitration Act, introducing provisions such as the serious irregularities, challenges on serious irregularities that is in the section 68 of the UK Arbitration Act, introducing the stay of proceedings under section 15, which provides for a mandatory stay unless the court is satisfied that the arbitration agreement is null and void or inoperative or incapable of being performed. And so we've seen these provisions work very well, despite the fact that we do have an infancy within this procedure or in conducting this procedure in the country. And when I say we're at the infancy stage, it's because this act has been well explored in the UK. It's been around since 1996, so they've had the test of time with it. But for Tanzanians, this is a new creature altogether, introducing new concepts, such as the competes rule, where it gives mandate to the tribunal to provide a ruling on its own jurisdiction. And this has been codified under section 34 of the Act. Another new innovation for us, it's an innovation, is the costs follow the event under section 63, 64 of the Act, which is part 8 of the legislation. This now has given us a codified costs shall follow the event principle, where now parties are able to rely on if the rules maybe do not provide, the arbitral rules that they are working with do not provide such avenue. And so we've seen great innovations and of course, yes, alignment to the UK Arbitration Act, but also certain other provisions which go away from the UK Arbitration Act and provides for much more local perspective, such as the introduction of the Tanzania Arbitration Center under section 82 of the Act. Also, Tanzania takes a different approach by adapting the New York Convention, not in a separate legislation, but within the enactment itself under section 78. Usually you would find such provisions that adapt the New York Convention in a separate legislative piece. Usually you would also find establishment of centers, national centers, in separate national legislations. However, this is embedded into one big statute that has about 101 sections to it. Most importantly, of course, the Arbitration Act in play covers both domestic and international arbitration. It provides for arbitration agreements that which have not been signed because of that broad definition that is provided for within the legislation. I'll move back to the principles under section 5, which are very important to sort of shed light on, because these go at par with international standards, at par as to what we've seen in the other presentations that have come before me. Section 5 of the Act provides for the general principles, and the general principles echo throughout the corners of many jurisdictions, and one, to have fair resolution of disputes by an impartial tribunal and avoidance at all times if unnecessary delay or unnecessary expenses to the parties. The other principle, which is the freedom of choice, which is the party autonomy principle that we all are sort of embracing to ensure that parties have that option, have that freedom to choose the procedure, to choose the appointment of the arbitrator that they wish to engage in their matter. The minimal court intervention also, we will see when I'm speaking on the cases. I did jump a slide, and I didn't jump it by mistake. I wanted to go back and forth in saying that the Arbitration Act covers also international arbitration. And Tanzania is not an island. We have been a member or have ratified the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards since 1964. And in 1992, we signed the ITID Convention. It was then reflected within the national law of the Tanzania Investment Act, as I spoke of earlier, which has now been removed due to the recent enactment of the Tanzania Investment Special Economic Zones Act 2025. Now, we'll speak more on that in a later slide. We are a regionally based country in the East African community. And so there are other provisions such as the East African Court of Justice, which offers arbitration rules 2012. And so there's an avenue there to access arbitration. The South African Development Community as well, the SADC region, having that Tanzania has been a member since December 2020. And within the SADC region, there is an arbitral institution under the AFSA SADC division, which was launched with the SADC panel of international commercial arbitrators. We also have a new continental-wide free trade agreement, which is the AFCFTA, and we'll see its impact in my later slide. Tanzania has also signed about 20 BITs, 9 remain to be in force, and 11 are not in force. In late 2019 or 2018, we did see Tanzania serve its notice of intention to terminate the Netherlands BIT. There was also word of a termination of the Canadian BIT, and so on and so forth. So there is this a pullback of this particular model of BITs, as we've seen conversations happen in different doors with regards to these BITs, and a shift towards the MIAs as opposed to BITs. Now, in terms of implementation of the Act, it's really growing because of the support and the level of support we see from the government stakeholders. And there's a clear policy direction now, despite the fact that there is no ADR policy in play. Now, the Act itself applied retrospectively. And so under Section 96, it had retrospective effects, and that did affect the arbitrations that were pending at that time when it came into effect in January 2021. The enactment is not supported by any court procedural rules. This is still not yet in place, although there is room under Section 95, subsection 3, for the Chief Justice to put up rules that will complement the execution of this particular piece of legislation. However, this is still on the pipeline, and because it's still on the pipeline, there are a lot of challenges faced by practitioners on the ground in channeling their arbitration-related matters in the courts of law. There are no practice notes or guides at the current moment. However, we are guided heavily by the precedents that comes from the English court, because our Act is a mirroring effect, as I said earlier. In terms of arbitral institutions, I will speak on this at much more length in another slide. However, we do have arbitral institutions, and they are recognized under the legislative piece and given certain immunities to the extent that they can act in good faith. The arbitration practice itself requires for one to be accredited. And why accreditation? Accreditation, of course, is mandatory in Tanzania for both local and foreign neutrals. Accreditation, of course, is advantageous if we speak to the fact that we will have a set benchmark on the standards required within the practice. We'll have a set benchmark on the aspirations that we want to achieve in terms of public confidence in arbitration. And then, of course, there's that need for consistency of the movement towards now introducing that reliability by the public of this particular service stream. Now, as professionals, we are charged, it will be a penal offense if we act as arbitrators, mediators, or adjudicators without being properly recognized and having an accreditation certificate in place for you to be able to practice. And so that's the slide that is in front of you. Along with that regulation that requires accreditation, there's also another regulation that requires one who practices to follow certain codes of conduct and practice. And that code of conduct and practice outlines rules such as the disclosure of conflict of interests, confidentiality, the need to ensure quality of process, maintaining impartiality, and of course, availability and dedication and having competence to perform the tasks that have been trusted to you by the parties. Arbitral institutions in the country keep growing. The number keep growing. Just more recently, about 2 weeks ago, there has been a new entrance to this list, which are not included in my slide yet. The Tanzania Institute of Arbitrators has been around since 1999. That's an institution where I'm currently the president. The Tanzania International Arbitration Center was established by the Tanganyika Law Society. It is based in Dar es Salaam. It is a company limited by guarantee. We have the National Construction Council. I think it's the oldest standing. It's a statutory institution and caters to the construction industry. And before, of course, the establishment of the Tanzania Institute of Arbitrators, we did see most commercial matters also go to the National Construction Council. And so the people there, the members there, saw the need now to have a separate body to administer commercial matters so that the National Construction Council can focus in on the construction matters that it was administering then. The Tanzania Arbitration Center, as I spoke of, is a creature of the statute, the Arbitration Act, Cap 15, revised edition 2020, under Section 82. And its headquarters are meant to be in Arusha, but what I believe is that they will they will change that soon through the reforms that I will speak to be in Dar es Salaam. And this is a multidisciplinary
There was some issue with Madeline's connection. She's rejoining. Yeah. Madeline, you have to unmute your audio.
Thank you. Apologies for that. My internet might have gone a little bit lower in data. Apologies. So the Tanzania Institute of Arbitrators, as we've already come to know through this presentation, was launched by the previous Honorable Chief Justice of Tanzania in 1999. And at this point in time, when I'm speaking to you, the membership keeps upwards, keeps going upwards, with 343 members in 3 different categories, having fellows, members, and associates. We have some international members coming in from Kenya, Tanzania, Uganda. By gender, we have about 239 male and 104 female members. And so it is a growing institution. It has a set of rules for arbitration and a set of rules for mediation, both modeled along the lines of the UNICITRAL model rules. on arbitration and/or mediation. At the current state for this year, it's holding a total value of disputes amounting up to 10 billion United States dollars. And so it is a very much growing exponential institution in the country that needs to be well recognized for its efforts in ensuring that there's consistency, there's a legitimacy in the process within the domestic landscape for arbitration, because most of these disputes are domestic arbitrations as opposed to international arbitration under the Tanzania Institute of Arbitrators. Now, moving on to our courts and how our courts have continued to embrace arbitration. Our courts have continued to embrace arbitration in many aspects. I've just put down a couple of aspects on my slide where you've seen the courts echo the courts in many other jurisdictions, that it is not an appellate court. Matters that have been put forward in a arbitral tribunal have been fully adjudicated. And when you go off to court to challenge an award in any sort of manner, the courts are not to revisit that as if it's appreciating the evidence before, which have been already adjudicated by an arbitral tribunal. So we see that in the Marine Services case. We see that also in the CATIC International Engineering case versus the University of Dar es Salaam, a 2020 decision where an award that infringes public procurement law or policy, that illegality may be sufficiently relied upon to set up aside an award. This is in conformity with most of the jurisdictions that have adopted the New York Convention on the Enforcement of Arbitral Foreign Awards. The public policy provision also was touched on in the Vodacom and Planetel case, where you see that the court held the award to have been procured in a manner that is contrary to public policy. The same is uncertain and unambiguous, they say. And then it proceeded on to say these are serious irregularities affecting the award, and remitted it back to the tribunal for reconsideration pursuant to Section 75 of the Act. In CATIC, further also, in the same case that I have already sort of put up in my first bullet point, I think that was just a repetition, that was also on the public policy provision and the application thereof by the Tanzanian courts, and how it can eat into the final award and set it aside or remittance back to an arbitral tribunal for reconsideration. On the issue of serious irregularities, a lot of cases are taking this route in the court for purposes of challenging an award, and we've seen an avalanche of these cases. The court keeps, of course, the same principles that one does not revisit these awards and serious irregularities, holds a high threshold for you to prove that award is tarnished, and it has these aspects spanning from it, and so it should be set aside. One such example may be a 2023 decision is the CSI electrical case, where the unilateral communication of the award by the institution that was administering that arbitration was seen to be a serious irregularity. And so what happened there was that the institution was seen to have communicated the award to one party without having done so to the other, communicated to the other that award has already been filed with the institution for purposes of now delivering it to the parties. And so that unilateral communication was seen as a serious irregularity. Another very recent case for, I think, is the Tarura and Canopies case. As you can see there, this gave a clear path to practitioners on the dilemma that we had on post-award enforcement procedures. The post-award enforcement procedures to date have not been put up very well in our legislation, and so we're going back and forth between the Act and a set of regulations that were really meant to be rules that can be adapted for the procedure, ad hoc procedures on arbitration where parties have not agreed to a set of rules. These regulations were to be opted on by parties. But then within those regulations, we saw that they had provisions for filing and recognizing an award. And so participants or practitioners would run off to court using those regulations. And so the Tarura and Canopies case really closes the gap, the procedural gap, as you can see there on my slide, as to the filing, recognition, and enforcement of a foreign arbitral award. Now, in terms of ITSID awards, we still don't have a clear roadmap in our legislation that puts together a self-contained framework for ITSID awards. And the Arbitration Act, that the current one, which is in force, has no specific provisions for the enforcement of ITSID arbitral awards to date. And so this route may be within the reform basket of the Law Reform Commission, but not very solid at this point in time that we will have such provision. Now, moving on to and I hope I still have time, to the future, and I'll touch on this very quickly. The future, what we see in Tanzania and the landscape for ADR is that we will have some sort of a refinement of this regime in Tanzania, where we will have an introduction to an ADR policy that directs us as to where the country wants to go in strengthening the environment for ADR in the country. We will hopefully see court procedural rules that enables parties to take arbitration applications, matters within the court, and those rules to set clear timelines, because at this moment in time, those timelines are faded. And so that in itself creates a lot of havoc for this particular framework to work well, because it is a lucid, coherent enactment, but it won't work well without these other foundations around it, holding it up. Reforming the new act, we've had it since 2021. It came into force in January, early January. Yes, we're revisiting certain provisions that we've seen that are a little bit challenging to implement, such as the Tanzania Arbitration Center, which has not yet become operationalized. Its provisions appear on several parts of the Act. I think it appears 31 times on the Act. It acts as a third-party appointer. But because it's not operationalized, that means within these 4 years, we've had a lot of challenges removing an arbitrator, reappointing or replacing an arbitrator, because it's that power within the Act is vested with the TAC. And the TAC is not operationalized yet for 4 years. And so you find persons really looking for this center to be maybe provided with wider definition to include other arbitral institutions in the country, to include other institutions such as the Tanzania International Arbitration Center, such as the Tanzania Institute for Arbitrators, to also have mandate and the whip to replace, the whip to appoint, and the other 31 times mandates provided to the center, being supported by the other accredited institutions in the country. We've also heard of reforms that are being discussed at the UNICITRAL on electronic awards. And so this is the work that is ongoing within the UNICITRAL working committees. And so therefore we do envision that these enactments or these reforms may consider further appreciating electronic awards and having a focus on increasing the accessibility of technology, because already the Act does provide for electronic signatures. It does provide for other use of technologies. And so therefore we're seeing that it might go the direction of even recognizing electronic awards. And so that is a space of digital innovation within arbitration that we look forward to. Another future prediction for Tanzania is the enactment of mediation regulations. We've seen the Indian legislature put up a wonderful piece on mediation, and that really has inspired us in order to ensure that mediation picks up pace. At this moment in time, as I'm speaking, since the introduction of the Tanzania Institute of Arbitrators mediation rules in 2022, we've only seen and administered 2 matters on mediation. I think that number is extremely low, and it's extremely an important, a critical matter at this point in time in my presidency as well, that we put a little bit more energy towards ensuring that we have a conducive legislative or regulation that gives mediation a pickup for Tanzania, and of course for the region at large, and for the global initiative under the Singapore Convention to also be recognized within the Tanzanian jurisdiction. In the country, we use adjudication, construction adjudication, and it is very, very, very common in construction disputes. However, we don't have a statutory framework for it. And so therefore, we are also hearing within closed doors that there could be a mechanism put up to regulate this construction adjudication practice that has been around for quite a long while. Now, in terms of mediation reforms, I think I've already given you a little bit of my idea there, that we are going to see improved institutionalization of mediation through these enactments that we foresee. On the African continent, we cannot go away without speaking about the African Free Continental Trade Agreement, because here is where we will see again an avalanche of disputes arising in connection with that intertrade activity. And as the activity will be quite exponential and colossal, we will be seeing an uptake or at least an increase in disputes, commercial disputes to say, and the caseloads within institutions in our countries will pick up. And so that is a space to look out for. One, because the AFCFTA does not provide for a dispute settlement mechanism for the participants within that, within the trade area. It only provides for the states, when the states are disputing, to have a dispute settlement mechanism under Article 20 of the AFCFTA. And so it's limited to that, to those kinds of disputes. And so opens up arbitral institutions to handle those other commercial disputes between the players that would be within that trade area. More on future predictions on my slide. I think we've touched on accreditation. Accreditation won't go anywhere, but we look to ensure that it's streamlined, standards are set, borrowing leave from jurisdictions that have put up such a framework of accreditation. We have seen an increase in third-party funding. We have an award against Tanzania under the IDSID, the Nachingwea Award. Was also the claimant there was third-party funded, and so therefore that increase in interest by Tanzanians might see that the legislative piece, when it does go through its reforms, introduces some sort of a policy direction in terms of third-party funding recognition in the country. We are a common law country, and so the rules of charpentry do apply. And so we will see how we will take this particular TPF provision forward. Will we borrow leave from the English, from the Singaporeans, from India? I'm really not sure at this stage, because the comments have just been tabled before the Law Reform Commission. award review mechanisms. This is, I think, was also presented by our Nigerian colleagues under their new legislation. We've seen an award review mechanism being introduced in several other jurisdictions as well, offering that appellate level of that particular award within either the institution administering it or otherwise. And so therefore, these are things that we are anticipating in the near future. I'm very thankful once again to the Global South ADR Initiative 2025 by Kovise and the many other colleagues that have supported this event. I have done and conducted a survey this year, ADR usage by Tanzanian businesses survey. And this survey was very interesting. And I think the interesting part is that it wasn't surprising. Because 26.67 have none at all encountered ADR out of the persons that have responded. There were 60 respondents. 21.67 said that they had little knowledge of these mechanisms. And so the data speaks volumes on the level of know-how or the level of awareness, the sensitization that has been done at to what level at this stage in time in 2025 for one African country. But I think it speaks to the rest as well, because the knowledge still needs to be amplified. More knowledge to Tanzanians, more knowledge to the East African community at large. So in my conclusion, I would say then the capacity building strategies are at the top rank of my agenda. That is to play a greater role in practice-oriented think tanks and innovative efforts. To provide virtual learning modules such as this Global South ADR initiative, which I fully support because this cuts costs. And so we wouldn't hear about the issue of costs in getting this knowledge. It really does give anyone reach to this information that is crucial in building up a culture of alternative dispute resolution enthusiasts. And so with that note, I thank you once again, and I am very much open to discussing further my presentation. I hope I was on time, but I really do think I was beyond time. Thank you.
Thank you, Madeline. It was a wholesome narration about the scenario in Tanzania. As expected, you have just performed to the maximum what I can imagine. And Tanzania is going to be a very interesting ecosystem when it comes to arbitration and future mediation. Due to paucity of time, I couldn't further stretch this. There's already the next speaker, Ms. Alex Murley from Mauritius, is available. Thank you, Madeline, for sparing your valuable time, sharing the thoughts about arbitration in Tanzania. Thank you.
Thank you very much, Inbav. Thank you.
So for the next speaker, we are pleased to welcome Mr. Alexis Merle, a practicing barrister in law and the founder of Merle Practice in Mauritius, specializing in civil and criminal law. He holds advanced legal qualification from esteemed institutions in France, Ireland, and the United Kingdom, and is called to the bar in both England and Wales and Mauritius. Mr. Merle currently serves as the registrar of the Mediation and Arbitration Centre Mauritius Limited, where he plays a pivotal role in administering ADR proceedings and promoting best practices. His active involvement in international arbitration bodies and his leadership in regional ADR development make him a valuable voice in the field. We invite Mr. Alexis Merle to share his insights on ADR in Mauritius and to contribute to today's dialogue. Over to you, sir.
Thank you very much for the kind invitation, and good morning or good afternoon to everyone watching us today, depending on wherever you are in the world. It's a pleasure for me to be able to discuss about how ADR, arbitration and mediation has evolved and is currently doing in Mauritius. So I think maybe if I can start with giving you a brief history about the country itself, so you can have an idea of how we came up with the laws that we do have here in Mauritius, because Mauritius was actually first really colonized by the French, and then by the British. So in Mauritius, we have a very interesting hybrid system of law, where most of our substantive laws will be based on French law, so the Code de Napoléon, and a lot of our laws which deals with company law, for example, and administrative law will be based on English common law. So this is a very interesting part of our legal system, because this is where our ADR will play a role, and where our ADR actually came to light. So unlike in Tanzania, like Madeline just said, that where they have an arbitration act which cater for both domestic and international, in Mauritius we currently have an arbitration act which cater for only the domestic arbitrations, and the International Arbitration Act, which will cater for international arbitrations. So our domestic arbitration rules will be based on our civil procedural code, which is based on the Code de Napoléon. So maybe one thing that we could be looking at our day is it still relevant? One may ask, is it still relevant to have two different kinds of legal framework for arbitrations in Mauritius? But our domestic arbitration is mainly based, therefore, on French civil law. And then the government enacted in 2008 the International Arbitration Act. And the International Arbitration Act, which is based on the UNCITRAL model law. So we have these two different legal framework that we use in Mauritius, which is kind of a bit of inheritance from our history. One thing maybe it would be good to know as well is that even if you have a domestic dispute under the International Arbitration Act, you are able as parties, if you have obviously a consent of both parties, to have the International Arbitration Act to be applied to your domestic arbitration. So you still have the option to opt in and have the International Arbitration Act applying to your dispute. So in Mauritius, in terms of institutions, I am currently the registrar of the Mediation and Arbitration Center of Mauritius, which is also called the MARC. So the story about the MARC, it essentially came up with the Mauritius Chamber of Commerce and Industry. And the Mauritius Chamber of Commerce and Industry dates back to 1850. And the first registered arbitration case in Mauritius under the Mauritius Chamber of Commerce and Industry dates back to 1855. So we have a very long-standing management and administration of arbitral disputes for almost 2 centuries now. And since 1850, the center evolved. It used to be under the aegis of the Mauritius Chamber of Commerce and Industry. And then it was rebranded in 2014 as the MARC. And it really revamped its organizational structure in 2017. In 2017, the institution created a MARC court and a MARC advisory board. The role of the MARC court is to deal with prima facie decisions, such as, for example, if the parties cannot agree on the number of arbitrators, it will be for the MARC court to decide. If the parties cannot agree on the arbitrator or the arbitral tribunal, then it's going to be the MARC court who will have to decide. The MARC court is currently composed of 17 eminent experts, and which is currently presided by Neil Kaplan, which is King's Counsel. Apologies for that. Can you hear me, Imba?
So you're audible.
Sorry, there was an issue. So we do have the MARC court. We have representatives from all over the world. We have members such as Lord Neuberger, Achille Ngwanza, Arthur Ma, Yves Fautier, David Rifkin on the board. And we also have the MARC Advisory Board. The MARC Advisory Board is also composed of 17 experts, but their role is to promote and assist the MARC Secretariat to better promote the use of ADR. So since 2017, the aim and the intention was really to give an international perspective to ADR. And this was actually the intention of the government since 2008, when the International Arbitration Act was enacted. One maybe particularity of our International Arbitration Act is the cooperation or collaboration that Mauritius does have with the Permanent Court of Arbitration, which is based in The Hague. If you look at our International Arbitration Act, the appointing body is the PCA, the Permanent Court of Arbitration. The PCA also had their first sub-office in Mauritius, and they've recently celebrated the 25th anniversary of their sub-office here in Mauritius. So basically in Mauritius, we have 3 arbitral institutions, the MARC, which I just presented. There is also the MIAC, which is the Mauritius International Arbitration Center, which was formerly known as the LCIA MIAC, but became a fully independent center in 2018. And it is currently located and share the same offices as the PCA sub-office here in Mauritius. Maybe now if I can turn and keep on giving some insights about our legal framework. I've mentioned the International Arbitration Act, which is based on the model law. We are also a signatory, obviously, of the New York Convention. And we have the no reciprocity reservation, so awards from any foreign states are enforceable here in Mauritius. We do have, since 2013, established the Supreme Court rules on international arbitration. And one of its specificity, which was a very commendable effort, was to have a panel of specialized judges of the Supreme Court who would have obviously received extensive training in arbitration matters, and they have now been earmarked as the panel of experts, the designated judges, who will be the one appointed when dealing with any matters concerning international arbitrations, either it is for setting aside or enforcement of arbitral awards. So we do have this process here and specificity here in Mauritius. The aim of it was to be able to deal with arbitration matters and disputes in a more efficient way before our courts. So this was the intention of the legislature back in 2013. As I mentioned, we also have the Code de Procédure Civile for domestic awards, but I think, in my personal opinion, it is maybe time to reconsider and have both acts a unified maybe legal framework, because we've seen recently in domestic cases, that the current legal framework concerning our Domestic Arbitration Act is currently lacking. There are some issues regarding the Act. Maybe if I can give one example, there was a recent case, the case of lateral holdings against against China Jiangsu, which concerned a domestic arbitration, which was conducted ad hoc. And it took more than 7 years for the arbitration to not even be over with, because as per our Code de procédure civile in Mauritius, every 6 months, the mandate of the arbitrator has to be renewed. And after 7 years, one of the party did not renew the mandate of the arbitrator, and the arbitrator did not give his arbitral award. So after 7 years, both parties were back to square one. So I think, in my personal opinion, in order to avoid these types of issue, maybe if we have a unified arbitration act, this would be able to solve such matters and give more incentives to the business users and economic operators here in Mauritius to use arbitration, give them more confidence into the system. Maybe one point I will try to stay on time. I promise him that I will. I would like to touch about is that we've been discussing a lot about arbitration, but I think mediation should be something that is as important as arbitration. And this is maybe one of the challenges that we do have here in Mauritius. As at date, we still do not have a mediation legal framework. Although Mauritius had signed the Singapore Convention, but it is yet to ratify it. Mediation is getting more and more popularity, and I think it is about time that the country thinks about having and incorporating mediation legal framework. On a very positive note, a few months ago, the newly elected government made a speech and talked about the intention to bring back Mauritius on the international stage for resolving alternative dispute resolutions. So this is a matter that the current government is definitely looking into. As recent developments regarding our legislative frameworks and ADR, the current Attorney General has mentioned that he intend as a reform to have a new Supreme Court Court of Appeal system here in Mauritius, which will deal with arbitral disputes and matters. Once again, the aim is to give more confidence and to be more efficient regarding the administration of appeals to, not appeals, but for application for setting aside or enforcing arbitral awards here in Mauritius. So there is definitely a will to amend things, and I think to be inspired on what is currently being done in the UK, what has been done, for example, in other countries such as Germany or Singapore, and even Bahrain, which recently have partnered with the Singapore International Commercial Court. So I think the current government is really looking into the matter to amend the current situation and to make things more efficient. Imba, maybe if I may as well, I don't know if I still have a lot of time. I would like to discuss about maybe a landmark case, a very recent case, the case of Laporte and Laporte, which judgment was recently delivered by the Supreme Court of Mauritius in February 2025. The interesting part, and why I want to mention this case, is because the case deals with the issue of security for costs. So the main point in dispute was the need to provide suitable security under Article 6 of the New York Convention when enforcement proceedings are stayed. So it was about security for costs in relation to an appeal to the Judicial Committee of the Privy Council under the Supreme Court rules. So just to give an explanation how the Judicial Committee of Privy Council is in the picture, is because in Mauritius, our last Court of Appeal remains the Judicial Committee of the Privy Council. So decisions from the Supreme Court and the Court of Appeal of the Supreme Court can be appealed to the Judicial Committee of the Privy Council, which was the case in the Laporte case. So in fact, in this case, the dispute arose from an arbitral award, which was actually administered by the MARC. This arbitral award was rendered in favor of Mr. Eric Laporte, and the proceedings were seated here at the MARC in Mauritius. The respondent was his brother, so Mr. Marc Laporte, sought to set aside the award and resisted its enforcement. But after his application to set aside the award was dismissed, he appealed to the Judicial Committee of the Privy Council. So the Supreme Court put the enforcement proceedings in abeyance, pending the appeal, and actually ordered Mr. Laporte to provide security by way of a bank guarantee for the full sum of the award under Article 6 of the New York Convention, and to pay security for costs to be incurred in the appeal to the Judicial Committee of the Privy Council. So the interesting part about this judgment is once again the pro-arbitration stance of the judges here in Mauritius by enforcing and applying Article 6 of the New York Convention when a party has applied for security for costs. And the interesting part is that it was for the full sum of the award and even for the cost to be incurred in the appeal to the Judicial Committee of the Privy Council. So it was the first time that our Supreme Court judges had to make a judgment about such a specific issue regarding the security for costs. So this was the case I wanted to bring on. Now, regarding maybe the current challenges and not issues, but yeah, let's say challenges to ADR here in Mauritius. I think we can separate it in two phases, and I think this challenge may be similar to in every other country actually. It's the need for, we need to have awareness. I think the main thing about ADR and users of ADR is creating the awareness on how useful and appropriate these measures are. So in Mauritius, the culture of people litigating have always been to go to court, but recently there's been a trend, and economic operators and other users are starting to realize the benefits of having recourse to mediation and arbitration. And it can clearly shows in the statistics, we're having more and more cases, either whether international or domestic as well. But there is a real need to recreate that awareness, but regarding mediation as well. So for arbitration, things are going well. Obviously, there are always things that can be done to better the system. But currently, I think there is a need for mediation. Madeleine also talked about mediation, having only received a few cases and administered a few mediation cases. The situation is similar here in Mauritius. Marc has administered a lot more arbitration disputes than mediation disputes. But I think the one way to be able to better promote the use of mediation would first to start with enacting a mediation legal framework. So maybe this is something that the newly elected government will be thinking about, and hopefully we will be able to see new changes and amendments made to better the mediation system here in Mauritius. So Inba, unless you have other questions that you would like me to answer or interact with, or if anyone has any questions about the jurisdictions in Mauritius, please feel free to reach out. I think I've kept to my word. I think I was given 15 minutes, and I think I should be within that timeline.
Thank you, Alex. It is a wonderful experience, what I had when I met you in Mauritius. That continuation I could see. It's a combination of the French and the British legacy in Mauritius, which led to the level of even Mauritius becoming one of the hub in the African continent, making it to be an effective gateway for not only when it comes to tourism. Mauritius also eventually facilitated multiple international arbitrations, particularly investment arbitrations. And that legacy is still continuing. And the task given to institution like yours, wherein you are the registrar, MARC, the Permanent Court of Arbitration of the Mauritius Chamber of Commerce Industry, and other institutions in and around Mauritius. We are grateful that your insight on the arbitration regime in Mauritius, which also has advantage of bilingual, very interesting thing for international arbitration stakeholders wanted to have, whether it is going to be the French facilitated arbitration or the English language facilitated arbitration. Mauritius is the destination and the seat predominantly what we need to have. Alex, as one interesting thing I wanted to know on behalf of the entire participants, to what extent this Mauritius courts, when it comes to enforcement of the foreign seated arbitral awards, any interesting phenomenons which you want to share here?
Yes. So regarding enforcement of foreign arbitral awards, as I've mentioned, we do have signed the New York Convention, and we have the law which transcribe foreign arbitral awards here in Mauritius. And also, as I mentioned, Mauritius does not look at reciprocity when enforcing foreign arbitral awards. One international award which was rendered, which maybe is the famous case of Betamax, that a lot of people might have heard of. That once again, this case showed that it talked about basically the public policy. That was the entire arguments which was argued before our courts. But the interesting fact about it is that Mauritius, regarding enforcement of foreign arbitral award, have always been a pro-arbitration stance. So as you have highlighted, where we are in Mauritius, we are at the crossroad of the African continent and the Asiatic continent. So I think from the legal framework that we have, the international financial center that we do have here in Mauritius, I think all the ingredients are united here to be able to be the most preferred seat in the region. You know, usually when parties, especially in international commercial disputes or contracts, if you have one party coming from, let's say, China and investing in South Africa, usually the party in South Africa will not want his disputes to be resolved in China, and the Chinese parties, vice versa. And I think this is what attracted and made Mauritius a real hub is that a lot of users have found out that Mauritius is actually equipped with all the legislative framework to be able to handle these type of dispute as an independent arbitral seat. So we have all the ingredients here, and I think maybe that's why we are where we are now on the arbitral scene. One very famous event, ICA, was even hosted here in Mauritius back in 2016, and obviously the bilingual aspect of it plays a very important role, because we are able to administer disputes both in French and in English. But also the fact that our hybrid system is based on French civil law and English common law. We are also well versed in our legal system here to adapt to different disputes coming from all over the world.
Thank you, Alex. Hope Mauritius is going to be a valuable resource for the Global South, and we hope the effective one should be there in the coming years. Thank you, Alex, for joining and sharing your valuable points.
Thank you very much, Imba, for your invitation. Much appreciated, and we will definitely be in touch with the Global South for sure.
Sure. Thank you.
Thank you.
Moving on with the next speaker, it is with profound respect and immense professional admiration that I rise to introduce a jurist par excellence and a stalwart of international arbitration, an architect behind one of the most pioneering initiatives in the field of alternative dispute resolution, the Global South ADR THIRUNAAL. We are honored to welcome Mr. V. Inbavijayan, a globally respected arbitrator with over 2 decades of exclusive experience in arbitration. As the managing partner of Global LLP and global advisor to KFCRI, he has presided over numerous domestic and international arbitration cases, earning acclaim for his expertise and impartiality. He is empaneled with leading arbitral institutions across Asia, the Middle East, Africa, and Americas, and his practice spans commercial, maritime, construction, and investment disputes. A fellow of the Chartered Institute of Arbitrators and fully approved CIAB tutor and course director, Mr. V. Inbavijayan has been instrumental in advancing arbitration education and institutional development worldwide. We warmly welcome Mr. Inbavijayan, our mentor, and looking forward for the insights that he will be sharing us with today. So over to you, sir.
Thank you. Thank you, Kovise Foundation, Conflict Resolution International, being part of multiple institutions, particularly my role as global advisor in KFCRI. First of all, I have to thank KFCRI for accepting this proposal to a wonderful initiative in the Global South jurisdiction, particularly the Global South ADR THIRUNAAL. Many of you would have heard this word as a first time. And I was one very fortunate person. Whenever a person comes and meet me, particularly in the Indian context, the name Inbavijayan is considered to be unique. Fortunately or unfortunately, I couldn't find any person, at least in this contemporary period, having the name Inbavijayan as a first name. I'm so happy to share that. And anyway, coming to the very significant theme of this THIRUNAAL or the day, there are 4 elements in it. The first element, what has been structured or it's a background or it's going to be the future, is all about effective and efficient 24/7 ADR services. That is quite interesting plans or schedules what Kovise Foundation Conflict Resolution International is planning. This is the first task. The second task is to call the entire Global South players, build an ADR institutions which secure the regional future. There are a good example of regional arbitration institutions, but Global South, which is consisting of around 139 countries, which predominantly are dealing with effective rule of law to be applicable in their jurisdiction. It is all the strengthening these regional centers, or if possible as a wholesome ADR institution for this particular region. Thirdly, Chennai, which is considered to be the traditional Madras, very significant the trading hub or a manufacturing hub, or it is a political hub for the British rule in the Indian subcontinent. The same pulse, why can't we can explore with alternative dispute resolution, particularly focusing the Global South jurisdiction. There was a good example of India, a success story when it comes to the business process outsourcing, including the legal process outsourcing, wherein the entities, whether it's private or public, focused in the cities in South India, which has evolved as a cities for the IT headquarters of the world, which eventually happened in the southern part of India, which is also part of the significant Global South. Why can't Chennai also become a pulse for ADR? Whether it is the virtual one or whether it is a physical one in the Global South. And the final destination leading to all the combination is the resolving without borders should be beginning with an alliance, which is nothing but a Global South ADR alliance. Arbitration institutions spread across the Global South. Legal practitioners, arbitration practitioners, law academicians, diversified professionals in this particular arena, focusing on the Global South, we can just formulate a GSADR alliance. All these four happen to be the backbone or the background or the future plans of this initiative GSADRT or the day. Focusing on all these points, just I will take another 5 minutes to narrate this, so that there are 11 more speakers coming from different jurisdiction of Global South, going to share very interesting arena of the developments in their respective jurisdiction. Dealing with effective and efficient 24/7 ADR services. No doubt, the world is fast moving. The disputes can arise at any point of time. The lawyers would be happy always to effectively manage these disputes. The resolution obviously should not be delayed. The very objective of ADR is quick, cost-effective, and hassle-free process in resolving the disputes. Even if you are stretching beyond this, why can't we can provide that services as a 24/7, which is possible? That can be the first task. Anyway, KFCRI being part of the Global South jurisdiction, the 24/7 alternative dispute resolution services has to be designed to deliver speedy, convenient, and fair outcome whether it is going to be physical mode or whether it is going to be the virtual or online platforms, wherein we have the multiple ODR institutions supported by the AI tools with the security or the cyber security, what was highlighted by many speakers. With that, a secured online platform, we can just try to make this happen 24/7. Earlier, when the speaker, Datu Mary Lim, the director of AIC, was speaking, even before this event, when this event was structured, she also was so receptive to accept this. And this might be the thought process of multiple institutions, multiple jurisdictions. We are trying to just consolidate all those, and we can just try to start with this 24/7, so that this event, which we happen to structure 24, or at least it is like 21 hours, not exactly 24 hours, 21 hours we are just structured so that that services can be provided, whether it is going to be in the late evenings. ADR is not going to be a part-time affair. It is going to be a full-time affair for the practitioners and the presiding officers like the arbitrators and the mediators. No public holidays. They will be available at any point of time with the fairness and the convenience of the parties. The justice can be delivered at the earliest possible time. 24/7 would be effective if it has been implemented in the way how it has to be. As ADR institutions, the strengthening regional ADR institutions. There are many regional institutions who have already partnered with us. Many national institutions, which also deals with a larger jurisdiction beyond their nations in those regions or the multilateral arrangements, has to be strengthened. And the key to ensuring fairness, once again, efficiency, once again, the dispute resolution, the fostering the local capacity, the Global South can enhance stability, reduce dependence on traditional systems, and drive the sustainable growth. All the ADR institutions should be strengthened. It's not that we are not equipped to that level, but the professional standards or the expectations which have been reasonably addressed by the global north jurisdictions and the traditional strongholds. Why can't the global south ADR institution can do it? The building or the capacity building to the expected requirements of the top institutions. Already the global south institutions are quite in the top 5, but still the global south institutions have to develop and build the whether it's going to be the infrastructure or the capacities or the skill, what is expected. That would be the second interesting task. Chennai, many of you, when you just look into the geographical location, it is well connected, and the history shows that the maritime trade across the Bay of Bengal, the Indian Ocean, starting from the Far East, stretching to the level of Africa and maximum to the Americas. Chennai happened to be a hub, and the European explorers explored in the way how the spice trade developed, and being such a interesting city or the region in the history, or particularly in the medieval history and the later part of it, Chennai is trying to be an hub. It's all a complement. There are already many regional hubs and specific hubs, all the region in the global south. Chennai also would join hands with them in the global south, offering the same efficient, accessible solutions for cross-border dispute. No doubt, similar to other hubs, the legal framework, the expert professionals would drive this initiative, making this region also to contribute reasonable in the ADR arena, particularly in Global South. The final one, on behalf of KFCRI and the partnering institutions, whether as knowledge partners or whether as a venue partner or the media partners, we all have to come out with an alliance. This is an open invitation so that as a follow-up of this Thirunal, reaching the second edition, preferably it might be a hybrid one, we have to create an alliance. That initiative is going to be floated by KFCRI, and this has to be the beginning of a new era in dispute resolution across the Global South. It is all uniting nations, the legal experts, as well as the institutions. This alliance obviously aims to remove barriers to justice and promote seamless cross-border alternative dispute resolution. With focus on all the accessibility, efficiency, and fairness, GSADR Alliance fosters collaboration that transcend borders, ensuring that disputes are resolved with trust and neutrality, no matter where they arise. At this point, I request my colleagues to, if possible, to share the knowledge partners details so that it will be an interesting phenomenon to begin with. Already in principle, the institutions in Global South as well as in Global North have taken it quite a serious note and are ready to support in this task by initially having a cooperation with us. This first beginning is knowledge partner. We have the Chartered Institute of Arbitrator South Africa, wherein a wonderful speaker mentioning about AFSA as well as the SIAB South African role. And very interestingly, similar to Indian Peninsula, the southernmost tip of South Africa, having a multiple geographical advantage, they are also partnering with us. Then we have a university, that is DSNLU in Visakhapatnam. We have the Camera D Commercio. It is in French. Sorry, it's in the Spanish arena, particularly focusing in Lima. Then we have the USMP. We have the Shenzhen Court of International Arbitration. We have Mr. Elias initiative in Lebanon. We have the Philippines Arbitration Center in the Visayas, PACB. We have Banja's company. We have the Sri Lankan National Arbitration Center. We have the Niti Partners and Associate. We have the Nigerian Chamber of Commerce, DRC. We have the MARC based out of Mauritius. We have the Jordanian Jordan International Arbitration Center. We have an excellent, the Mexican ENAR, and the subsequent slide would show the continuity of this list. Can you move on to the next slide? Yes. We have the whole-time supporter, the Southern India Chamber of Commerce and Industry. We do have the Swiss Arbitration Association from the Global North. We have Blackpole Group from Dubai. We have INIA, wherein Mr. Arif was so kind enough to make this successful event. We have LATCAM from a very interesting jurisdiction in South America. The speakers are going to share in the coming sessions. We have the Universitat EFIT. We have iResolve, a contemporary ADR institution, very successful institution, where I personally have a connect for long, based out of Tanzania. We have the ACMC, We have the Asian International Arbitration Center, part of the ALCO initiative. We have the firm from Mexico, from Adras Ota. We have the Medellin Bureau, and further stretching, we do have the next slide. The arbitration boutique Co-Global, which is the global technical partner, along with supporting organizations of KF, Kovise Foundation, Kovise Ecovacity, Kovise Agro, and Kovise Chamber of Agriculture, all the major the affiliates of the Kovise Foundations, which are the leading supporters for this initiative. Can you move on to the last one? Next. Yes. And finally, the venue partner who are always with us, the Sikhi Center for ADR, there's a Southern India Chamber of Commerce Arbitration Institution, as well as the media partner, the Stockholm Chamber of Commerce Arbitration Institute. I wholeheartedly thank you. But anyway, this is just a beginning. And in this particular Thirunal, we have just completed some 60-65%. We have very interesting speakers on the line. And now I'll hand over to my colleagues to further run through, starting with our Philippines colleague.
Before that, I would like to take this moment to thank Inbavijayan sir for that truly insightful and inspiring address. Your words today are a testament to your profound commitment to the principles of justice, your unmatched expertise in international arbitration, and your visionary leadership that gave life to GSADRT. You have not only shaped legal discourse, but have also empowered a global community of dispute resolution professionals through your mentorship and guidance. We are deeply grateful for your continued dedication and for being both a beacon of knowledge and a source of inspiration to us all. Thank you so much, sir.
Moving on to the next session, we have Mr. Jonah from Philippines. We are pleased to welcome Mr. Jonah, a seasoned legal practitioner with over 2 decades of experience in litigation and alternate dispute resolution. He's the founder and president of the Philippine Arbitration Center in the Visayas and currently serves on the board of trustees of the Philippine Dispute Resolution Center. Mr. Pueblo is a certified arbitrator, a professor of law, and a recognized authority in construction arbitration, having chaired numerous tribunals under CIAC and PDRCI rules. His academic and professional contributions, including international training and authorship in ADR, reflect his deep commitment to advancing dispute resolution in the Philippines and beyond. We cordially invite Mr. Jonah to share insights on the realm of ADR in Philippines and enrich today's session. Over to you, sir.
Hello, good evening here from the Philippines. I hope everybody can hear me. Can I see a thumbs up?
Yes, sir, we could hear you.
Okay, thank you very much. Hello, Inba. Thank you for inviting me. So I'm attorney Jonah Pueblo. I'm a lawyer from the Philippines. So I'll be discussing arbitration here in the Philippines and how Philippine arbitration affects also or interacts with international arbitration. So if you will allow me to share my screen. Thank you very much. So I'll be discussing Philippine arbitration institutions and recent Philippine Supreme Court jurisprudence. So my lecture will scope are the various arbitration institutions in the Philippines, what law affects Philippine arbitration, Philippine Supreme Court jurisprudence on arbitration, and the Philippines in international arbitration. Next slide, please. So what are the various ADR institutions in the Philippines? So we have the Philippine Dispute Resolution Center. It is considered as the premier arbitration center in the Philippines. Most commercial arbitrations in the Philippines are conducted through the PDRC. We have a new one also, the Philippine International Center for Conflict Resolution, or the PICCR. It acts as the arbitration arm of the Integrated Bar of the Philippines. That's the primary legal society in the Philippines. And then the aim of the Philippine International Center for Conflict Resolution is not only domestic arbitration, but also international arbitration. And then the last one, which is close to my heart, the Philippine Arbitration Center in the Visayas. I'm sorry, can we go? Yeah. It is the first school-based arbitration center in Southeast Asia and the first arbitral institution outside of Manila. So in the Visayas, which is the heart of the Philippines, we have an arbitration center which was founded in a law school. And through that law school, we enhance or advocate the awareness of dispute resolution, including arbitration. Next slide, please. So what Philippine laws affect international arbitration? So we have this perception of international arbitration. The general perception is that party autonomy. However, because of certain laws, especially on construction arbitration, the Philippines has quite a unique setup. In what sense? Because we have this law known as the Executive Order 1008. For all intents and purposes, we have, when it comes to construction dispute in relation to arbitration, including mediation, if it's a construction dispute, you have the jurisdiction is through the Construction Industry Arbitration Commission, or the SIAC. No? It's a statutory obligated arbitration. That means it is an because it's required by law. So if you have an arbitral dispute involving construction, you have, if it's in the Philippines, you have to follow or go through SIAC, no, or the Construction Industry Arbitration Commission. Also, we have the Public Act 9184, or the Government Procurement Act of 2003, wherein all government procurement disputes, even if there's no arbitration clause, because of the mandate of this law, you are required to resolve your dispute through arbitration. And if it's again a construction arbitration, you will have the jurisdiction is with the Construction Industry Arbitration Commission. Notwithstanding, even if you you place in your arbitration clause a different institution, whether it's international or domestic. And then our Republic Act 9285, or the ADR Act of 2004, we created our Office for Alternative Dispute Resolution. It provides accreditation of arbitrators, mediators, or ADR practitioners who wants to resolve disputes governing or concerning government entities or government-related disputes. So these are usually the three major Philippine laws that may affect international arbitration. For if you're an international arbitration practitioner, who you might find it a little bit different, especially on the concept of party autonomy. Okay, so next slide, please. So as I've said, insofar as construction arbitration is concerned, even if you have a different arbitration clause, that provides a specific arbitral entity or institution. But if it's a dispute, a construction dispute in the Philippines, you have to file your case, or anybody can file the case at the Construction Industry Arbitration Commission. Because Section 4 provides that SIAC shall have original and exclusive jurisdiction over disputes arising from or connected with contracts entered by parties in construction in the Philippines. And it's so expansive that it does not only deal with direct construction-related concerns. Even adjacent aspects of the construction dispute may be covered by the Construction Industry Arbitration Commission, not only issues of workmanship, but it will also include violation of the terms of agreement, interpretation, payment default. No? So the only thing that is excluded on the very expansive jurisdiction of the SIAC is issues of employer-employee relationship, and if there is no arbitration clause in that contract. That is the only time that SIAC cannot have jurisdiction. So there should be an arbitration clause, and it should be construction-related dispute. However, again, as I've said, if it's a procurement issue, even if there's no arbitration clause, because the law already requires parties that in the event of dispute, you have to go to arbitration. If it's a construction dispute, then it has to go with the CIAC. Next slide, please. So, obviously, numerous case. I'm sorry, I lost my screen. Well, numerous cases were filed challenging the jurisdiction of the CIAC. I can't seem to find my screen. Well, in any rate, as I've said, there is a case where one case or a party to the arbitration clause provided for a specific institution other than the SIAC. Now, for example, there was a case that it said the case should be filed at the ICC, or the International Chamber of Commerce. But since it's a construction dispute, they went to the Supreme Court of the Philippines, and the Supreme Court ruled an arbitration clause or a submission to arbitration shall be deemed an agreement to submit an existing or future controversy to the CIAC jurisdiction, notwithstanding the reference to a different arbitral institution or arbitral body in such contract or submission. So that was shut down by the Supreme Court, saying SIAC still has jurisdiction. In another case, the Supreme Court stated that since SIAC jurisdiction is conferred by law, it cannot be subjected to any condition, nor can it be waived or diminished by the stipulation, act, or omission of parties. So as long as the parties agree to submit the construction contract dispute to arbitration, or if there is an arbitration clause in the construction contract, the SIAC, no, as long insofar as construction arbitration dispute in the Philippines will have jurisdiction. There was also an issue whether who has legal personality to file a case involving the collection of sum of money which involves a construction contract. That party challenged the SIAC jurisdiction, saying this is no longer a construction dispute. This is just a matter of collection of sum of money. The Supreme Court says the law does not preclude parties from stipulating a despite the law providing a preferred forum or arbitral body, they cannot divest the SIAC of jurisdiction as provided for by law. And even if it is not primarily a construction dispute, but if it is related to construction, including collection of sum of money as a byproduct of that construction dispute, then the SIAC has jurisdiction over the matter. Next slide, please. Oh, okay. Here in the Philippines, the trend right now is the concept of dispute boards. Now, I don't know if some of you are familiar with the concept of dispute boards, but right now, because of the numerous construction projects in the Philippines, the government is beginning to use what we call, if anyone familiar, FIDIC condition of contracts. So with FIDIC contracts, part of the dispute resolution mechanism uses dispute boards. In one of these construction disputes, one of the parties filed a case at the CIAC or the SIAC, saying that because SIAC has jurisdiction, then the case or the dispute has to be resolved by SIAC. The other party challenged it, saying, no, this is a FIDIC contract. And it is clear in the FIDIC contract, as part of its multi-tier dispute resolution mechanism, is that a dispute board has to be convened first before it can go to arbitration. The Supreme Court said no. Even if there are other forms of dispute resolution mechanism that is required, but the end result is arbitration, then the SIAC can immediately acquire jurisdiction. So, in a sense, on the perspective of international arbitration, practitioners in international arbitrations who are into construction arbitration, especially dealing with FIDIC contracts, are a little bit aghast, for a lack of a better term, with how things work in the Philippines insofar as construction arbitration is concerned. With regards, however, on the perception of whether the Philippines is an arbitration-friendly jurisdiction, I promise you the Philippines is an arbitration-friendly jurisdiction. Why? Because of the numerous rulings of the Supreme Court favoring arbitration. So, for example, the Supreme Court of the Philippines, in one of its cases, decided that interpretation of contracts should be construed to favor or give life to the arbitration clause rather than defeat it. Another ruling of the Supreme Court where arbitration was challenged, the Supreme Court stated that arbitration agreements are liberally construed in favor of proceeding to arbitration. Thus, the general rule in the Philippines, insofar as arbitration is concerned, when in doubt, the Supreme Court will rule in favor of arbitration. The Supreme Court will rule in favor of the enforcement of an arbitral award, except if it violates public policy rules. So, the Philippines is an arbitration-friendly jurisdiction. In fact, Filipino lawyers are quite adept insofar as international arbitration is concerned. Why? Because of our history. Now, we were colonized by Spain. So we are our judicial system is well entrenched in civil the civil procedures or the civil aspect of the practice. But since we were also colonized by the Americans, we are also adept with common law. So we are both a civil law and a common law country. And for international arbitration, that is considered as an advantage. So, insofar as the recent ruling of the Supreme Court in Mabuhay Holdings, or that we call the Mabuhay Holdings Doctrine, in view of the numerous Supreme Court rulings, the Supreme Court said it will always lean towards presumption in favor of ADR. The Supreme Court will not review or reverse an arbitral award unless it violates the public policy rule. So if you want to challenge the enforcement of an award in the Philippines, you have to make sure that you have a very strong public policy grounds. If not, expect of all likelihood your challenge of the enforcement of that award will be denied by the Supreme Court. No? It will always favor the arbitral award. There are rulings, or there are attempts to challenge an arbitral award wherein they insist on the modification of these arbitral awards. The Supreme Court said no, you cannot modify an arbitral award. So whether there is even a clear error on that arbitral award, the Supreme Court said the courts cannot modify arbitral awards. So what are the recent arbitration developments in the country? So we are now big also on sports arbitration and sports mediation. So the Philippine government entered into a MOA with one of the Philippine institutions in arbitration, the PDRC, which is the gold standard here in the Philippines. They entered into a memorandum of agreement where sports disputes may be resolved through arbitration and mediation. We also issued Republic Act 12021, or the Magna Carta of Filipino Seafarers. You would know that there are a lot of Filipino seafarers all over the world. With this law, it provides that all covered ocean-going ships are required to provide onshore and onboard grievance mechanism, which shall be submitted through voluntary arbitration. So if there are disputes insofar as Filipino seafarers are concerned, arbitration is the ultimate dispute resolution mechanism. In the tourism aspect also, we are creating tourism courts and establishing tourism arbitration and assistance centers involving tourist concerns. And the recent one is the Philippine Arbitration Center in the Visayas has signed a memorandum of understanding with Teres for the use of artificial intelligence in arbitration of disputes administered by the PACV. So insofar as arbitration is concerned, we are now matching the international standard, where the use of artificial intelligence is used in arbitration hearings. And the Philippine Arbitration Center, the Visayas, is the first institution that is using artificial intelligence in its arbitration cases. The Philippines has been in the international limelight for two arbitration disputes. One is the Philippines versus China arbitration in The Hague, covering the West Philippine Seas. So in that arbitration where China did not recognize the arbitral tribunal at The Hague, applying the doctrine of competence said, no, we have jurisdiction over the matter. They resolved and issued an arbitral award. Well, sadly, until now, it is not yet enforced because on the international level, the main problem is how to enforce it with regards to states. And if that state doesn't follow, what do you do next? So that's where we are right now. But the Philippines won in that arbitration award. The other one is the heirs to the Sultanate of Sulu versus Malaysia. And this one is a little bit where heirs of the Sultanate of Sulu involving the Sabah territory tried to went to arbitration insofar as the company that that handled the I think the oil concession in Sabah, no? But despite the award issued in favor of the Sultanate of Sulu, this has not been enforced, and in fact, the arbitrator has been challenged and sanctioned. They tried to enforce this in Spain and in France, but I think it did not go the way they wanted. I'm not favoring any of these parties, okay? I'm just expounding to you two international arbitration disputes involving, in a sense, the Philippines. So that's Philippines versus China on the West Philippine Seas, and the heirs to the Sultanate of Sulu versus Malaysia. So, all in all, the Philippines is very arbitration friendly. Enforcement of awards in the Philippines has not been a problem, even for international arbitral award or foreign arbitral awards. But I do understand that some international councils or international parties are a little bit concerned with the monopoly of the Construction Industry Arbitration Commission in the Philippines involving construction disputes in the Philippines. But insofar as the Philippines is concerned, the Construction Industry Arbitration Commission works. In what sense? In the Philippines, the SIAC is required to resolve a construction dispute within 6 months. So you cannot go beyond, an arbitrator is forced to resolve the dispute in 6 months. So all disputes involving construction disputes in the Philippines ends in 6 months. That has not been a problem with the Philippines, especially that it actually benefits international practitioners, considering that if the issue or the property that you want to challenge in the dispute is in the Philippines will immediately enforce that dispute. No, usually I advise clients in resolving on issues of construction, if the property or the company where the money is in the Philippines, you're better with the Construction Industry Arbitration Commission filing it at the SIAC, because the Philippines will immediately enforce it. But obviously, if you want to enforce an award where there's no property here in the Philippines, then you're better off handling it to the international whatever arbitration clause that provides an international institution, assuming it's an international arbitration in construction. So I promise Inba that I'm going to finish it in 30 minutes. So I hope I've done my I complied with it properly. I'm happy if there are any questions insofar as Philippine arbitration is concerned.
Joner, I have a participant question raised here. Anyway, before going into the question, thanks for the highlight of DRBs, the dispute review boards in Philippines, and the interesting judgment about the public policy making Philippines to be a pro-arbitration regime. A participant, Mr. Sushil Shankar, has raised, what is the basis for arbitration in seafarer dispute in the Philippines? In which contract does an arbitration clause exist when it comes to seafarer? Any thoughts on that?
Thank you for that question. So basically, yes, this is what we call the statutory required or statutory mandated arbitration mechanism. So if it's a contract with a Filipino seafarer, which generally is being issued in the Philippines, then you are whatever that contracting company is or maritime company is, you can be sued in the Philippines, or the seafarer can file an arbitration case here in the Philippines. And you will be because it's mandated, then the Philippine law will require you to comply with the arbitration. So the intention is to protect the seafarers, the Philippine seafarers, which right now I think compose like almost 55% of the world seafarers.
Thank you, Jenna, for the enlightening presentation, and particularly sharing one more interesting note about Philippines and PACV, wherein it emanated from the law school, a university. It is hats off for the efforts done in Philippines, and universities, particularly universities attached area centers, have to facilitate. That is very, very important. And with this note, I thank once again on behalf of KFCRI to joining in this GSADR Thirunal day and made it a success as of now. We're very happy, and our relationship should be there for the GSADR Alliance. Thank you, Jenna.
Thank you very much for having me, Inba. Good evening to all.
Good morning, good afternoon, good evening. I know our audience spans across multiple time zones, and I'm delighted to join you wherever you're tuning in from. My name is Abdullah Abu Wasil. I am the Deputy Managing Partner of Wasil & Wasil, a disputes and geopolicy firm with offices in Washington, D.C.
Sorry to interrupt, Mr. Abdullah. We have prepared a introductory speech for you. Let me take over that.
Oh, yes, of course, of course.
Sorry for that.
No, please.
Ladies and gentlemen, I take immense pleasure in welcoming Mr. Abdullah Abu Wasil, who is a distinguished legal professional and thought leader in international arbitration and space law. He currently serves as a Deputy Managing Partner of Wasil & Wasil and Secretary General of the Jordan International Arbitration Center and Chief of Staff at the Hague Institute of Global Justice. Mr. Abu Wasil has represented high net worth investors in complex investment arbitration disputes across the Middle East and has appeared before numerous arbitration tribunals and legislative bodies, including the US Congress. He is also a key contributor to the global space policy, having co-authored the Washington Compact, a landmark treaty on commercial space conduct. We are honored to welcome Mr. Abdullah Abu Wasil to share his insight in evolving ADR landscape in Jordan and the broader Middle East and enrich today's proceedings with his global perspective. And the dice is up to you.
That was a phenomenal introduction. I couldn't have done it any better than that. So thank you so much. And on that note, let me express my deep gratitude to the Kovise Foundation and Inbavijayan for convening a remarkable event. I think that the Global South is more than a geographic label. It represents a dynamic network of emerging markets, entrepreneurial spirits, and legal innovators reshaping the 21st century. From manufacturing drones and aerial vehicles to pioneering fintech and cryptocurrency, the global south is redefining the new world. And with that, comprehensive resolution frameworks are needed, and that brings us to Jordan. So I am the Secretary General of the Jordan International Arbitration Center. Jordan is nestled at the crossroads of Asia, Africa, and Europe, and our kingdom has always acted as a bridge commercially, culturally, and legally. And this started with our Bedouin tribes doing oral conciliation and mediation in the deserts, to the Ottoman era Qadi courts, and now to the modern era, which has harmonized the UNCITRAL inspired statutory framework. So today, Jordan's arbitration framework is defined by 4 pillars. The first being Jordan's arbitration law number 31 of 2000 and its subsequent amendments, which took place in 2018. Second, its emerging institutional infrastructure, that being the Jordan International Arbitration Center, to administer global disputes within Amman. And third, a judiciary that has embraced arbitration through consistent pro-enforcement rulings. And finally, the ongoing reforms that are being designed to keep our processes agile, tech-savvy, and user-focused. So this journey is vital because the global south is very much confined geographically within the MENA region. A renewable energy project financed in Europe, built by Jordanian contractors and underwritten by a consortium of Gulf and Asian investors, will present novel legal questions. And if we want parties to see Amman as a natural neutral forum, just as they see Singapore, Geneva, or Dubai, we have to offer them modern laws, not only on the books, but also world-class institutions that harness artificial intelligence, virtual proceedings, and seamless digital file sharing. So this afternoon, I'm going to walk through those 4 pillars to give you an introduction to Jordan's arbitration framework and JIAC, of course. And at the conclusion of this, please feel free to shoot me an email, connect on LinkedIn. The arbitration community is very welcoming, and I would love to get to know all of you. So I'm going to commence by talking about the arbitration law, which essentially is the foundation of arbitration in Jordan. And that's based on law number 31 of 2000 and its subsequent amendments. Now, the Jordanian arbitration law, similar to the majority of arbitration laws in the Middle East, was derived from the Egyptian Arbitration Act, which itself is based on the UNCITRAL model law. Now, those familiar with international arbitration will know that the majority of countries have based their national arbitration laws on the UNCITRAL model law, including India's Arbitration and Conciliation Act of 1996. It's adaptable, it's reliable, and it's proven for success. But in 2018, the Kingdom of Jordan issued amendments to the model law, issued amendments to the Jordanian arbitration law, which made it significantly closer to the UNCITRAL model law, but with key differences. And some of those differences include the applicability of the Jordanian arbitration law to both international and national arbitration, a preliminary award on jurisdictions being capable of challenge only in the course of annulment of the final award, and a time limit of 12 months to render the award, running from the date of the tribunal being constituted rather than the date of the proceedings commencing. Now, Jordan's unique 12-month clock for issuing the final award was inspired by Switzerland and Singapore, but runs from constitution rather than hearing commencement. Tribunals now in Jordan meticulously plan procedural timetables in their terms of references, or they risk court-imposed sanctions by mutual agreement, fostering greater procedural discipline. But following the 2018 amendments, arbitration in Jordan grew substantially. Filings rose by about 25%, reflecting a growing confidence in Amman as a seat of arbitration. And anecdotally, about 60% of modern arbitration agreements with Jordanian parties now expressly select Amman, which is up from about 10% in 2015. So this is a substantial evolution that we're seeing in arbitration being seen as, rather than an exotic alternative, as a suitable resolution mechanism. And although the Jordanian arbitration law is published in Arabic, I want to note that our team at GIAC has drafted an unofficial translation of the law in English, which can be found on our website, giac.world. And I'm going to share my screen for just a brief second to show you. Let me see. Okay, so this is the GIAC website. It is giac.world. And as you can see here, if we go to the Jordan arbitration law, we have both a HTML format and we also have it formatted in a web page style for the ease of users. However, if you would like to download a copy, you can do so, which is the unofficial translation by GIAC with footnotes and everything needed for users who are entering the market for ease of accessibility for users. So that's the Jordanian arbitration law. And internationally, Jordan is also a party to the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. And it's also a party to several bilateral treaties on legal assistance with its neighboring countries, such as Egypt, Qatar, and the UAE. But one of the points that I have to make significant is the Kingdom of Jordan did not have an arbitral institute to administer disputes similar to Egypt's KRICA or the UAE's DIAC or ADGM. Under the arbitration law, coordination of arbitration-related court matters was scattered among 3 tiers of judiciary. Now, the Court of Appeal handles judicial assistant requests, such as orders to compel document production or to appoint default arbitrators. The Court of Cassation adjudicates enforcement and annulment applications for domestic awards, and the Court of First Instance is charged with enforcing foreign ceded awards. But despite this scattered framework, there was no dedicated arbitral institute within Amman to guide parties, manage filings, or just essentially provide institutional support. In March of last year, we started the Jordan International Arbitration Center precisely to fill that institutional void. Now, to ensure global standards, GIAC is supported by an international advisorate consisting of leading practitioners, academics, and in-house counsels from every major arbitration hub. And we are particularly honored to have Dr. Wolfgang Peter, the architect of Switzerland's unified arbitration centers, serving as our honorary president, who provides invaluable guidance on governance and best practices. In our first year, which was 2024, brand positioning was paramount. We sponsored virtually every major international arbitration gathering, London, Istanbul, Washington, and China, and we established Amman as a serious up-and-coming venue. Now, parallel to these outreach efforts, we forged a partnership with JuiceMundi, the premier global arbitration database I'm sure many are cognizant of, contributing our translations of Jordanian court rulings and our forthcoming rules so that practitioners worldwide can access and cite Jordanian materials with ease. And in this regard, I'll show you here. What we have done is we've aimed to make this is the JuiceMundi partnership page. As you can see, we have published 15 cases thus far with details and translations so that those entering the market can easily access all of the information that they need. The composition of the tribunal, who was on counsel, and all the additional information needed. So this partner was started last year, and thus far it is going very smoothly. But as we begin to draft the GIAC rules of arbitration, we find ourselves in a unique opportunity to essentially paint on a blank canvas. We've spoken to the Secretary Generals of almost every single arbitral institute. I have good relations with all of them, just to understand their rule-making journey. But in recognition of our era, our rules are also taking into consideration artificial intelligence, virtual hearing protocols, electronic case management, just to ensure GIAC stays ahead of technological disruption. And geopolitics too shapes our mandate. Historically, the Kingdom of Jordan has acted as a neutral mediator in regional disputes, from trade embargoes to water resource allocations, while maintaining trusted relationships across continents. So GIAC aspires to embody that neutrality, whether parties come from sanction-related claims, tariff disputes, or complex cross-border joint venture disagreements. They will find Amman as a suitable venue. But ultimately, from learning global best practices, honoring what has worked elsewhere, and weaving in the technological and geopolitical realities of 2025, GIAC aims to become not just Jordan's arbitral institute, but the dispute resolution hub of the Levant, an institution where parties worldwide can confidently place their disputes, knowing that they will be resolved efficiently, transparently, and fairly. And we're excited to be bringing the GIAC rules of arbitration to you very soon. And I will be sure to share those with everyone accordingly for your feedback. But one aspect that has been prevalent across the globe is the digitization of the judicial system, and foreigners entering the Jordan legal system find challenges locating relevant materials because public information on case law is scarce and Google is not your friend in Jordan. So to address this, and similar to our publication of the Jordanian arbitration law, GIAC has collected select case law from the Jordanian courts to provide guidance towards the current standing of the Jordan judiciary on pivotal issues on arbitration proceedings in the Kingdom of Jordan. Again, those can be found on our website, giac.world, under Select Case Law. We have provided an English summary of all of these judgments with the case reference itself. And these can also be found on JustMundi with all of the original documents filed before the courts. What is ostensible from this select case law is that the Jordanian courts embrace arbitration wholeheartedly. Jordan's highest court, the Cassation Court, repeatedly confirms strict adherence to party autonomy and arbitrator competence. For example, in the Cassation Court's judgment for case number 112 of 2022 and 297 of 2023, the Court of Cassation underscored the principle of competence by confirming that challenges to arbitrary jurisdictions belong first to the tribunal itself, with judicial review deferred until any later annulment proceedings. This deference upholds parties' choice to have expert panels decide their own scope. Similarly, in case number 916 of 2022, if I'm not mistaken, the Cassation Court illustrates their expansive view of what constitutes a written arbitration agreement. There, they said that even an unsigned standard form contract binds its signatory when the clause was clearly incorporated by reference and the party thereafter paid filing fees. This pragmatic approach lowers hurdles for enforcing arbitration clauses in the region, in contrast to the more rigid interpretation that we see elsewhere. In case number 2246 of 2019, the Cassation Court reaffirmed that annulment petitions are not backdoor appeals. Absent a manifest breach of public policy or a tribunal acting beyond its mandate, the reviewing court confines itself to examining formal defects such as capability, procedural irregularities, or arbitrator impartiality, thereby safeguarding the finality of our awards. And finally, in judgment number 2301 of 2022, the court crystallized Jordan's strict non-intervention principle under the New York Convention by enforcing a London seat award, making clear that neither the choice of the seat nor institutional rules justify judicial encroachment, so long as the award does not offend narrow public policy exceptions. Taken together, these judicial decisions reveal a judiciary that regards arbitration, again, not as an exotic alternative, but as a mainstream, well-understood mechanism deserving of full respect. And across multiple judications from Jordan's judiciary, the pro-arbitration stance has become clear. So what GIAC has done by codifying these principles in publicly accessible English language summaries is to shape how users perceive and engage with Jordan's robust pro-arbitration courts. And there are a lot of reforms currently taking place in Jordan, one of them being the digitization efforts of GIAC. But of course, one of the most impactful endeavors currently taking place is that of ours. As noted, Jordan didn't have an arbitral institute up until last year. So when we established the Arbitral Institute, the idea was to get everyone on board in the country so that we can develop this institute into a comprehensive body for the kingdom. So it was established in March 2024, and it aims to become the country's arbitral institute. And we are working closely with the University of Jordan, with the Ministry of Jordan, and with many others to help GIAC boost its reform of the Jordan arbitration system. But at the same time, the Jordan arbitration law is constantly being reviewed for scrutiny and for any amendments. Just, I believe 2 weeks ago now, the Minister of Justice for Jordan convened a meeting with the Jordanian Arbitrators Association to discuss the developments to arbitrator training, to the arbitration law, and to initiatives for university students who are looking to get involved in ADR. And with that, currently workshops are being developed for arbitrators to meet international standards, and there are workshops being developed for students to become better practitioners. But ultimately, dispute resolution has long been present in the kingdom, but more effort has been put recently towards fine-tuning arbitration specifically. GIAC and the Jordanian Ministry of Justice are leading the charge on this. Arbitrators and practitioners are being trained to meet international standards. Jordanian arbitration law is constantly being scrutinized. And looking ahead, there are exciting opportunities for collaboration and engagement with Jordan's arbitration community. GIAC, we invite universities, bar associations, international institutions to partner with us on advanced research programs or training programs, whether exploring AI-assisted document review, sovereign immunity and questions, or disputes arising from renewable energy ventures. In the coming months, we will circulate our rules of arbitration, and your insights as practitioners, as arbitrators, as students will be invaluable in refining these procedures. So we very much look forward to your comments on those. Finally, when structuring your next cross-border agreement, consider designating Amman as the seat under GIAC administration so you can benefit from our modern, UNCITRAL-inspired framework, expedited timelines, and a truly pro-arbitration judiciary. Together, we can not only elevate Jordan's arbitration framework, but also the global hub, the global South as a new hub for arbitration. I thank you all for taking the time to listen to me today. Again, please feel free to connect on LinkedIn. Please feel free to shoot me an email. I remain completely available to connect with all of you. And on behalf of everyone at GIAC, thank you again for having us. And I hope everyone has a remarkably tranquil weekend ahead.
Thanks a lot, Abdullah Abu Wasil. I just have a simple question on interim measures, which I think it is up to, like, what extent can arbitral tribunals seated in Jordan issues enforceable interim measures, and what are all the limitations where such kind of interim measures are challenged or required court's assistance in enforcement?
Can you hear me?
Yeah, I could.
Okay, so what extent can arbitral tribunals in Jordan issue interim measures? So in Jordan, the arbitration law provides that arbitral tribunals seated in Jordan possess express authority to order interim measures, subject to the parties' agreement. Under Article 23 of the law, it provides that parties may empower the tribunal to grant any provisional relief they deem necessary, whether to preserve evidence, maintain or restore the status quo, secure assets, or protect witness testimony. And absent any contrary agreement, the tribunal may, on its own initiative or at a party's request, issue such measures. In practice, as a practitioner myself, in practice, this has enabled tribunals to tailor relief to the specifics of each case. They draw on a broad discretionary mandate that mirrors and in some respects expands on comparable powers under the UNCITRAL model law. But because the tribunals lack coercive power, any interim order must be enforced by the courts themselves. If a party refuses to comply with the tribunal's measure, the tribunal may certify the order to the competent Jordanian courts for immediate enforcement, whether by seizing assets, compelling document production, or freezing bank accounts. This is a two-step mechanism, the tribunal issuance followed by the judicial enforcement. This ensures that both the effectiveness of the interim relief and respect for both the judicial oversight.
Perfect. Thank you. Thanks for the question.
So my question to you, Mr. Abdullah, is how far JIAC is embracing technology or innovation to improve arbitration process, be it in domestic or international cases?
Thank you. Thank you for your question. Yes, this is something that we take into consideration very strongly. As a personal anecdote, I am on the younger side with respect to my age, so I understand the embrace and the substantial effect that technology will have. I saw when the internet was dial-up. You remember when it was dot, 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 and you would dial up your internet. I saw when it became Wi-Fi, and now I'm seeing AI. And that's something that we're taking very strongly into consideration. And I can give you some insight. One of the things that we're currently looking at, and this is exclusive, no one knows about this so far, but one of the things we're currently looking at is a partnership with Justical. Justical is one of the leading virtual proceeding providers in Finland, if I'm not mistaken. And the goal there is we will have at JIAC, hopefully, a fully virtual proceeding system, so that just how you and I are speaking right now, we can be in multiple corners of the world and have proceedings handled virtually without the need for calls, without the need for anything. Just have everything handled virtually. And with that, we are looking at the possibility of an AI arbitrator. Now, this is something that's very extravagant, and parties, I can tell you as someone who deals with clients daily, parties are going to be hesitant to implement an AI arbitrator because you don't want a decision in seconds. You want someone who thought about a decision. But this is something that is currently picking up traction, and we are taking it into consideration as well. And we're looking forward to possibly adding it into our rules so that if parties agree to have their dispute adjudicated by an arbitrator, we can simply take all the facts, take all the case file, give it to the AI, and have the arbitrator give the award. The virtual proceedings, of course, is another one. And then another aspect that we're also looking at is the digitization efforts. Have everything digitized. The DIFC courts does this phenomenally, and I give my commend to them and to the DIFC arbitration court. But the digitization efforts is what we're looking at, because in Jordan right now, everything seems to have excelled substantially except the digitization efforts. So that's what we're also looking at working on.
Thank you. Thank you, Abdullah, for sparing your valuable time, even though you are in the western part of this globe. Your input on the Jordan is most valuable and acceptable. No doubt, with the limitation on the digitalization, the other components prevailing in Jordan would facilitate it to be a very prominent and promising hub in the Global South, to be an arbitration-friendly jurisdiction. And with this note, we are very happy to partner with JIAC in the Global South ADR Alliance. Thank you.
Mm-hmm. Thank you so much. You guys are phenomenal. The work you're doing is phenomenal. And I wish you the best of luck, and I wish everyone a tranquil weekend ahead. Thank you.
So the next speaker for the day is Mr. Fola Alade. We are honored to welcome you, sir. He is a distinguished notary public and a leading figure in Africa's ADR landscape. He is the founder and principal partner of FOTEFA Partners LP and the visionary behind the Mediation Academy of the same, where he has significantly advanced ADR practice and education. Mr. Fola serves as a global mediator with the United Nations and holds numerous prestigious appointments across Nigeria's legal and ADR institutions. Renowned for his dynamic training style and thought leadership, he continues to shape the future of dispute resolution through mentorship and innovation. We invite Mr. Fola to address the gathering and share his valuable perspectives on the domain of ADR in Nigeria. Over to you, sir.
Yeah, thank you so much, Shakti. I'm audible. Can you hear me?
Yes, sir.
Awesome. Yeah, I'm truly honored to be here with everyone. So I remember when Imba reached out to me to speak on international on ADR specific reference to arbitration. I told him, I said, Imba, I'm a mediator. I'm a full-blooded mediator. I said I eat, drink, and sleep mediation, but I will be happy to speak on your platform because I believe that if we all call ourselves ADR practitioners, we all should be able to work together. And my starting point really would be on this note. I have this implicit belief that arbitration, ADR, the approach to ADR should be more like some kind of trajectory. And when I'm talking about trajectory, what do I mean? When disputes arise, we should start off with negotiation. If negotiation fails, we try mediation. If mediation fails, then we then try arbitration. I believe if we all work together and adopt this procedure, we'll find an enabling environment that will be very, very dispute friendly to practitioners. So on that note, I will be talking about today's paper. I was told to speak about the role of Nigerian parties as stakeholders in international mediation. So I think the starting point really should be this. Why does Nigeria matter in global mediation? Why are we having conversations about the infusion of Nigeria into global mediation? Ladies and gentlemen, Nigeria is not only Africa's most populous country and largest not only the most populous country and largest economy, it also plays a very significant role in regional commerce. And as global disputes have become more complex, Nigeria's participation in mediation, not only arbitration, is critical for regional and global stability. Now, I think at this point, I should also talk about the population of Nigeria as I speak right now. Nigeria has over 200 million growing population. Now, thanks to technology, I dare say that the world is already flat now because I'm here in Nigeria. I'm having conversations with practitioners and attendees from all over the world. Now, the infusion of technology into what it is that we do right now has also significantly increased engagement in cross-border transactions. Now, most commercial transactions are now beginning to have the tripartite dispute resolution clause that talks about negotiation, that talks about mediation, and eventually talks about arbitration. Now, these clauses are also being included in tech, construction, and energy. Now, the significant impact of what is happening right now has also helped in some legal and institutional foundations. Now, Nigeria has also enacted the AMA, which is the long form of Arbitration and Mediation Act, which now formally recognizes mediation as a standalone process. Now, because of this, we are now beginning to have strong institutional presence in Lagos, Abuja, and other states in Nigeria. Multi-door courthouses are springing up. Private mediation centers are now springing up. And interestingly enough, the Nigerian courts are now beginning to not only support but enforce mediated settlement agreements, to the effect that agreements that have been settled are then adopted as consent judgment between parties. Please permit me to just talk about some of the key highlights of the Nigerian Arbitration and Mediation Act. I'll speak to section 67 sub 1, which ties into today's topics and talks about how the law would apply to not only domestic but international commercial mediation proceedings. So what this invariably means, ladies and gentlemen, is that if Nigeria enters into any commercial transaction with any country and there's a dispute at all, the enforcement can be applied to not only domestic but international settlements. It would also interest you all to know that section 73 sub 5 of AMA also gives preeminence to online dispute resolution. So the era of having to leave one point to go to another point has been replaced with you virtually mediating from the comfort of your homes. And this law also provides that the parties can conduct the mediation sessions through any electronic means that is available to them. Now, interestingly enough, the growth of ADR with specific reference to mediation in Nigeria is in leaps and bounds. Now, thanks to ADR evolving into ODR, the technology landscape in Nigeria is changing. You know, people seem to be embracing mediation more because of the convenience, because of the ease, and because of the speed. And Section 73 sub 6 of AMA also provides that an agreement that with the agreement of parties, a mediator can also make proposals towards settlement, but has no right to impose settlement on the parties. Now, Section 77 also talks about the fact that information in any form which comes out of a mediation session cannot be used as evidence in any arbitral, judicial, or administrative proceedings. And Section 81 provides mediators with immunity to the effect that mediators cannot be brought to court to talk about any mediation sessions or be held liable in the discharge of their duties unless it has been shown that the mediator has exhibited an element of bad faith. Now, for me, Section 82 sub 2 of AMA seems to be the most significant of all, as it has finally laid to rest the misconceived and the wrong assumption that mediation is not binding. So we can now say that mediation is not only binding, but it is enforceable as a contract. We all know, as a consent judgment, rather, we all know that the end product of a successful mediation settlement is an agreement. That agreement in itself is a contract. So with the infusion of Section 82 sub 2, it invariably states that that particular agreement can be adopted as consent judgment. Now, Section 87 of AMA is not any different from the Singapore Convention on Mediation that we'll be talking about, which essentially states that international settlement agreements are enforceable in Nigeria and the laws of the convention resulting from mediation. Now, to also give further credence to the framework and the geometric progress mediation is making in the global space, we have the Lagos Multi-Door Courthouse, which was a concept that was initiated by the NCMG. Now, please permit me to just give a bit of context into the Multi-Door Courthouse here in Nigeria. Aside from the fact that the Multi-Door Courthouse is the first of its kind in Africa, the concept was first of all brought about by Harvard professor Frank Sander. And essentially what he proposed was a concept of having a court with a multi-door. And the analogy I would use is you just having a building that have so many doors. So the implication is that when there's a dispute that arises, there's a framework of trying to see whether in that same place that dispute can be resolved through negotiation. If negotiation fails, you try mediation. If mediation fails, you try arbitration. So that way, you're able to provide disputants with multiplicity of options. Now, this inspiration was actually was replicated in Nigeria by Kehinde Aino, Senior Advocate of Nigeria, and it was eventually launched in Africa in 2002. Now, the way cases are being referred to mediation at the Lagos Multi-Door Courthouse are in three ways. It could actually do it through the walk-in, where the parties walk into the Multi-Door Courthouse to initiate a mediation, to initiate a suit, or they can actually have court referred. Now, this one is actually very popular. So for cases that are in court, the judge can exercise his discretion to have the case referred to mediation. But mind you, that is all the judge can do. Parties cannot be compelled to settle, but they will be told to see whether there can be available means towards which the dispute can be settled. And of course, we have the direct intervention, where the LMDC director can look at certain cases in the issue of public interest and then decide to come in to resolve the dispute amicably. Now, still within the framework of this, we also have the Singapore Convention on Mediation, to which Nigeria is the 13th, which was ratified in 2023, and Nigeria is a signatory to it. So the implication of this is that countries that have been ratified or signed the Singapore Convention can do international, when disputes arise, the international settlement agreements with coming out of it can be enforced in it. So all of this, ladies and gentlemen, is all happening almost all at the same time. AMA coming out in 2023, and Nigeria being ratified in 2023. And some of the benefits of Nigeria that has come from the ratification of the Singapore Convention is this. We first of all have enhanced dispute resolution mechanisms. Businesses and individuals in Nigeria can also leverage extensively on mediation as a way of having disputes resolved. Now, we're also having increased foreign investment. Now, one of the downsides that has been some kind of stumbling block to foreign investments in Nigeria basically has to do with the fact that when disputes arise, would they be in court for years without end? But with the infusion of mediation into the global scheme of things, more companies are coming into Nigeria. The business environment is more favorable, and it's also attracting foreign investors. And of course, we all know that the language of the 21st century is speed. So and this is one of the frameworks of mediation. You have cost and time efficiency, and most importantly, it's also very accessible to international markets. Now, of course, we cannot do justice to this conversation without looking at some of the cases that have been brought about, some of the cases against mediation. Is the fact that for as long as there is a delay on one side, there's a delay. Delay always favors one side. There's always one side of the party that wants the case to spend longer years in court. And apart from this, again, is also this misconceived notion of the non-bindingness of mediation. People still believing that mediation is not binding. So a lot of awareness needs to be done. And because people are so used to having things done in a particular way, they don't seem to see some of the benefits of mediation. And I dare say that some lawyers too are also not also helping the narrative. They still believe that, if any case comes up, rather than us embracing ADR, we should still try and see how we can go to court to have issues slugged out. Now, of course, parties cannot be compelled to participate except when they are ordered by the court. So the principle of voluntariness can be a sword and can also as well be a shield. So parties cannot be compelled to mediate. And of course, for there to be a successful mediation, there has to be the cooperation of both sides. And if the parties involved in mediation are not willing to compromise, there is no way the process cannot end in failure. But having said all of this, let's talk about the opportunities ahead in terms of the role Nigeria is playing in global mediation. There's a need for Nigeria to also leverage a common base for harmonization with international ADR standards. There's also a need for us to also position ourselves as a neutral seat for not only cross-border mediation in West Africa, but collaboration with global ADR bodies for training, accreditation, and development. And of course, this is also coming into areas of industry-specific mediation. We are beginning to have organizations coming up saying that, you know what, we don't have that much time to spend in court. Can we have issues? Can this dispute be resolved effectively and quick? And because Nigeria has been well positioned to become a leader in international mediation from the global south, critical steps are being taken to include not only institutional strengthening, but legal clarity, intentional alignments, and strategic education. This we can see from conversations that are going around the subject surrounding ADR with specific reference to mediation. Now, in rounding up, I would like to speak about, I would like to end with this picture here, which is a toolbox that states that when disputes arise, I know I said it the first time, but it's also important I rehash it, that one way of having disputes resolved should not be the first port of call. There should be some kind of trajectory. We try negotiation. If negotiation fails, we look at mediation. If mediation fails, we look at arbitration. And I also belong to the school of thought that the rate at which the ecosystem of dispute is changing Should we still be referring to ADR as an alternative? Should ADR still be seen as an alternative to litigation? Or rather, shouldn't it even be seen as an appropriate dispute resolution that provides various ways and manners in which disputes can be resolved? And on this note, ladies and gentlemen, I end my session. And then one of the reasons why I decided to do this was to leave enough time for questions, as I believe that engagement is the strength of clarity. Thank you. So Imba, I think I'm done. I told you I was not going to go beyond 15 minutes.
Thank you, Fola. Anyway, the insight as you shared with us on the mediation, particularly international mediation, and the way Nigerian jurisdiction has facilitated the new Arbitration and Mediation Act. I presume, hope I am right on it.
Yes, you are.
This is a good try, similar to the Indian subcontinent. For your information, in India, we have this legislation or the act titled as Arbitration and Conciliation Act. This is an interesting legislation, traditionally using the word conciliation instead of mediation. And it has facilitated since 1996 in India till the recent legislation of Mediation Act 2023. Being such a development which happened in India, we had a bifurcation of these mediation in the context of court annexed, that is the court referred, then the agreement-based mediation, then we have the institutional mediation, and as a substitution, we have the community mediation and online mediation. These are the very interesting development, not taken from the Singapore protocol, but traditionally what was happening the Indian subcontinent. In the morning, there was a speaker, Indian origin speaker in US, practicing in US. He comes from a particular province in India, which is called Gujarat, wherein that state, as an innovative idea, brought in this court-referred mediation, made it to be a pre-institutional process. Before starting arbitration or before even taking the issues or the disputes to the court registry would eventually refer the matter to mediation. So much of development we have seen in a contemporary period regarding mediation in the Indian subcontinent. That is very, very interesting for us to share with you. And the Nigerian model also happened to be on that same line. And as a participant, we are very interested to hear a different perspective of Nigerian ADR, one pertaining to arbitration, another about mediation, being complementing the ADR scenario in the West African nation. And thanks, Fola, for sharing the insight. And as rightly highlighted, international mediation, particularly on the commercial disputes, would be the future. Thank you. Thank you very much.
Yeah, thanks so much, Imba. So honored to be here. Thank you very much.
So for the next session, today we have with us Mr. Juan Camilo Bolivar. We are delighted to welcome you, sir. He is a seasoned regulatory and compliance counsel with over 12 years of international experience spanning digital law, GDPR, and public-private legal strategy. He has served in key legal roles at TikTok, Hermes, and Upfrance, where he led high-stakes contract negotiations, implemented GDPR frameworks, and advised on digital risk governance. A certified data protection officer and university lecturer, Mr. Bolivar currently teaches M&A and digital business at EAFIT University, integrating cutting-edge topics such as AI regulation and fintech law. His multilingual expertise and cross-sectoral insights have also shaped public policy initiatives in Colombia, including sustainable tourism and digital transformation strategies. We are honored to welcome Mr. Juan to share his perspectives on ADR and regulatory landscape in Colombia and to enrich today's discussions with his global legal acumen. Now I hand over the stage to you, sir.
With the due permission from the organizers, before Juan is going to start his wonderful presentation, here Juan is given a compliment, particularly from that particular jurisdiction where you have a privilege for additional 10 more minutes you can just expand the knowledge about the core, that's the soul of Latin America, where Colombia is positioned, and how the stakeholders, particularly when it comes to the promotions of alternative dispute resolution in the jurisdiction, not only focused in Colombia, the vast the geographical boundaries beyond Colombia in the Latin American region. Welcome, Juan, and we are very happy on behalf of KFCRI to have you, because your partnership, which has been facilitated in dual aspect, in person as well as your meddling, and we are very happy along with the university wherein you are promoting this concept within these students. Welcome, Juan.
Thank you so much, sir. Thank you for the presentation. Can you hear me well?
Yes, sir.
Okay, thank you so much. I think we can, I can expand some things about international arbitration, Colombia, and LATAM perspective about this international field. Maybe we can wait a little 8 minutes until it's 9 a.m. here, because people are aware about the schedule from 9 to 9:25. But I'm honored really to join this global forum that brings together international arbitration leaders, scholars, and practitioners across the globe. As you said and you mentioned, thank you for the presentation. My name is Juan Camilo Bolivar, and I will speak today as a legal scholar, as an international legal advisor. I am a former contract manager for TikTok in Europe, mainly in France and Benelux region, Belgium, Luxembourg, and Netherlands. I work at TikTok for 3 years at the beginning of the rise of technology, of TikTok technology in the world during the pandemic. And currently, I am serving as professor of digital business and M&A at the University of EAFIT in Medellin. As well, I'm advising public institutions, public-private institutions on public-private strategy. So if we are ready to start, I can share my presentation and let me know.
Yes, Juan. But anyway, before going into your presentation on the perspective, most of us want to know about LATAM, what is actually identified or addressed to be?
Yes. Latin is a very particular subcontinent. Yes. Across Latin America, we have huge countries such as Brazil, Chile, Colombia, Mexico, and Peru. In terms of comparative institutional landscape in Latin America, we can say that we have a very developed and modern arbitration law. We are inspired on the UNCITRAL model and the best practices of European law, such as France and UK. However, the enforcement, what I see in my practice is that the enforcement remains uneven. It's not like in Europe or other jurisdictions that enforcement with the international convention we have today, it's still easy. Here in Colombia, at least, and is a major problem for Latin America, is that the enforcement can cause several problems of perception of the judge. So while Colombia has a clear jurisprudence on public policy, we can say, we have some exceptions. What we call orden public or public order here, it's subject of interpretation. And this subject of interpretation, it comes very broad, undermining enforcement of foreign awards. So Colombia really stands out for its clarity about enforcement and the respect of international conventions and the hosting of foreign awards, because we have a strong institutional support of the Court of Justice, and we have centers, chambers of commerce that are really doing their job. I'm talking about the Chamber of Commerce Bogota and the Chamber of Commerce of Medellin, the two main cities in Colombia. So actually, they offer digital filing and virtual hearings. What is a trend that we can see since COVID-19 pandemic? And this is the subject that I'm going to talk to you about today, the intersection between tech, arbitration, ADR, and LATAM.
Oh, so nice, Juan. But as a individual, having an aspiration to travel across the globe, when I started into international arbitration, I had that aspiration. Then I took arbitration as a tool to travel across the globe. And after the pandemic, that has been cut shorted, that virtual is the only option. Having said that, any interesting fact about Colombia as a country, looking into its history? Anyway, your presentation, you can just very well start in a couple of minutes. But as an aspirant to travel, there are multiple destinations each and everyone would have. Particularly from my region, everyone would be interested to go to the Spanish part of the Americas. That's what we see the South American countries, except Brazil. What is your say on the country as such, Colombia? And a very interesting thing about Colombia for all of us to be prepared to go to that destination.
That's a very tricky question, sir. Actually, in Medellin, I'm working in tourism, which is a field that is rising in Colombia. Colombia today is, by excellence, the best destination for tourism in Latin America. We, as you know, we got like a social transformation since a couple of decades already. 30 years have passed since we got this transformation in Colombia, and we are hosting by the way, a lot of international events at the Greater Convention and Visitor Bureau, where I am an ally today. Our mission for the international world is for people to get in love or to fall in love with Medellin and Colombia, because we have a lot of things to offer in terms of biodiversity. We are the most biodiverse country in the world. So what are the main advice and tips? Just come with your best attitude, because Colombian people are very warm, and you will be very, very welcome here. In Colombia and Latin America, we have this particularity. So you are very welcome when you want to come to Medellin. Even we can host this kind of international events for arbitrators and legal practitioners here in Medellin. We have all the infrastructure, and from the public sector, we can get a little bit of help through the Greater Convention and Visitor Bureau that attracts international events to the city, for instance.
Okay, sure. Then we will be there before the second edition of GSADR of the day. Thank you. Now you can start your presentation, and we are awaiting the insight what you are going to share about your jurisdiction in the Global South.
Thank you, sir. Just 1 second. So you can see my screen?
Yes, sir.
Great.
Sir, I think you're on mute.
Sorry. So thank you so much for inviting me to this international congress. I'm very honored to be here to talk about Latin America, Colombia, as rising contributors to global arbitration in the age of artificial intelligence, AI. I'm representing Colombia to talk about the legal structure of arbitration in Colombia, but I salute and I thank the Greater Medellin Conventions and Visitor Bureau and the University of EAFIT to be knowledge partners of this event in Colombia. And thank you, you all in India, the Kovise Foundation Conflict Resolution International, and thank you to all the organizing committee for making this possible. We are in a 24-hour virtual event that brings together arbitration leaders, scholars, legal experts, practitioners from across the Global South. And we are very happy in Colombia here that we are fostering South cooperation. So, as I said previously, my name is Juan Camilo Bolivar. And I will speak today as a legal scholar. I have an experience over 15 years working at TikTok, for instance, as a contract manager during 3 years during pandemic. I'm also a former legal advisor at Hermes Paris, where I used to work for international subsidiaries and advising on contract negotiation, legal structures, M&A, and plus arbitration clauses design. I also work at Willis Towers Watson insurance sector in Paris. And the topic today is very related with what I like to do, which is data. I'm a data protection officer with a certification under GDPR. My passion about international business law comes from the University of Versailles in France, where I study my master's. So the topic today of what I'm going to talk about is both timely and complex, because I want to go on the intersection between tech-driven arbitration in Colombia and Latin America. So we are going to see the legal structure, the evolution, and AI and integration today in Latin America arbitration. We will explore as well the evolution of arbitration in Colombia, in contrast with international trends and comparative law here in Latin America. And at the end, we will dive into the legal and ethical implications of international arbitration, artificial intelligence in dispute resolution. I will give you a mini business case about my practice at TikTok, designing transnational clause on the international contracts of the business product data terms of these tech giants and how it works. Because more than a theory, what I'm interested in is to apply this practical side of myself to real problems in Colombia and in Latin America. So, Colombia has the arbitration in Colombia is legally grounded in the Constitution, in the Article 116 of the Constitution of 1991. That's our latest version of Constitution, which allows private individuals to temporarily exercise judicial functions. This constitutional endorsement was reinforced with the enactment of Law 1563 of 2012. So let's say that since 2012, Colombia has a modern infrastructure that talks about international arbitration and domestic arbitration. This is one of the first LATAM legislations that goes into that way. We have to remind, maybe there are other speakers talking about Brazil, but we have to remind that there are other jurisdictions that make no difference between international and domestic arbitration in Latin America, but Colombia does. So they give us a national and international arbitration statute. This statute is a modern Colombia arbitration law and was adopted just taking into account the international principles of United Nations model law, UNCITRAL. So when we're going to talk about this law, this very recent law since 2012, Law 1563, we can say and emphasizes that there are three core principles. The first of all is voluntariness, voluntariedad in Spanish. What is voluntary? Willing. We also have this second principle about temporariness, which are principles of international arbitration law. And the competence. Remember these principles, competence, which is an international principle of international arbitration. And in Colombia, we define and we take these international principles of the United Nations and we applied it in private arbitration or commercial arbitration. This presentation will also be driven towards commercial arbitration. I think that if we can talk about investment law arbitration, we will have to have another presentation. So this is the focus of this presentation. So when the law came into effect in 2012, legal scholars and international arbitrators in Colombia were very excited because Colombia was going from the dark to the light in terms of international arbitration, because we understood that defining, for instance, ad hoc and institutional arbitration that will be enabling foreign and domestic awards to be enforced under these standardized procedures. So Colombia has a very good relationship with international law, and we see it under the New York Convention. Before we get into the relationship of Colombia and New York and the other international conventions, I will just say, to close the domestic arbitration law, to say that there are some key aspects that Colombia is very different from the rest of countries here in Latin America. These aspects, I would say that Colombia treats international arbitration distinct from domestic arbitration. That makes a huge difference. There are some other countries, such as Brazil, they don't. So they have problems to enforcement foreign awards. This gives us flexibility. For instance, flexibility in terms of governing law, flexibility in terms of institutional rules. As I previously mentioned, we have two main international arbitration centers in Colombia that are the Chamber of Commerce of Medellin and the Chamber of Commerce of Bogota. Both of them, they have the ADR and arbitration center. So in Colombia, we have this institutional power that give us the way to be connected with the international principles of arbitration. So Colombia ratified in 1979 and reapproved in 1990 the International New York Convention. For those who are not aware about this international convention, this gives us the possibility to enforce foreign awards in our territory, even if they were not issued here, for instance. There was a very complex constitutional journey to ratify this New York Convention. It had been signed in 1979, but the implementing law was stuck down in 1988. And only after legislative revisions and discussions in the parliament, that was approved. This delay highlights the tension between domestic constitutionalism and international commitments here in Colombia. It's an issue that I would say that is still affecting Latin American jurisdiction. Since 2011, Colombia's Supreme Court has embraced a pro-arbitration posture, applying international standards, very robust, very consistent. We got this evolution since the Supreme Court was aligned with the international arbitration principles. So we can say that Colombia is a member of the ICSID, the CIADI in Spanish, and has been party to multiple investment arbitrations under bilateral investment treaties. Yes, this is an international engagement position that Colombia has, and it's very natural for Colombia to be a hub of international arbitration in the region. So we're moving from one of the most important and strongest contributions of development of hybrid legal doctrine. We can say that some scholars such as Silva, Bustamante, they are revealing that although arbitral awards are not formally binding here in the country, they are increasingly being used as a persuasive precedent in high-stakes sectors, such as infrastructure and energy. These two main sectors in Colombia that are fostering and driving economy. In fact, Colombia is developing a soft jurisprudence framework where consistency and coherence are achieving through citation practice and institutional memory. So, how is the panorama of Latin America? We see countries like Brazil, Chile, Peru, that have also developed modern arbitration law based on the same UNCITRAL model. However, how I said, enforcement remains uneven. While Colombia shall be a legal platform for European and US businesses. Why? Because Colombia has clear jurisprudence on public policy exceptions, for instance. Other jurisdictions often interpret orden public order too broadly, undermining enforcement, as you know, of foreign awards. Colombia stands out because of its clarity. Yes, because we have a strong institutional support from the centers of the chambers of commerce. And now we are using technology to offer digital filing, virtual hearings, as well in the war. But I deeply think that in our countries, in the South hemisphere of this war, we have to use technology to fill the gap of development. And the gap of development also relies on international arbitration practices. So Colombia and the region have a huge opportunity to use the new technologies and the new trends on technologies. Legal techs and the rising of legal techs here in LATAM is a very important point of that. So when Colombia state the 2012 Colombian Arbitration Statute, we saw a rise of international arbitrations in the country. Cities such as Bogota and Medellin were hosting more arbitrations. We recognize party autonomy and the principle of competence, and we attended to an enforcement of foreign affairs broadly. I think I have a couple of minutes. So I would love to share with you a TikTok case, because during my tenure at TikTok, I negotiated contracts where arbitration clauses were embedded into the platform commercial architecture. In that arbitration, we say privacy by design. In this case, arbitration by design. So these agreements of the tech companies talking about the tech sector because in Latin America, we are hosting and attending a rise of technologies, fintech technologies, legal technologies. So when these giants of technology come to our region, we can see that these agreements are often mandated by ICC arbitration, Paris arbitration, not Paris itself, but for those who have the opportunity to go to the International Chamber of Commerce, we can say that it's a place where commerce and trade and business are secure. So tech giants like this, they use ICC arbitration, either in Paris or in London, with English law and governing law. Crucially, when talking about these clauses, this contract included data governance clauses tied to controller data regimes, ISO 27001 and ACC's standard commercial clauses were linked to these arbitration clauses. It was a model in which we have a 250K liability cap. We had to negotiate with Christian Dior, Air France, and all these big French and European giants, the arbitration clauses, because partners, they were not sure about the election and the choice of the forum. So my main point is arbitration is being integrated into digital ecosystem from the start. And that's a lesson that we have to learn here in Latin America and in the South. Because this model offers a valuable blueprint for Latin America. For instance, platforms based in Bogota, Sao Paulo, Buenos Aires are starting to consider similar clauses. When we talk about governing law in data protection, for instance, we're talking about GDPR and CCPA, California. So what's the lesson that we have from in AI, for instance, to talk about regulatory and an ethical roadmap of arbitration? To govern AI in arbitration, we must look to emerging global frameworks. For instance, the European Union's AI Act entered into force last year, 2024, is the most comprehensive example. We, as a region, we have to go in that way because we have to impose transparency, explainability, and oversight obligations. In arbitration, the Silicon Valley Arbitration and Mediation Center, for instance, and the Stockholm Chamber of Commerce have published practical guidelines in that way. In Latin America, we have to adopt, and we are adopting AI. So Latin America must not lag behind. Colombia has the capacity to pioneer regional standards rooted in proportionality, fairness, and accountability. Colombia is not only complying with international arbitration standards, but is actively shaping them through technology. I think I have 1 more minute time. Yes. Okay. So my conclusion is our region has a lot of things to put in place in terms of international arbitration, ADR. We are a region that we are leveraging robust legal framework. Yes, we have doctrinal innovation. Yes, we have openness to technology. And we can position Colombia and Latin America more broadly in these international legal scenarios. We can be leaders in fair, efficient, and tech-augmented dispute resolution. So thank you, everyone, for your attention, and thank you to the Kovise Foundation Conflict Resolution for inviting me for this little talk about my region. And I will look forward to continue this dialogue and this conversation with you all, if you desire. Thank you so much.
Sir, we have a question in the chat box
Yes.
from Mukesh, which is as follows. With Colombia's rise in international arbitration, how do you see the impact of regional institutions in shaping the country's arbitration landscape?
That's a very good question, because institutional arbitration in the region is what we have the most accomplished. As I previously mentioned, in Colombia, for instance, we have the Chamber of Commerce of Medellin and the Chamber of Commerce of Bogota, which are the two main cities in Colombia that are fostering ADR, that are fostering arbitration, and that are fostering the inclusion of technology into the international arbitration or domestic arbitration proceedings. So we are aware of international changes. We have an opportunity here in Latin America, because we have a lot of relationship with the United States and Europe, and we can be a hub and host these international disputes here, because we have the legal framework as the law of 2012. We have a doctrine innovation and legal innovation that is crucial for international arbitration. And we are into that path of fostering and improving institutional arbitration. I would say that public sector and public-private alliances and strategies are effective here in Latin America, at least in Colombia, to foster arbitration, mediation, negotiation, because we understood that using ADR and arbitration would mitigate the impacts of the burden state of legislative and judicial decisions. We in Latin America, as you know, we have a huge problem of bureaucracy. And bureaucracy means time. And we know that arbitration is time. Arbitration most important benefits is time. And that's what we have to get back from the international or domestic arbitration centers in Latin America. Time.
Thank you, Juan, for the insightful perspective of arbitration in Colombia as well as LATAM, and particularly your past experience as in-house counsel. That's very, very interesting. We will take this quite seriously, and we will, as a part of Global South, the partnership and the Medellin Bureau, all get together along with the universities we can, and we will explore, and whatever the objectives, the 4 objectives of this GSADRT or D would be done. And with your support from that region, really it will happen. Thank you, Juan. And
thank you so much.
now I request, thank you. Now I request my colleague to introduce the next speaker, a judge from the Brazilian jurisdiction.
Yeah, it is an absolute honor to welcome Judge Andrea Galhardo Palma, a distinguished civil judge currently serving at the Sao Paulo State Court, where she presides over the Second Regional Corporate Insolvency and Arbitration Court, covering 29 industrial cities. With over 2 decades of judicial experience, Judge Andrea has overseen thousands of cases involving contracts, torts, corporate law, construction, and public contracts, and has played a pivotal role in arbitration and insolvency proceedings in Brazil. Judge Andrea holds advanced legal qualifications from the University of Sao Paulo, the University of Pennsylvania, Columbia University, and is also currently pursuing a PhD in business law at the University of Lisbon. She is a fellow of Chartered Institute of Arbitrators and an active member of several international legal and arbitration bodies. We invite Judge Andrea to share her valuable insights in the ADR landscape in Brazil and to contribute to today's discussion. The floor is now yours, ma'am. Ma'am, I think you're on mute, ma'am. Judge, I think you're on mute. Kindly unmute.
Oh, sorry. Okay, again. Good morning, everyone. It's a pleasure being here. I think this is an amazing event. I would like to say, first of all, thank you to the Inbavijayan. I don't know if I spelled your name correctly. And Vajavan could organize us around the world and to stay together. And because we are fellow from CIR, it was a little bit easy to find us. So, and I'm so glad to be here. I will share a little bit thoughts about Brazilian overview of framework regarding arbitration. But let's say a little bit more about my position here, because I'm not arbitrator and not lawyer, but I'm a judge and at a specialized court in São Paulo, and we deal with challenges regarding arbitration. And also, we are court of the assistant in arbitration proceedings for example, seizures or to notice or force testimony or for hearings and so on. We are, or for enforcement also, we can cooperate with the arbitral tribunal during the arbitral proceedings, and also after arbitral award, we can serve as a court of the enforcement and also for challenges regarding annulment and so on. So I will address a little bit how, for example, São Paulo structured this specialized court. But I want to say first that Brazil is, like Colombia, is a civil law country. And we have a one constitution, federal constitution for all states, one federal civil law procedure for all states, and also civil and criminal code, and also arbitration federal act for all states. So it's a little bit easy organize judgments for judiciary and for lawyers understand how the judiciary works, and also it's a little bit easy to harmonize our judgments and precedents and so on. Regarding precedents, these come from the federal superior court, and we called Supremo Tribunal Federal, and also in federal level that discuss issues regarding federal law, we have Superior Court of the Justice, and also the tribunals around the states, and like São Paulo, that is a second ground of or appellate courts for the state of São Paulo. I'm a member of the first level yet, but the final stage in the specialized court, and after me, we have the São Paulo, the Tribunal of the São Paulo Appellate Court. So that's this framework. And I will address a little bit more during my presentation, but I want to say that nowadays, Brazil is the second country that has the number of the arbitration. First one, United States, and the second one, Brazil. This is a good thing for us. It means that Brazil has been increased arbitration because not only the arbitration federal act is good, but it's because the judicial courts can enforce arbitration in Brazil. So we are a friendly court for arbitration. It's not for coincidence that ICC create in few years ago a department in Brazil, in São Paulo. They have an office in São Paulo, and we have many chambers of the arbitration chambers for domestic international arbitration, not only in São Paulo, but around the state, but mostly São Paulo, Rio, and I want to say Kansas CBC, Fiesp, and another small chambers, and also chambers that deal with insolvency and arbitration we have. And it's nowadays is a very important place for arbitration. But we have some problems. I will address this a little bit. But first of all, my agenda here in this event for you is give you an overview about arbitration framework and how Brazilian law treat public and private entity participation in arbitration, some key trends and developments that we have nowadays, and how the role of the judiciary regarding arbitration, and how many cases we can enforce or deny or annul in Brazil, especially in São Paulo, which is rare, but some cases had a strong, let's say, commotion because it was big cases, and so, but it was important that because courts only intervene in that situation that is a big problem or gross violation of the due process of law or the duty of the disclosure and the duty of impartiality, independence, and only in a rare case. So in addition, I will address some current challenge and critical issues regarding arbitration. So I think I can pass this. If I have any problem regarding my PPT, I will ask some help from the Shakti prior. I want to say thank you, Shakti, for your support in this organization, let's say.
Sure, ma'am, sure.
Okay, let me share this screen because let's see. I'm not fine this for sharing. If you can share for me. I don't know if you have this.
Just a minute, ma'am.
Because I'm not.
We are sharing from our side, ma'am. The screen is being shared now.
Yes, because okay. Let's go on to the overview, please. I think it's the third chart. Because they are
Currently, the
not.
slide is on the overview of Brazil arbitration, Judge.
Okay. Hmm. And, it's not working from my computer, sorry.
Sorry to interrupt in between, ma'am. Is it not working for you, ma'am?
No, it's not working.
Is your presentation not visible on the screen for you, ma'am?
It's not it's appearing, but I don't know how can I pass for you.
Ma'am, the thing is like the control of the presentation is with us. As and when you need to change the slide, you just intimate us in order to change the slide and we'll change it.
Okay,
Yeah,
but can you go on to the overview of arbitration framework? It's a little bit.
It's that slide itself, ma'am, that is present, if I'm not wrong.
Sorry?
Ma'am, it is the same slide, the overview of Brazilian arbitration framework, which is
Okay.
Yeah, ma'am.
So nowadays, since the Arbitration Act in 2096, and our Supreme Court has decided in 2001 that this law was constitutional. And after that, this law, which is based on, in ancestral principles, but not only ancestral, but also French law and also Spanish law. And after that, the institutional arbitration has increased in Brazil. And after 2001, in 2002, Brazilian has adopted the New York Convention also, and so, which was important for recognition of the International Arbitral Award. Today, and since 2002, this role is to recognize the International Arbitration Award is competence of the Superior Tribunal of the Justice in a federal law, which is a proceeding that is not take so much. And I cannot, for example, decide about the recognition of the International Arbitration Award. Only this federal level in a superior court has the power to decide about it. And regarding the organization of the after recognition in 2015, Superior Federal Court of the Justice recognized also the principle of the competence, which means that the arbitral tribunal has the first competence to decide, first prima facie, the competence to decide his own competence, and also the validity and the effectiveness of the arbitration agreement. And after that, the courts in all levels and all states has been using this principle, for example, to deny lawsuits or challenges at the first place without going to arbitration. So it's very important. Which Brazilian Arbitration Act decides that court has the narrow intervention to the arbitration proceedings. We can cooperate mostly, and also we principle in the first place, for example, for emergent measures or urgent measures before the constitution of the arbitral tribunal, and during the proceeding as a court assistance for seizure or to decide about the collect assets or to stay contracts or without intervene on the merits, just for urgent measures. And now in São Paulo, for example, we can give urgent measures to anticipate evidence only in a narrow situations that, for example, the position of the witness has any problem regarding issue or personal issue, or, for example, the own health or the risk of the lose this evidence, and has to be crucial or to justify that the court can anticipate the decision from the arbitral tribunal. It's rare also, but for example, sometimes the risk of the lose this evidence justify anticipate the evidence, but we can confront this evidence during the arbitral proceedings. That is our framework. Another narrow provision that the Brazilian arbitration law has is the annulment. We have a few grounds of the annulment, but for me it's a huge ground, because it's 8 grounds of the annulment. We can annul if the part violated the due process of law, or the tribunal violated due process of law, and the tribunal has lack of the independence or impartiality, or break the rule of the duty of the disclosure, and the arbitral exceed the power regarding the arbitral convention, and also when the tribunal is corrupt or any criminal situation during the arbitral proceedings, and also when the arbitral, because it's not from the law, but it's a precedent, when the tribunal exceed the power and decide against the public policy in Brazil, in a substantial situation, or in an evidence, let's say, decide issue that is not arbitrable according our legal framework. So regarding the trends nowadays, is very interesting, because Brazilian has, after 2015, Brazilian law has amended and allow arbitration in a public sector. I don't know if you know well, but Brazil is a big market for oil, gas, infrastructure, and energy. And this kind of contracts normally comes from the public sector, government, and regarding contracts of like PP contracts or concession. And nowadays, in a federal level and also state level, government, public entities can make a contract with the arbitral clause, and this kind of the contract and the proceeding is very interesting because is the way that confidentiality has a little bit flexibility because of the public interest in that contract. And also some arbitral institutions have been rules regarding the arbitration in a public sector also is very interesting. They're using also, for example, construction and other tools in that contract that dispute boards before arbitration in a contract. Some states that use contracts with the arbitral clause in the public sector also put in a clause of dispute boards for this kind of the contracts, and mostly because the investor before giving money ask for this kind of the clause in a contract. So another interesting trends that have been occurring in Brazil is that our law nowadays allows that interface harmonically between insolvency proceedings and also arbitration. We adopted in insolvency law the ancestral model law on cross-border insolvency. And this law says that if the parties in arbitration proceedings goes to the insolvency, arbitration proceedings can continue. We don't stay arbitration proceedings, and also we don't interfere in a validity and the effectiveness of the arbitral clause, which is very important for parties and also for business in Brazil. But our law, insolvency law, said that we don't interfere. Arbitration and insolvency can continue. But if the subject matter of the arbitration is payment, compensation, or has a huge impact of the assets of the insolvent party, that can be a risk if the arbitration can continue, because always issue regarding payment, compensation, transaction that has impact in arbitration in a insolvency process, the court of the insolvency has the power to decide. So, an example, if the part discuss compensation and wants to make a payment during the arbitral proceeding or discuss this issue regarding the essentiality of this payment, and the arbitral tribunal does not stay the proceedings, this arbitral award can be annulled by judicial court, the court of the insolvents, because the court of the insolvents, after the insolvency proceedings or after the initiate the insolvency proceeding, say that only courts can decide about payment. All assets, all rights regarding payment, and organize this payment regarding not only one creditor, but regarding all creditors to protect them. There is a principle that in insolvency law that say equal treatment regarding all creditors. That's why if the subject matter in arbitration is a new credit or payment that's new credit in advance, this payment in advance is not is prohibited, and the tribunal, arbitral tribunal, it's not allowed to make this happen. I don't know if I'm clear about that, because this issue is complex, especially for studies, not for students, not for practitioners. But nowadays, court has been decided that arbitral tribunal has to be or has to take this in account for decide if the arbitration can continue or not. So regarding the judicial support and enforcement, there's some issues in Brazil that is a complication regarding this, because going to the court is a little bit cheaper in Brazil. And what is happening now is that most after arbitral award, most part of the parties don't pay or don't comply voluntarily the arbitral award. And so they use the courts, judicial courts, for enforcement, which is not good for us because we are overwhelmed. All states, all judges, but they use this as a strategy to avoid paying in payment and gain time to use this in a future as a strategy. And also they use the challenges as a strategy to avoid payment in advance. So this is our vision that is not and critical point that we can discuss, we have been discussing in our court and also with the arbitral community, because lawyers goes to the court in a frivolous ways to avoid payment after arbitral award or to comply with the arbitral award voluntarily. They use courts to gain time. And so this is a critical point. Another critical point that we nowadays is facing, that our arbitration federal act in Brazil has the same clause that say that the arbitral tribunal or the arbitrator has the duty to disclose the relevant fact that can jeopardize your independence and the impartiality, and also jeopardize the arbitral war. And because this article in our law, Article 14, is so broad, without any specification which kind of the the fact should arbitrator review, or make this clear. And also most arbitral institutions don't have this checklist as IBA guideline has, and sometimes this is a big issue, and some lawsuits come to us to decide if the arbitrator violate duty of disclosure or not. And some institution now has some checklists regarding some questions that arbitration should to answer if they have any problem with, for example, another the lawyer of the parties, and they if they have the kind of relationship they have, and so on. But I think, for my personal view and also the court view, that they have the power of the arbitral community and also arbitral institution to make this clear, has a checklist of the objective arbitrability, also objective facts that they can disclose, and like IBA guidelines. But the Brazilian Arbitration Committee is a organization, also creates some considerations that arbitrators can use for as a guide for disclosure, but it's not it's only a recommendation. It's not something that can oblige arbitrations to follow. So I think also some current challenges, regarding current challenges and critical issues, because these flaws in our legislation and the use of the judicial court as an instance to enforce the arbitration or to decide about annulment, arbitral community sometimes say that there is a big judicial activism in specific cases and regarding arbitral proceedings or arbitral cases. So sometimes this happens, I think, but it's rare. And some case has a big impact in arbitral community, but especially in São Paulo, the number of the annulment is irrelevant. They use judicial court to go to ask for annulment, but in 99% of the case, let's say, we deny these lawsuits, so these challenges. So, but some cases that are gross violation of the duty of the disclosure, or also the violation of the arbitration agreement, we decide in a rigorous way, and there is a big impact in our community. The last critical judgment was that in insolvency issues, that Superior Court of the Justice decide that compensation, it's compensation during the arbitral proceedings is prohibited if the part is insolvent. You can discuss the new credit, the new right of the indemnification or new damages, but you cannot make this payment or you cannot effective this decision if the party is insolvent. This power is the judicial court of the insolvency, because the public order and the mandatory law of the insolvency in Brazil. I think that I address the most important framework in Brazil. I don't know if you have any questions regarding that, but what I can say that according to Professora Selma Lemes, one of the drafters of our law, Brazil is the second place in the number of the arbitrations. So I think we is because we as a judge and courts, we enforce arbitral award a lot. And the annulment and the enforcement is also a power of the judicial court, unfortunately. But we dream that arbitrator parties in arbitration can respect the arbitral award and comply with voluntarily, but it's not happening nowadays. So I think I give you, I don't know if in a clear way. Sorry, because sometimes my English is a little bit rough because I don't have been using a lot as a professional, and sometimes to change the links is a little bit difficult today. But let me know if you have any questions, and I hope I can stay with you another time discussing about arbitration and also the perspective around the world. If you need anything from the judge from Brazil, let me know, and I will glad to serve you and to give our overview regarding arbitration and also the court assistance in arbitration proceedings. Thank you all.
Thank you, Judge Andrea, for the bird's eye view, what I can see from a judge having a pro-arbitration approach. And we are very happy on behalf of KFCRI. We are indebted to you for this wonderful presentation and acceptance, first of all. And anyway, because of proximity of time, we have to just move on to the next speaker. Any queries, we will share to you so that you can leisurely get back through emails and we can convey to the audience. Thank you, Judge Andrea, for facilitating. Thank you.
Have a nice day.
Thank you. Thank you.
For the next speaker of the day, we have Professor Jose Miguel. We are delighted to welcome you, Professor. He is also a distinguished lawyer and lecturer in the field of dispute resolution with deep expertise in ADR. He holds dual LLM degrees in investment treaty arbitration and international commercial arbitration law from prestigious Swedish universities. His academic work explores the intersection of psychology and law, particularly in the context of arbitration and enforcement mechanisms. Professor Jose currently serves as the head of thesis production unit at University of San Martin of Porres and is the president of Arbitration Council at Lima Region's Chamber of Commerce. We invite you, Professor, to enrich today's session with insights on current scenarios of ADR in Peru. The stage is now yours.
Thank you so much. Thank you so much to everyone. As I'd like to take a couple minutes at the beginning to thank the organizing and production teams behind this impressive event that gathers so many of us and allows us to share our national view on the perspective on ADR. I particularly find it very interesting that we're having this 24-hour event like the week right before Shavuot, which is a holiday in which we study the law for 24 hours in celebration of receiving the Torah from God. So that's a very peculiar coincidence. I'm so glad I get to be a part of this. I also like to thank my fellow speakers for taking the time to illustrate us on their national approach. For what undeniably is a private effort to preserve peace within the confines of our respective jurisdictions. I believe ADR arbitration, of course, but ADR in general is an effort to promote peace and resolution that keeps us further and further away from violence, which, in the context of Latin America, it's an effort, a daily effort where that we're pushing. So as far away as from violence as we can be. So having said that, thank you so much once again for letting me speak today about these issues. Now, I was asked to talk about the existing arbitration legislation in Peru, but approaching just the Arbitration Act of 2008 wouldn't do justice to the sui generis system that we have here in Peru. You'll see. The Peruvian Arbitration Act of 2008 follows very closely the 2006 ancestral model law, with some Lima-centric texture. For example, international arbitration that has its seat in Peru needs to go through Lima courts, even if arbitration, the seat of the arbitration is in a different province. So that's pretty Lima-centric. That's a characteristic of our law that reflects, of course, most of our national discourse on the centralization. It's an issue, and we have to work on it. But it's something that if you want to practice arbitration in Peru, you have to be aware about. So international procedures must seek judicial collaboration, like injunctive relief, enforcement, or annulment of arbitral awards. Of arbitral awards through the Lima courts. Also, residual appointments, like the residual appointments or challenges, are addressed not by the local judge or the local courts, but by the local chamber of commerce. That's a very idiosyncratic um, rule here in Peru. It's based on this idea and this lack of trust and lack of confidence on judicial decisions. Like at the heart of the discussion when making this rule was this idea that judges in Peru are not very trusted, and and uh, uh, and parties are usually very suspicious of judicial decisions. Therefore, appointments or challenges are addressed, as I said, by local chamber of commerce or the institutions they create explicitly for that issue. I'm going to talk a little bit more about Chamber of Commerce is in a little bit. But as I was saying, they are in charge of making the decisions regarding appointments or challenges when there is in a residual matter, right? When there is no agreement by the parties. Curiously, the Arbitration Act has the 2008 Arbitration Act has been reformed only 3 times in its almost 20 years. First time to regulate the state participation. It was in 2015, so it's 7 years after the original issuing of the law. After that, it was there was this modification to the law, to the act, to change the requirements for registration of interim measures due to anti-corruption legislation. So Peru and the US entered into investment agreement, and this investment agreement had some requirements regarding anti-corruption, which led to legislation with to anti-corruption legislation, and therefore modify the requirements for the registration of interim measures. It was not a particularly popular decision, but also not very written much about. There wasn't much written about it, because it is sort of a niche issue, right? Arbitration, although it's very important in Peru, the registration of interim measures in arbitration is absolutely a niche issue. So, although there were some commentary in, as I said, niche platforms, it wasn't really made a big deal of. But in 2020, the legislation, not legislation, I'm sorry, at the initiative of the executive, there was a new modification that established a 10% mandatory fee to interim measures issued in arbitration procedures where the state was a party. This means that whenever you enter into an arbitration procedure with a state, be it a municipality, regional government, or national government, even public-private associations, you would need to put down 10% of the total amount of the contract, just to be able to get interim measures issued by the tribunal, the arbitral tribunal. This is a requirement that the state does not have to follow with, because, of course, the state has this privilege of not being required not having these requirements for any interim measures, not in arbitration, but not in litigation either. So there is, in fact, quite different. And this decision actually did make a fuss, but it was 2020, COVID was all around us, and it was a little bit complicated to follow through with it. I know we have limited time, so I'm gonna push through a little some of the points that I was gonna make. I was going to say that what I just told you is only the first part of the story, because the other and more important part is the fact that since the 90s, a lot of Peruvian legislation has tried to promote alternative dispute resolution. In 2009, we have the Mediation Act that makes it a requirement to start any commercial litigation in front of a judge, makes it a requirement to first go to mediation. And you need to have a lack of agreement document signed by the mediator in order to be able to start litigation. So from 2009, it's mandatory to go first to mediation and then we can proceed with litigation. And also, of course, since 1991, every public procurement act has referred every dispute related to public procurements contracts to arbitration. Most recently, they also included dispute boards as a means of dispute resolution. Thus, Peru has a great number of lawyers specialized and familiarized with mediation and arbitration through sheer necessity, because it is mandatory in both of these cases to be familiarized with mediation, arbitration, and now dispute board proceedings. Procurement-related conflicts are so relevant to arbitration that almost 3 out of every 4 arbitrations in Peru are related to procurement contracts. I think the precise number is 72%. So 72% of arbitrations in Peru are arbitrations with the state. I mean, either against municipalities, regional governments, national governments, or private-public associations. So we have a big chunk of the arbitral practice here closely related with administrative law, procurement law, and therefore arbitrators need to pass a certification by the procurement authority here named OSCE, OSCE. Well, recently changed its name, and arbitral institutions as well. So arbitral institutions, to be able to manage procurement-related arbitration, need to pass evaluation by the procurement authority, with the exception of the arbitral institutions sponsored by local chamber of commerce or universities. And there I have to reveal my bias that was mentioned at the beginning of the speech, where I myself, I'm a member of the council for the Lima Region Chamber of Commerce, and also I'm a registered arbitrator for the University of San Martin de Porres Arbitral Institution, Center for the Investigation, Research, and Solution of Disputes, as it were. This gives a great deal of autonomy to Chamber of Commerce and university-based centers, and restricts the participation of privately and tailor-made institutions. As I mentioned, the Arbitration Act has a lot of Lima flavoring. Thus, the Lima Chamber of Commerce has greatly benefited from judicial decisions that refer arbitration to them, as opposed to other arbitral institutions, in a manner very similar to what my dear colleague Jade Lauer, who talked several hours before me due to time zone difference, in a manner similar to the Coraline decision in Sweden. If you're not familiarized with it, it's a decision where the interpretation of an pathological arbitration clause was determined to be in favor of the Stockholm Chamber of Commerce Arbitration Center, due to the fact that it referred the arbitration to Sweden. In a similar manner, when there is a lack of clarity regarding where in Peru we need an arbitration, sometimes the judicial branch has defer to Lima Chamber of Commerce. In the instances where it gets there, because as I mentioned before, the Chamber of Commerce is the one in charge of deciding challenges, decisions, residual appointments, and even sometimes issues regarding competence. A final word regarding court rulings. We have very non-intrusive judiciary, but I'd like to talk about the Maria Julia precedent, which reversed expropriation made by the Ministry of Transportation after the Ministry of Transportation failed to pay the compensation established by an arbitral tribunal that was called specifically to determine how much should be paid to this mining corporation, Maria Julia. So we don't, although we have a very non-intrusive arbitral trade, although we have a very non-intrusive judiciary, they do take some decisions that are partial to arbitration and enshrine these decisions made there. So much so that the arbitral tribunals are allowed to decide on issues of reversing expropriation, which in Peru is an exclusively legislative power, national legislative power. So that, I think, paints a pretty clear image of the non-intervention of the judiciary. As I mentioned in the beginning, don't want to overtake the. I don't want to take over. I'm sorry. The time allotted to my fellow speakers. Once again, just want to say a couple words because I was asked to regarding the future of arbitration in Peru. I see a bright future for arbitration in Peru. I understand that we all see our field of practice as a promising one, but Peru in particular, and this procurement law that refers everything to arbitration, opens a big door for the practice of arbitration and the trial by fire, basically, of arbitration specialists. So I believe Peru is a particularly well-suited environment to sharpen your teeth in matters of arbitration and dispute resolution. I hope that makes us valuable assets when determining who you introduce or who you select to be part of your teams in matters regarding dispute resolution in international environments. So once again, don't want to overtake. Just one last word, if I may. I want to take advantage of the platform to remind everyone to keep in mind the horrible tragedy happening in Palestine. And of course, since we are in a global south forum, just try to keep in mind the several struggles of many peoples for their liberation. So, having said that, thank you so much once again for letting me partake in this event. And thank you so much to all the other speakers for sharing their knowledge. I myself just talked from, usually give this kind of speech from my lectern in class, and this is an amazing opportunity to share with the whole world. Thank you. Thank you so very much.
Yeah. Thank you, Professor Joe Miguel. We are very thankful from KFCRI. Within a short notice, you have accepted. Even the day next to your Sabbath, you are kind enough to reach us. And Ms. Samina, the part of KFCRI who couldn't join right now, or has a high regard to you. And obviously, we could see the presentation now, what happened, the message, what has been conveyed, particularly about the jurisdiction Peru in the Global South. Professor, we are going to have a long-term relationship with your university and your jurisdiction, particularly the tasks ahead, the GSADR Alliance. We need a long-term support so that all stakeholders in Global South have to be real players, making the traditional seat to be, whether it's Peru or whether it's Brazil, whether it's going to be India or any Global South country. Thank you, Professor.
For the next speaker of the day, we are honored to welcome Ms. Tanya Godard, a distinguished attorney at law, independent arbitrator and mediator with 2 decades of experience in both contentious and non-contentious legal practice. She holds advanced legal qualifications from the University of West Indies and Usgoth Hall Law School, and is a fellow of Chartered Institute of Arbitrators as well as CEDR accredited mediator. Ms. Godard currently serves as the Secretary General of the Arbitration and Mediation Court of the Caribbean, where she leads efforts to promote international commercial dispute resolution across the region. She also chairs the Barbados chapter of CIAB and co-chairs the Caribbean Committee for the campaign of greener arbitration. We invite Ms. Tanya Godard to share her insights on ADR in Barbados and contribute to today's session. I now hand over the virtual stage to you, ma'am.
Hello, thank you very much for this kind opportunity. I'm just checking to see if I have a quick presentation. I was wondering if I'm able to share it. Let's see. Well, it doesn't matter. I can continue. Before I begin my presentation, first of all, greetings, good day, good afternoon, good night, wherever you are in the world. Before I make my comments, on the developments in arbitration in the English-speaking Caribbean, I just want to make 3 quick points. First, I am truly honored to be here. These are the events that remind us that arbitration is truly an international field to be in, and you never quite know when the opportunity would arise for you to participate in these types of esteemed events. Second, my other point which I wish to share is that, fun fact, if everyone doesn't know, the Speaker's chair in the House of Parliament in Barbados was donated by the government of India since 1966, when we became independent. And we recently had a visit from a group of esteemed politicians from India, and they took pictures of being by the chair. It's a beautiful wooden chair carved, and we've been using it since it was donated to us by the government of India. So these types of collaborations have been going for quite a long time. We may not consider it, but they have been, and it just shows how we do operate within a global context. And the third I want to say is to Inba. As an organizer of these types of events, I could not imagine the logistical feat that this is, of having persons from various time zones and coordinate them. So I truly tip my hat to you, sir, because this is quite the feat. Let me just say that. Just so I start, is it possible for me to share my screen? No, okay, that's fine. So let me start by talking about the various developments within the Caribbean, because what is very important for us to understand is that the English-speaking Caribbean is a complex melting point. And for those of you in jurisdictions where that's the case, I think they would be quite the understanding as to how that arises. Historically, we have a very mixed history with various groups being brought to the region. So we have our First Nations people, our indigenous persons, and then through colonial groups, we've had quite the mix. Now, having said that, oh, I think I've got it now. Oh, yes, great. I've got it. My apologies. Great. So having said that, we have to understand the English-speaking Caribbean in context of what we call CARICOM. CARICOM is the Caribbean community which was organized under the Treaty of Chaguaramas 1973 and revised in 2001. There are 15 member states, 5 associate states, and who are of various ethnicities, as I started to say. There are Africans, obviously. There are people from Indian descent, Europeans, Chinese, Portuguese, and Javanese. And we also have a mix of religions within the region. Christianity, for obvious reasons, Hindus, Muslims, Jews, those who practice what we call traditional religions. So there's quite a melting pot. CARICOM is headquartered in Turkey, which is in Guyana. And what is important in CARICOM for our purposes is that a lot of decisions which affect the region are made at the CARICOM level. For instance, later on in my presentation, I'm going to discuss the various updated arbitration legislation that was passed. That model arbitration bill was the product of a Canadian-funded project called Impact Justice Project, where they brought several esteemed jurists from within the region to draft the model arbitration bill. And that was subsequently adopted by the LAC, which is the Legal Affairs Commission of CARICOM, which is a grouping of all of the attorney generals and solicitor generals from the various member states, which I stated. So just for context, I have a little map here to show you how diverse. We have the Bahamas and Cayman to the north of the region. We have Belize, which is in Central America. And then to the south, we have Guyana and Suriname. So you could well imagine, the complexity of the layers. What is also important to understand here is that they have various economic sectors, and they also have various languages and so forth. Actually, in St. Lucia, for example, it has a civil code context to it within a Commonwealth-speaking Caribbean. And similarly, in Guyana, it's Roman Dutch influences for some of its property matters. So you can appreciate that there is some complexity due to our historical context in which we're operating. In terms of the Caribbean, we have 2 appellate courts, again, adding to the layer of complexity. We have the Caribbean Court of Justice, which was established in 2005. I had the privilege of being just before I left law school to attend the opening. And then I also had the privilege to be part of the first case that came before them under its appellate jurisdiction. It is the judicial institution of CARICOM. It has two jurisdictions. It has an original jurisdiction to interpret the Treaty of Chaguaramas, and it also has an appellate jurisdiction, where it is the final court for some of the states. Unfortunately, even though there are 15 member states and 5 associate members, there are only 5 countries which have signed on to the Caribbean Court of Justice, being Barbados, Belize, Dominica, Guyana, and St. Lucia. The other jurisdictions within the English-speaking Caribbean still use United Kingdom, the board of the Privy Council, which many of you would be familiar with. Hence, the melding of these various appellate courts and case law can lead to very interesting developments. Now, what I will do going forward in my presentation, I'm going to look at some of the recent legislation that has been passed with respect to arbitration and also the case law. What we have found within the jurisdiction is, depending on where you are, each one has a focus for its economy. And I think many of you would appreciate that. So if you are in Guyana and Trinidad, they are oil and gas related. They do a lot of, Guyana has mining, exploration of gold, extraction of gold and so forth. If you were in Barbados, there is the issue of offshore financial services and renewable energy. We are one of the leading markets for solar power within the region, if not the world. And if you are in the Bahamas and Cayman, BVI, definitely you are looking at the provision of offshore services, and sprinkled in there is quite a lot of construction arbitration as well. So each jurisdiction has a niche in terms of the types of arbitration matters that come from them. Having recognized that having a robust arbitration system is important for the development of foreign direct investment, respect for the rule of law, we have seen over the last 10 years or so an escalation in the number of jurisdictions which have updated their legislation. And just for reference here, I have the last 5. British Virgin Islands Arbitration Act 2013, Jamaica Arbitration Act 2017, Trinidad and Tobago Arbitration Act 2023, Bahamas Arbitration Act 2023, and Guyana's Arbitration Act in 2023. So definitely you can see that there has been a renewed interest in arbitration. I'd like to say that it was purely indigenous coming up as a grassroots, but what I will proffer as a suggestion, as a contributing factor, is the increase in international investments and having law firms and investors who, because the conventions such as the UNCITRAL model, and which these all are modeled after the UNCITRAL model on arbitration law, the New York Convention. I always like to say these pillars of the international commercial arbitration are meant to travel. They speak the language of international business. And as a result, these jurisdictions, understanding their importance, have felt the need to upgrade their legislation accordingly to provide an inviting environment for international investors. My next slide, which I'll go to, will talk about some of the incentives that we've seen across the board. And there are 2 types of sweeteners, as a colleague of mine would say. Now, one of them goes to practical issues such as exemption from specific tax liabilities like VAT and so forth, or the exemption from the requirement for work permits in order for international arbitrators, if they need to, or even regional arbitrators, should they be traveling from one jurisdiction to the other to conduct arbitrations, they wouldn't need to ask for work permit, as that could sometimes take a considerable amount of time. But also we have found our procedural enhancements as well. So we have procedural efficiency with respect to the availability of consolidation within these legislations, evidentiary standard, what, the weight, where we talk about arbitrator having the ability to consider all types of evidence and giving them the appropriate weight. We've actually seen that codified in some cases, especially where there's still what we refer to as a British protectorate. We see them skirting around the issue of litigation funding, be it conditional fee agreements or third-party funding. For many of us within the English-speaking Caribbean, and those of you would be able to tell me from your respective jurisdictions, the topics of maintenance and champerty still maintain, and as a result, third-party funding for many of the jurisdictions are not allowed. I should have said earlier, which I'll mention here, is that of these, when I showed you the map of the CARICOM and the various states, what is very interesting, which has added some complexity, is that the legislation across the region varies from that which mimics very old 1958 and 1887 English legislation, all the way to modern legislation reflecting what was the UK 1996 Arbitration Act and so forth. So the understanding and the interpretation of arbitration across the region can somewhat be disharmonious as a result, because the legislative framework in which some of these arbitrations are conducted is quite antiquated. But I do think with these developments, we will see more and more jurisdictions updating their legislation. So as I said, in addition to issues of litigation funding arrangements, we also see codification of the finality of awards and judicial support of arbitration. Many governments have spent time having their judiciary trained in international arbitration to understand its benefits and to also allow them to act efficiently, because many of these jurisdictions also have separate commercial courts. And obviously in commercial matters, you're going to see arbitration come up quite a lot. And as a result, the various governments have had their judiciary trained in that regard. So we're seeing progress. Those of us within the bubble, as we like to say, would like it to be quicker. But what I think my preference is, I prefer steady, where we have adopted definitely international best practices for the good of the region. And that really, for me, is a consideration to be had. Now, so that's just a quick look at some of the developments within the case law, within the legislation in terms of the incentives it provides and providing an environment which international investors would be comfortable in. I'm not, for the purposes of today, because I only have about 25 minutes to talk about the ISDS factor, but we do see a number of jurisdictions. I think there are about 3 countries right now within the Caribbean, the English-speaking Caribbean, who have appeared before who have cases before ICSID in different types of matters. Oil and gas again, smart contracts for transportation, and I think one was hospitality. Now, having had a nice framework supplied by the legislation, I want to touch briefly on the role of centers. And this is why the work that your INBA is doing is so important. I would tell people that these are important. As stated in my, so what we have in the region, especially those who've had updated legislation, is we have a number of arbitration centers. They are about 4 and 5. Barbados has 1, Jamaican has 1, Trinidad has 2, Cayman has 1, and BVI. what we all agree on, because we do try to have a collaborative relationship, is that we have, as centers, multiple roles. Not only do we have to grow awareness about the use of arbitration and ADR in general, but part of it is capacity building. I am with the Chartered Institute of Arbitrators. As indicated in my bio, we teach arbitration. We also try to host practitioners workshop for those who don't necessarily want the qualification, but they want an understanding of the framework. We host training for media, and we also still have to host, mediation and arbitration, because that is our business. Just as an idea of some of the things we've done, when I became Secretary General, just before the pandemic, could you imagine, 2020? I started in January, and by February, March, the pandemic broke. One of the issues we wanted to address, which we'll speak to diversity later, is to open the panel. Most centers have a fixation on the recognized names, and I think that is good. It grows authority and it shows that you have the necessary gravitas. But equally important is the development of your domestic or regional arbitrators, who may not get the opportunity to participate in the larger, more established centers, but they have qualifications, they have undergone training. What they lack is the experience, and that is one of the greatest hurdles for young and upcoming arbitrators and mediators to get. And one thing we considered was we asked persons who had the necessary experience to submit their CVs to be considered for our panel, so that we can grow ADR regionally at a very grassroots level. I also did a survey for SMEs, because we found that small businesses weren't utilizing arbitration as much, or mediation as much as they could. They did not understand best practices in terms of preventative measures. So we had a survey there. We also conducted mediation training for virtual mediations, which has its own ethos behind it. And definitely, because of where we are in the region, diversity was big. It wasn't just about gender, it was about persons who may have challenges and disabilities. It's also about those from various backgrounds who were not necessarily lawyers, but maybe in finance or construction, all of those things. And finally, for me, I am the co-chair for the Campaign of Greener Arbitration Caribbean Subcommittee. We are acutely aware of climate change and its challenges, and felt that one of the ways we can contribute to the conversation was to have our ADR practitioners understand their role. So that's just there's a lot that can be said about the role of centers and how pivotal they are. And I implore all of you in the panel who are here today to support your regional centers. We need it. That's how we we get to develop arbitration properly within our region, and we can grow it to international best standards. So I always campaign for that, to support your regional center. Next, a quick look at two cases which recently came out of the Caribbean, the English-speaking Caribbean, which are somewhat interesting in that they challenged our traditional ideas of where is arbitration a suitable remedy, because we also understand contracts and so on. One is Family Mart China Holding Company and Ting Chuan. This one's a landmark decision because it dealt with whether certain aspects of company law are arbitrable. In this case, it was a company that was winding up. It was a joint venture agreement between Family Mart China, which is a chain of convenience stores in the People's Republic of China, and they had a joint venture agreement. There was a petition to wind up the company because there were issues within the joint venture. And one of the Court of Appeal, it came up in the Cayman Islands, and the issue was, can a wind up petition, is it arbitrable? And we have found as parties have more and more sophisticated financial instruments that these are considerations coming before courts, hence the importance of training your judiciary in understanding. The matter went before the Privy Council. Mr. Chuan raised 4 points, which he thought should have been resolved by arbitration. And the board confirmed that, yes, the arbitration, that a tribunal has jurisdictions to make certain orders, but there are areas which they cannot. And therefore, it's found that they can arbitrate matters which underlie the winding up, but not necessarily the winding up petition as itself. So you can see the case law pushing the realms of where we see arbitration functioning. And that's why Family Mart was such a groundbreaking decision. I'm just cognizant of the time, because it shows the interplay between arbitration and winding up in jurisdictions of the common law, especially if your winding up legislation is outdated. You could imagine the challenges. The second case I want to bring, which is also quite interesting, is the arbitration of internal trust disputes. We have seen that some arbitration legislation have considered it. It's become a hot topic. This is a wealthy family from Nigeria who incorporated a company in the Bahamas. And they eventually, what happened is that the settler to the trust redistributed the assets, much to the annoyance of one of the beneficiaries. The challenge with a trust is that you have to be a party to an arbitration agreement. But if you're not a party, as the beneficiary, whatever outcome comes about from the arbitration, you're affected by it. So you could well imagine there is this beneficiary who's, to their mind, disadvantaged by something the settler has done, but they can't do anything about it because, as far as they're concerned, they are not a party to the arbitration agreement. And this was also an interesting case. The court, as being pro-arbitration, allowed the matter to be resolved by arbitration. So we're seeing those types of cases which are pushing the envelope in terms of arbitration. Next, the benefits. You talk about the choice of the arbitrator, being confidential and flexible, and finality of the award. All of those were taken into context with the use of having trust arbitration and it being part of their legislation. Just as a roundup, because we are discussing ADR, I want to talk about mediation for 2 minutes. It is available. We have a court-connected arbitration mediation program, and I'm rostered with the Supreme Court of Barbados, for example. It is available through the courts, institutions, and privately as well, but very few jurisdictions have legislation outside of the court directives, like, directives number 1, directives number 2, but it is available. What we've also seen is the brave step by a few countries within the region to sign on to the Singapore Convention on Mediation, which was in 2018, and we have 4 states, Belize, Grenada, Haiti, and Jamaica, who signed on in 2019. What I will say is it hasn't been put to the test as yet, but I'm very much intrigued to see how it would operate in practice within the region, because we tend to, because of the informal and flexible nature of mediation, there is only 1 or 2 jurisdictions have legislation, such as Trinidad, and the others don't. So I'm interested to see how it would be implemented. What we're also seeing as when we talk about the future, so we're seeing the updating legislation. We are seeing also the types of topics being expanded in terms of trusts and company law issues. I recently attended a workshop where they discussed the mediation and arbitration of tax disputes, especially under the OECD model under Action 14. That's also something. So we see the expansion of mediation within these various and arbitration within these various sectors. And what it also does is it gives opportunity to many upcoming arbitrators to be in what I like to call the non-traditional sectors. And because international arbitration is by its very nature international, you can be where you are and be part of matters which are elsewhere, you know, and if you are multilingual, better yet. So therefore, the opportunities are slowly expanding for persons who are within the ADR sphere. So this environment where you have not only countries updating their legislation, but also the expansion of areas where they want to conduct ADR, be it arbitration or mediation. I use those because those are the more recognized. It is creating an environment, but I will say this, for us within the region, it is slow and steady, and it is with opportunities such as these, where we get to share our understanding and our knowledge that are so crucial to the development of ADR practitioners in the region. Now, I wanted to say that the number that I was in the presentation, I started to feel, I don't know how many of you are cricket fans, I started to feel like a night watchman. And I was a little concerned because by then everybody, the state of play at the end of the day, everyone's a little tired. But that's the role of the night watchman to keep the overs going until. So I do appreciate everyone's patience in staying up. I know it's quite late where a lot of you are. So I do very much appreciate, but since the pitch was so well prepared, I felt like Jason Holder coming up to the wicket. And I said, I still have to do my thing. So thank you very much for this kind opportunity. It is very much appreciated. And all the best. It was fantastic, really was. Yes, thank you so much.
Sir,
Yes, yeah. Tanya, as a beginning remark, we from KFCRI are quite thankful for your initiatives through the Arbitration Mediation Center or the court in the Caribbean community. And we need to have a long-term relationship so that the traditional connect should be viable in the modern era of ADR. Thank you once again, Tanya, for joining and sharing the perspective about the Caribbean community ADR.
Moving on to the next session of the day, we have Ms. Natalie Najjar from Lebanon. We are honored to welcome Professor Natalie Najjar, a distinguished legal scholar, arbitrator, and attorney with over 3 decades of experience in domestic and international arbitration. A PhD graduate from the University of Paris, Panthéon-Assas, she has taught arbitration at leading institutions, including Assas and St. Joseph University in Beirut, where she currently leads courses in both PhD and LLM programs. Professor Najjar is a senior partner at Ibrahim Najjar Law Firm and represents the Lebanese state before the ICSID, in addition to serving on numerous arbitral tribunals. She's also the chair of the Arbitration Commission at ICC Lebanon and General Secretary of the Lebanese Review of Arab and International Arbitration. We are privileged to welcome Professor Natalie Najjar to share her insights on the ADR landscape in Lebanon and to enrich today's proceedings with a scholarly and practical expertise. Over to you, ma'am.
Thank you very much for your kind presentation. Allow me first to thank all the organizers and Mr. Inbavijayan for inviting me to speak in this very prestigious global and virtual platform, and for giving me the opportunity to introduce all the attendees to arbitration in Lebanon, to main features of arbitration in Lebanon, and to present the specific information relating to arbitration in this country, because probably this is a very tiny country, but actually beyond its very limited volume, actually Lebanon has a very long history in arbitration, as we can see it. But before stepping into the subject, let me introduce you with a brief overview of the socio-economic facts of this country. Lebanon, let me tell you, is an Arab country. It's considered, however, the most liberal country in the Arab world, both in terms of its economic, political, and legislative system. Lebanon does not have a state religion. It is a multi-confessional country, and it's accustomed to complex relations between different religious communities and between different Arab and Western cultures. Lebanon is at the gates of Asia, and at the same time, 3 hours by plane from Europe. It is considered as a crossroad of culture, as a sort of a melting pot. Well, of course, Lebanon has known many difficult times during its past decades. However, today, Lebanon seems like a country full of promises. For some years now, Lebanon has proven to be one of the largest natural gas countries in the world, although it still remains unexploited. So it's in due course of being exploited. And also it has a fairly large natural oil reserve that is still untapped and on the verge of being exploited. So there is a big potential with regard to natural resources. However, unlike other Arab countries that have long exploited oil and gas in the region for all the past few years and for all the past decades, whereas all other Arab countries were exploiting natural resources, the discovery of these resources is very recent. So for all these years, Lebanon has mainly relied on culture, on education of its citizens, rather than on natural resources and assets. This is why with regard to arbitration, we can notice that the Lebanese arbitrators have always been extremely prized in international arbitration. They are the most appointed arbitrators in the Arab countries and the ones that rank among the top 15 worldwide. So for a tiny country, it's a huge fact. First of all, you should know that major projects await for being put into practice, because first of all there's a huge effort in order to rebuild the country, and of course we are on the verge of exploiting the natural resources, and the international community is now paying an increased attention to this tiny little country, and it has become the center of attention of many world leaders today. In addition to the exploitation of gas and oil, there is a full future of this country with regard to services because, as I said, it has always relied on culture, on education, whereas other countries were relying on other types of resources. So in this context, it's important to say that we should not base ourselves on the experience of the last few years, although they have been very and extremely difficult for the country, but we should see this country as a land of opportunity, and above all, to see the Lebanese arbitrator as being of international caliber, because of their, as we will see it later, of their profile. They are multilingual. They have several cultures, and especially they have a huge ability to juggle with different global legislative systems. In recent years, of course, Lebanon has not been among the most frequently cited party in international arbitration. However, this was due to the economic circumstances and political ones that this country endured. But today, with the change of the political facts and the political background, there is lots of opportunity in this area of the world. And it is very important to stress that we are today we have initiated a new phase of reforms, and the political appointments, notably the one of the President of the Republic, who is a person who has who have a very he's a bright figure and an honest man and a hardworking man, and the president of the cabinet also, who is of an international caliber, who was the head of the International Criminal Court. So this places this country on a new era, in a new stance that makes him very promising in the future. How does that influence arbitration? Well, it's important to say that Lebanon, given this openness, this liberal system, has always been also very open to arbitration, this institution being the most prominent method of dispute resolution internationally. So, and Lebanon has always known a very huge effort in international trade. It positions itself. First of all, the import and exports are very, compared to the domestic industry, is very prolific. And moreover, we can say that the Lebanese people have a huge history in traveling, in trade, and in international businesses worldwide. So this has reflected on arbitration and has influenced the system, which is one of the most liberal arbitration systems in the Arab world. Our system is taken from modern French law, and it was adopted in 1985, and it has it enshrines the most liberal principles in matter of arbitration. It's very liberal as the French law, and generally Lebanon has not is not known for having courts that testify a sort of defiance with regard to arbitration. To the contrary, courts are generally have adopted a very positive stance with regard to arbitration, and they consider this method as a very regular one, very normal method, and there is no competition between state courts and arbitration, which is quite different from the neighboring countries, where we know that in the Arab countries in general, arbitration is considered as an exceptional method of dispute resolution, which is not the case in Lebanon, as it's regarded as a very normal and usual way, and there is no strict positions with regard to the solutions that govern arbitration in this country. And of course, this has reflected on the importance of the arbitrators and their profile worldwide, because they come with a very rich background, because Lebanese lawyers, Lebanese arbitrators, and Lebanese people are generally multicultural, multilingual, as I said, and they have they are aware, and they study several kinds of systems. It could be the Arab system, the Lebanese system, and the French system and European system, as well as common law systems. So they are very open to worldwide solutions, and that explains why they rank among the top 15 worldwide, whereas they come from a very tiny country. Just to give you an idea about the size of this country compared to, of course, India, we are only 10,450 kilometers. So this gives you an idea how tiny we are, but we should not judge this country upon its modest size, but more on its culture and its position and its location in as I said, because it's a crossroad, and Lebanese people have always have a very huge tradition in traveling, in exporting their knowledge, and of course of being very keen in so many different languages and systems, and also legal systems. I myself, for example, I speak fluently with completely fluently 4 languages. I am very frequently appointed in arbitrations, and in particular in international ones. And I have been a professor in France, in Beirut, and I have absolutely no difficulty in adapting either there or here. And I have been appointed in so many different and very varied profile of arbitrations, whether implicating Arab countries or elsewhere. So this gives you an idea how polyvalent and how Lebanese arbitrators can be very I mean, they can adapt to so many different cultures and to different systems. Now, what about the Lebanese landscape with regard to arbitration? First of all, allow me to tell you that given the fact that we have endured so many ordeals in the past, we have centers that have developed, and recently new ones have been created. But one center is the most prominent center in Lebanon, which is the Beirut Chamber of Commerce and Industry, that has an arbitration center. And this center is most often called upon for domestic and international cases, but mainly with regard to cases involving Lebanese parties. However, it has recently revised its rules and is becoming more competitive at the regional level. In addition to this center, the ICC, International Chamber of Commerce, Lebanon, has a very active commission. I am at the head of the arbitration commission at the ICC Lebanon, and it's very often appointed in order to suggest arbitrators for the ICC, of course, elsewhere internationally, and of course. But if you know better the ICC, you would know that it's not a center that's based in Lebanon. It's only the committee that's referred to, and this is why we cannot say that it's a center based in Lebanon. It's the arbitration commission that relates to the ICC in France or elsewhere, because there are now several seats of the ICC worldwide. So it's just the ICC Lebanon committee that is called upon whenever it's decided by the ICC in France. Or elsewhere, or in Singapore or elsewhere. Well, in terms of the Lebanese legal landscape with regard to arbitration, let me tell you that in order to implement the Lebanese legal provisions with regard to arbitration, as I said, that are taken from the French Reform of 1980, 1981. Well, the Lebanese courts in general, and in terms of judicial precedents, do not testify, as I said, hostility with regard to arbitration, but to the contrary. However, we do have some particularities and some specific solutions, sometimes more in domestic arbitration than in international arbitration. And the major modern principles are shaped to the image of the French case law and are well enshrined in Lebanese practice. The remedies at the post-arbitral phase are very efficient. They are also taken from the French Reform, and they are very liberal with regard to international arbitration, because if I didn't say it, we do have a dual type of arbitration. We have domestic and international. They are governed by different set of rules, but in international arbitration, we have a very liberal system, as I said, that is taken from French law. And Lebanon is a party to the New York Convention, to the Washington Convention, has concluded many bilateral treaties, investment treaties with many different countries that you can, of course, you can have a look on them if on the site of the Knesset. But most of all, you should know that the Lebanese legal landscape is, in general, very favorable to arbitration. Of course, with some, as I said, peculiarities, some particularities that are specific to the countries, but that are not against in their major guidelines. They are not obviously. They do not infringe international standards. In short, Lebanon is undoubtedly a land of opportunity, even if an important path remains to be made, mainly at the security and political fields and levels, but also in order to confront multiple challenges that cannot be concealed with a view to an economic and judicial recovery in the country, and in order to allow this country to become a hub in the future. However, despite all these challenges that are waiting for this country, and I am sure that this country is ahead of a very prosperous area, and it is not only according to my point of view, because lots of changes have occurred recently, and it is the trend now. We should nevertheless give a very specific attention to the Lebanese arbitrators that have always continued to be among the most sought after in the world. And as such, it's important to learn about these arbitration and their own specific backgrounds in order to go beyond the framework of only Euro-Arab or Western Arab relations, but also to seek their appointment in more diversified disputes involving, why not, Asian countries. I myself have been appointed in some Asian cases, and I think that Asia should know more about this profile of arbitrators, because it suits a lot this type of dispute resolution method. So this is what I wanted to express with regard to Lebanon, but I would like, of course, to hear any relevant question that could be asked at that level, and of course, I'm here for in order to answer your questions.
Thank you, Natalie. Obviously, Natalie is not an outsider. She is already part of the advisory committee and the board of KFCRI from its inception. And the way how Professor Natali highlighted about the Lebanese jurisdiction, which is not only liberal, which is also a quite very unique hub within that particular Arab world. And that is a great takeaway. And we are happy once again on behalf of KFCRI. Continuously, your support is required, and already you're providing that. And this has to go in a longer way, wherein now this task of Global South ADR Alliance, in that we need your support as well as participation at the near future. Thank you.
Thank you very much, Mr. Inbavijayan, for your invitation, and I was happy to lecture and to give this conference, this virtual conference with you, and allow me to assure you that I will always be at your side whenever you need any advice in this field.
Yes, thank you.
Thank you so much. Bye bye.
Moving on with our next speaker, we are pleased to welcome Mr. Sameep Khanal, a Nepalese qualified lawyer with extensive experience in project finance, international arbitration, and foreign investment advisory. He has represented clients in high-value arbitration under UNCITRAL and ICC rules and has played a key role in landmark infrastructure financing deals, including US 1.8 billion Arun 3 and USD 453 million Upper Trishul 1 hydropower projects. Mr. Khanal also serves as the editor-in-chief of the Transnational Law and Policy Review and has contributed to legal education and policy reforms through his work with the Center for International Law, Nepal. Currently pursuing his LLM in Geneva Center for International Dispute Settlement, he brings a dynamic and globally informed perspective. We are honored to welcome Mr. Sameep Khanal to share his insights on the ADR landscape in Nepal and to contribute to the richness of today's discussion. It's up to you, sir.
Hello. So thank you for this very detailed introduction. So hi everyone. So I'm Sameep as introduced. So I know every one of you are thinking like why I'm listening to Nepal at these late hours and like what Nepal has to offer. But certainly I think like Nepal has some perspective to provide. And I'm sure for India and our neighboring countries, like the practice in Nepal has many implications. So which I will show in my slide because there are a couple of case laws that transgress boundaries and like that affects not just Nepal but also India, and there are a lot of recent changes that builds on the global practices like the issues of corruption in arbitration, like the issue of fact finding in corruption. Those issues like those are discussed not just in a minnow country like Nepal but also across Paris, Geneva, and London. And I think those changes are also like introduced recently in Nepalese legislation, which I'm sure I think this ADR Global South Day will certainly benefit from. So to the next slide, please. Yeah, so in this presentation, I'll try to be as brief as possible due to the constraint of time. And since Nepalese arbitration regime is as vast as it may seem, so we just have limited time. So I'll just try to give a good perspective so that it resonates with the ADR Day and the Global South perspective. So I'll basically try to cover the Nepalese arbitration landscape, and then I'll try to show the basic high-level introduction to arbitration legislation, that is Arbitration Act 1999. And then I'll discuss the recent reforms and the recent, or should I say notable, case laws on arbitration, in which I'll try to highlight some of the good ones and some of the bad one decision that Nepalese Supreme Court has enacted, and which has implications on the practice across Nepal as well as in international arbitration across borders. And then I will try to give a high level suggestion, like what could be the suggestion that can be incorporated to make it more innovative, make it more practical in terms of cross-border settlement of international dispute by arbitration. So starting with the next slide, where I'll try to just introduce to the Nepalese arbitration landscape. Can we go to the next slide? So just to introduce, so Nepalese arbitration is not just focused on the commercial arbitration or not just to the institutional or ad hoc arbitration. So Nepalese arbitration dates back to a long time where we have a rich history of being party to ICSID conventions. And like when ICSID convention was introduced, Nepal was one of the earliest signatory to that convention. And then like a lot of countries in South Asia, so we are also party to the New York Convention. In New York Convention, we have a typical reservation in place, that is one the reciprocity reservation and one the commercial reservation. And why I say this is because this has come to haunt the international settlement of dispute between Nepal and India, which I will show through a case law in the later part. And then like quite surprisingly, Nepal has only faced one investment dispute so far. And in that dispute, like the Axiata telecommunication operator basically claimed there was a breach of fair and equitable treatment by Nepalese government when assessing the tax, and they deemed that those tax were not like in line with what they legitimately expected from the investment that they undertook in Nepal. And a three-member tribunal unanimously held that Nepal did not breach the fair and equitable treatment standard under the UK-Nepal BIT. So far that's the only case, and in that case, unanimously the tribunal has upheld the Nepalese defense. And since that, what has transpired is that Nepal has itself enacted a model BIT. So that model BIT, like all the model BIT across the world and in global south these days, even in Africa. So what is the trend is now the model BIT tries to make a draft which is as loaded and as biased in favor of state as possible, which I think is not the right trend. Of course, the state protection and investor protection should go hand in hand. That's why I think in this case, the recent India UAE BIT is a good practice, because in that case, the India government also has a very high loaded state favoring BIT, but it came to the practical terms and like listened to the investor and tried to not take a hard position on some of the issues that model BIT usually provides, like absence of fair and equitable treatment standard, a very rigid MFN and national treatment standard, as well as no recourse to direct international arbitration, and a very stringent cooling period up to 5 years, which is also present in case of Nepal model BIT. And I think drawing from the regional experience, I think Nepal also can try to be flexible, practical, and try to align its interest. At the same time, not forget that the very purpose of BIT is to actually encourage the foreign investment. So I think that's something to look after in days to come from Nepal. And one issue that I also want to highlight in this landscape is the Public Procurement Act. So I understand from the Indian perspective, recently India is being rigid in opting to arbitration in public procurement and bidding contracts. And why I draw Indian experience is because in Nepal too, there are a lot of bureaucrats and like people in the Ministry of Construction and Development. Those ministry are also more and more inclined to drop arbitration from public procurement and model procurement documents and bidding documents. And this is maybe because in context of Nepal, what I can say is this is because the Nepalese arbitration award rendered against state or are being susceptible to numerous challenges, not just at the high court level, but it also goes to Supreme Court level. In some case, even though the case are dropped. There's an increasing and a very bad practice to take recourse to, the extraordinary remedies like repetition, which is a very bad and exercise, because that's not what the purpose of those remedies are. And I think drawing also from the Indian experience and also from Nepalese experience, what I can see is going forward, Nepal will also have very hard time, or Nepalese practitioners, Nepalese private practitioners, Nepalese construction professionals, they will have very hard time convincing government to have arbitration as the method of dispute resolution in the procurement contracts. And so what is also interesting is Nepalese Procurement Act itself prescribes the arbitration procedure, and that is coming into increasing scrutiny because of the numerous challenges. So that's the general overview of arbitration landscape in Nepal. So I think now in next slide, can we go to the next slide? I think in that slide, like I'll just deal with the Nepalese Arbitration Act 1999. So it's due to limitation of time, so I'll just deal on it on a high level basis. So it's the Arbitration Act 1999 is the governing legislation. So it is inspired by Ancestral Model Law 1985 version. So that's why some of the recent amendment that was introduced in 2006, like the recognition of interim awards and those kind of issues are not present in Nepalese Arbitration Act yet. And then that act is also very rigid in that it has not been amended since a very long time. So it was only a year back when it was systematically amended, and in that time too, what I would say that those amendments were not very business friendly. Those amendments were not carried out in a manner that you would amend a 24-year long legislation, because I think those legislations are meant for practitioners, businesses, and those I think in that sense such kind of legislation should be shared. There should be consultation and there should be discussion, and that's how it should be amended. But unfortunately, it was amended via ordinance, and it is also tragic and comical because uh, while this ordinance was amended, there was a coalition government in Nepal, and those coalition government had absolute majority. So it was kind of unusual for a coalition and an absolute majority government to introduce a piece of amendment through an ordinance. So that's also the context behind the recent amendment, which I will of course deal in the next slide. And so in this so this is the basic Arbitration Act overview. So due to limitation of time, I'll not be dealing more on every aspect. So like you can see, there's a judicial role. So it has a very high involvement of High Court. So High Court is involved in the appointment of arbitrator if there's a failure among parties or disagreement among parties or deadlock among parties. Then there's also in the removal of arbitrator, and also funnily in the evaluation of the jurisdiction. So as you can see, like in some of the good arbitration jurisdiction, the contestation of jurisdiction is provided exclusively with the arbitral tribunal. So only if there's a manifest error in jurisdiction, then that subject is like to be decided by the court. But in Nepal, it's still not the case. So High Court has a very high role in this. So one good thing about this legislation is it provides the very broad language to provide interim relief. So the arbitrator have broad discretion to provide those kind of interim remedies, I think, which is really important for a prospering arbitration process. And I think this remedy has been very helpful in cashing bank guarantee, in like foreclosing various kind of assets before the settlement of the arbitration procedure. And like it provides for both the appeal and enforcement procedure. Like it's a standard appeal and enforcement procedure, heavily inspired and incorporated a lot of terms from New York Convention. So it's a pretty standard legislation in that sense. So now I think we can go to the next slide, where so this is the ordinance that I was discussing about earlier. So So there are a couple of really innovative and really contextual changes that have been introduced by this ordinance. So one among them, which I find highly relevant and highly pro-arbitration friendly, is the expedited enforcement of arbitration awards. So this ordinance also introduces expedited arbitration, but as we all know, like the modern arbitration, institutional arbitration do provide that kind of avenue, and like if you choose that rule, then you can use those remedies. So it was nothing new, but what it actually introduces new is the expedited enforcement timeline. So now the parties have option to actually shorten the timeline of enforcement, and I think really innovative and really helpful to actually sort down the cynicism surrounding around the arbitration, because as you know, arbitration in our part of the world is like getting a higher scrutiny, because of course it was supposed to be a quick settlement, but due to numerous challenges one way or another, and due to lack of discipline in conducting of the arbitration proceeding, it's taking longer than anticipated. So that's why I think this introduction certainly helps in like making the best out of the arbitration procedure. And another change I found really relevant is the recent changes explicitly says that you are not uh, you should not re-examine the evidence in the setting aside proceedings. So I think I know this might not be a very new thing for some of our colleagues and some of the participants, but I think due to lack of explicit provision like this kind of provision, there would be a lot of examination of evidence, and the court would flounder between one issue or the other. And I think this explicit provision in the Arbitration Act now will certainly discourage court from going into the evidence, and also provides comfort to the arbitral tribunal, because and the parties, because they didn't opt for the tribunal to actually review and take it as an appeal of an arbitration award. And second is the finality of the award. So now the arbitration ordinance also has said that now that the once the award is rendered, it is final. Like now, this also sounds very obvious, but usually what happened in this part of the country is that once you had this award rendered, now the High Court usually suspended the application because it anticipated the challenge, and then it only enforced it after the challenge procedure was decided. But now it's no longer the case. The prevailing party can simultaneously go for the enforcement, whereas the challenging party has to demonstrate these certain criteria before they can challenge the award, which is provided in the next slide. So if we go to the next slide, so like I said, there's no automatic suspension of the award enforcement now. And interestingly, the ground for suspension of those enforcement is by the opposing party is very high, and that is it should include the case of corruption, fraud, or a risk of irreparable harm. So now I think this issue, the issue of corruption, is like very pertinent in international arbitration, and like French court and the Swiss court have laid down numerous judgment, and the arbitrators are increasingly under pressure to investigate and resolve the issue of corruption. So I think I found it interesting, like because a country like Nepal has actually deemed that this kind of issue is relevant before suspension of award, maybe because like in this part of the world, like the allegation of corruption is too much frequent. So but what I think so even though this is an innovative provision, what I find a bit difficult to adjust, is because it does not require any kind of security or financial guarantees during the suspension proceeding. So if you look at the countries like Japan or UK, it does not, provide parties with the right to go on a fishing expedition to challenge the award. So you have to be serious, and you have to have that sense that if you don't challenge it in a way like in a fair way, then you'll have some financial repercussion. So I think introducing some kind of financial safeguards would certainly mean that this provision would not be misused, but let's see how it goes. And second issue among this recent amendment is the standard of proof. So the ordinance lacks clarity on the standard of proof in corruption because, like I said, it's a new provision and there are so many discussion and rich jurisprudence established by French Court of Cassation and the Court d'Appeal of French Court and also the Federal Swiss Tribunal. So Federal Supreme Court. So they have laid down various standards like the prima facie evidence and the higher standards by some tribunals which require clear and convincing evidence. And like some French court have also said that it should have a circumstantial evidence providing to us the certainty that the corruption was actually in place. So not as high as beyond reasonable doubt, but not as low as the civil standard of evidence. So there's always this tussle of what kind of evidence one should use in evaluating the corruption, because one, corruption is a serious offense, but then again a tribunal or a court is not evaluating a criminal obligation or a criminal liability. In that case, it is just evaluating whether there was an award tainted by the corruption. So that's why this kind of standard is really interesting in this context. But I think what Nepalese ordinance missed out is to actually have a say on this, what would be the correct standard. So I think this is something which will be fleshed out in practice, and let's see, like, we'll have some clarity. So to the next slide. So now I'll just summarize like the key case laws that has been issued by Nepalese Supreme Court. So this case basically acknowledges that the law governing the arbitration agreement and the law governing the substantive contract are not always the same. And just because one party is party to the so there's a substantive law governing the main contract, you should not assume that that also is by in itself also covered, it is also covers the arbitration agreement. But I think this might seem like a very innovative judgment, but I think this is not actually helpful in a common law context, because if you look at Singapore courts, like if you look at English court in Enka versus Chop, they have taken a very practical approach and said that when a party has actually entered into the contract, you can't assume that unless there's a proof to that effect, you can't assume that they tried to have different governing law. If they had intended, then they would certainly put that. But this judgment flipped that assumption and said that the parties will have to be choosing those different law, and you can't assume that. And I think this creates a practical problem in defining what would be the law governing the arbitration agreement. And actually this case is very close to the civil counterpart of Kebabji and Cloud Food Cloud in French court, where French court also had this similar provision. But bear in mind, French law has a very different standard. Like in defining the arbitration agreement, it says that the arbitration agreement is governed by international public policy and international standard, and it's an autonomous. But since Nepal and common law takes a conflict of law approach, so I think this case is an interesting approach, very close to French approach, but I think it fails to look into the close connection test and those kind of tests that one could recourse to in finding out the law governing the arbitration agreement. So I think it will be interesting. So the UK has amended its law to make it clear. I think we should also do a similar exercise just to have avoid this kind of legalese conversation, at least to businesses. So the next case in the next slide, I think I think to our Indian audience in this panel and in this forum, like all to the attendees, I think this case is really relevant, because in this case, basically what Nepalese Supreme Court said, which I think is rightly the case, but which was unfortunate, is that the Indian awards are not enforceable in Nepal. And I think I don't have to explain more because, as you know, India has a list of reciprocating territories, which is, I think, very surprising to me because India is such an advanced arbitration jurisdiction with so many sophisticated case laws cited across numerous, jurisdiction. But still, the Indian government maintains that reciprocating territories, and Nepal is not in that territories. So now, in this case, basically the Shanghai brothers got this award rendered in India, and it tried to enforce in Nepalese court. And Nepal has, like I said earlier, it has a reciprocity reservation. And since India will not recognize Nepalese award, so the Nepalese Supreme Court also upheld the High Court's decision not to recognize this award. I think this is, I don't know why this reciprocating gadget is still in place. I think we could do away with this because, at least from Nepal's perspective, because India is Nepal's largest trading partner, and I think if we are to promote this cross-border trade and commerce, I think we should certainly, take out this kind of unpractical and unfriendly, practices. But let's see how things will transpire. And the final case. So I don't want to go more into this. This is also a very erroneous judgment. It basically says that if there is no appointing authority, chosen by parties, then you have to go to the Nepalese court. Like, I think this is very erroneous because, as all the practitioners would know, Onchitol provides that default procedure for appointing authority. So does ICC rules and others. Like, they have that procedure, but now it says that you have to go to the High Court. I think, which is, in my view, very preposterous and impractical. So I think these kind of decisions are actually affecting the interpretation and belief of practitioners in arbitration. So finally, like, let's to the next slide, please. So finally, this is my final slide. So basically, what I believe is the next step for a minnow country like Nepal, which has a lot to learn, but also which believes in arbitration as a means of settling dispute. So maybe we should have a clear law governing the arbitration agreement, do away with all this analysis and dispute like UK did. Maybe we also should permit parties to waive the grounds for challenge, because that way party will be more motivated towards settling dispute through arbitration, and it will make it efficient and less susceptible to frivolous challenge. And third is, we should limit the court review of jurisdictional objection as much as possible. Maybe the inspiration is Swiss and French practice. And we should also have modern regime for enforcement of interim awards, though those issued by foreign seated arbitration, and also support the request for evidence from foreign seated arbitration award. And we should also recognize the emergency award issued by SIAC and others, because now arbitration is not just about after the constitution of tribunal. Arbitration is more and more also concerned about pre-constitution of tribunal remedies. And finally, like, we should also provide for arbitration legislation should also provide for joinder and consultation, which is more and more important remedy, because in context of multi-party arbitration, in construction arbitration, there's not a single party, and like, the arbitration should now grow to include and absorb those kind of possibilities as well. So thank you for having me in this webinar and listening to me throughout. So if you have any questions, I would be happy to take it. Thank you.
Yes. Thank you, Sameep, for the insight on the Nepal in the perspective of investment arbitration, as well as the perspective of Chartered Institute of Arbitrators, Nepal chapter. It is a nostalgic feeling when it comes to the Nepal, particularly the Nepal institution. I think the oldest institution in Nepal, that is the Nepal Council of Arbitration, similar lines to the Indian Council of Arbitration. And if you can see the model of functioning of these institutions being the very unique qualities of the traditional arbitration mechanisms, and it was acceptable, no doubt. But now the world is moving fast. The reforms, the acceptability, the judicial pronouncements, all are rapidly developing. And the good thing is that, as you rightly pointed out, as of now, Nepal has faced only one investment arbitration, wherein it's a good statistic for all of us to understand to what extent the applicability of this ADR mechanisms in the jurisdiction, particularly between the two giants, Asian giants, the one side the Chinese and the other side the Indian. That is a great opportunity what Nepal can provide, and your insight on it was wonderful informations. And thanks once again on behalf of KFCRI to have you on a late evening in Nepal, sharing with us. Thank you.
Thank you. Thank you, everyone.
Due to an unforeseen event, we would like to proceed with the next presentation by Mr. Akash from Dubai. So we are pleased to welcome Mr. Akash Pavnikar, a seasoned contracts and commercial manager with over 2 decades of global experience in construction law, arbitration, and project management. Currently serving at RKEZ in the UAE, Mr. Pavnikar is a chartered quantity survivor, a member of the Chartered Institute of Arbitrators, and holds an LLM in construction law and arbitration. His expertise spans high-value infrastructure projects, including airports, malls, and residential developments, with a strong focus on FIDIC contracts, claims management, and dispute resolution. He has led commercial teams across major firms such as SC, CEC, AI Ferra, and Larsen & Turbo, consistently delivering strategic and profitable outcomes. We are honored to welcome Mr. Akash Pavnikar to share his insights on the ADR landscape in the UAE and to contribute to the depth of today's proceeding. Over to you, sir.
Thank you so much for detailed introduction. Good evening, distinguished guests, colleagues, and fellow arbitration practitioners. It is an honor to be invited to speak at this esteemed forum, and I extend my sincere thanks to the organizers for this opportunity. Today I am going to cover India and UAE's role in construction-related international arbitration. Considering that my background is from the construction, my focus will be on the legal developments, the construction sector trends, and few case law, which help us to improve our arbitration and institutions. International arbitration, particularly in the context of construction, present a landscape of unique complexities. Projects often span jurisdiction, constructed in one country, governed by the laws of another, and executed by parties from entire different legal and cultural backgrounds. This global interplay necessitates a reliable, a confidential, and enforceable method for dispute resolution. And that's why making arbitration not only relevant, but very much essential in the construction industry. Apart from arbitration, definitely there are many alternative dispute resolution mechanism is available. And ADR is the best, but eventually last resort is arbitration. So it must be considered carefully, as few disputes may become technically so complex that despite we have the experts during the construction of the project, we lose the trust, we lose the faith, and eventually we have to resolve that through arbitration. To give one example, which is from my experience, which is happened on the multi-million-dollar project, is and this is the most favorable topic, even means most of the cases I have seen in the arbitration on this topic, which is the extension of time claim for the contractor. When there are delay event occurs, contractor is entitled for extension of time. But the most disputed, the most disputed occurs is like which impact analysis we have to consider. Now, definitely contractor may consider, for example, impacted as plan analysis, because it might be a beneficial for for his company, to which will give you additional extension of time, whereas the engineer and the employer will consider, let's say different method, which is like, say, window analysis. So that's the reason we should draft the contract in such a way that it this dispute has to be resolved during the draft itself. We should understand, means by lesson learned, that what are the disputes are there in the industry, and accordingly we should draft the contract. Now, even the Society of Construction Law also stipulates that what are the impact analysis methods we have and should be considered during the construction of the project. I will little bit emphasize on the standard form of contract, which is widely used, worldwide is used, which is a FIDIC standard form of contract. Now, why standard form of contract? Because definitely it's a tried and tested and widely used, and which means the party who are entering into the contract understand very well the intention behind the clause which has been drafted and how it has to be interpreted are very much aware by both the parties. Also, I would like to emphasize that, for example, FIDIC has robust dispute resolution mechanism, which, for example, sometimes engineer decision or latest, let's say FIDIC 99 or FIDIC 2017 has engineer determination, following which DAB, which is a dispute adjudication board, and then amicable settlement, and eventually then it will land up in arbitration. I understand that this forum is for the arbitration, but these backgrounds will help me to understand that why the legislative reforms, why the institutions has to see all these details and enhance their rules in such a way that it helps the construction background people. Now, first, I would like to start with India's legislative reforms, which has recently has been considered. So India is definitely has Arbitration and Conciliation Acts, which is based on unsettled model law, and it's a part of New York Convention in approved in 1960. So from last approximately from last 6 years, India has come up with many reforms to this act, which is 1996. Say in 2019, India has established the Arbitration Council of India, enhanced authority of arbitral tribunal, and declaration of impartiality and independence. Further, after 2 years down the line, in 2021, they have removed the automatic stay. They have streamlined enforcement of freedom and choose arbitration, that is including the foreign national, which is again one of the important point has to be considered. And now in 2024, India has submitted a bill to promote the institutional arbitration, reduce judicial intervention, and timely resolution and integration of with Mediation Act. Now, this reform is very much important, which strengthen the institutional arbitration. And being as a contracts manager from last 20 2 decades, 20 years, when I'm drafting a contract, or when I'm advising someone to draft a contract and consider, which institutional arbitration has to be considered. These reforms are definitely, are important points which helps me to consider that which institutional arbitration has to be considered during the contract. Now, let's understand that what are the arbitration institute India is having, which is definitely India's International Arbitration Center, then in Indian Council of Arbitration. India has come up with again the Mumbai Central of International Arbitration, which is I am a young member of that, and Delhi International Arbitration Center. India also considers some international institutions, which is LCIA, Singapore International Arbitration Center. ICC is one of the important institutions, for India. Now let's go to UAE. Let's understand that what is the position of UAE. Now UAE has entered into the New York Convention in 2006, and it has the Federal Arbitration Law 2018, and it is also based on the UNCITRAL model. Now, I would like to go a little bit back when I was in my previous company. We have all, we had many delay events due to which we have submitted extension of time, and we are at the verge of that amicable settlements, and after that we have to go ahead and submit. We had to go ahead for the arbitration. And that time there was a news that DIFC LCI is going to change and going to merge with DIFC. It created so much chaos that so much rumors, so much the news that it hold us back to submit the arbitration case, to DIFC LCI. Definitely, UAE has come up with a very well prepared the seminar, webinar, and many much details which help us to understand that how smoothly DIFC LCI is going to take over by the DIA. Now, this is why I'm referring that now in future, now definitely if any countries is coming up with lots of reforms, then by considering those reforms, by considering that it's the changes are happening, for example, in India in every 2 years, despite it is a positive, it will be little bit hesitate for me to consider those kind of institutional arbitration. Now again, of course, UAE also has some of the institutional arbitration, which is, for example, Abu Dhabi Commercial Conciliation and Arbitration Center, DIAC, as I mentioned. Sharjah also has Takim, and Ras Al Khaimah also has RAC ICC. Of course, I'm from the construction background, so I will touch upon some cases which I chose, which help the industry to understand what are the disputes which occurs during the construction of the project and how it should be considered in future, so that it will have it will be means the arbitration case will be resolved in a very short manner, without much cost, without engaging the many lawyers and all that. Now let's understand some India's case law, which is first is PNC Infratech and NHAI 2025. I have taken this case because I recently in the initial I mentioned that I strongly recommend to use FIDIC form of contract, and from this case we will understand why. So the case detail was an arbitral tribunal directed the NHAI to pay near about 485 crores with the interest to PNC Infratech due to delays in construction of a 4-lane Agra bypass under a FIDIC form of contract. Now, if you see a FIDIC form of contract, and recently FIDIC 99 in 2017, that has near about 26 to 27 clauses, which gives or which drafted in such a way that once the delay event occurs due to the default of the either employer or engineer or even the authorities approvals, it drafted in a such a way that the procedure has been mentioned, in such a sequential manner that the contractor has to submit a notice within a timeline which gives the opportunity to the employer to to resolve that delay event, so that both the parties should not enter into unnecessary delay, unnecessary dispute. And by doing so, the contractor also within a timely manner has to submit proper extension of time by choosing a proper method for impact analysis and submit to the to the engineer. Now the impact of this case is it reinforces the enforceability of FIDIC based contract and the tribunal authority to award substantial compensation for a project delays. Now, how institution has taken up? Indian Arbitration Institution has emphasized the importance of clear dispute resolution clauses in construction contract and have provided guidance on handling the FIDIC based dispute. Now, this is where we have to understand the foundation. Definitely, the arbitration is the point where we will come and will resolve through the arbitrators. But before that, if we have the strong clauses stipulated in the contract, a standard form of contract which is very much easy for the parties to understand, then it makes the life of everyone easy. And that's why this case is very much near to me. The next one is the Mumbai International Airport Limited versus Airport Authority of India. In this case, the court allowed interim relief under Section 9 of Arbitration and Conciliation Act 1996. And the impact is, it reinforced the court's supportive role in arbitration and particularly in granting the interim measures. Now, why I choose this case is like when so in my life I have many times listened that the contractor is a claim oriented, he is submitting so much claims, but trust me that no contractor is making a profit by submitting a lots of claims. Even the Society of Construction Law also says that the compensation is the what contractor has incurred the cost, and the burden of proof goes to the contractor. Now, let's say that the contractor has entered into the dispute, let's say the extension of time claim, and the engineer is not certifying his extension of time claim, and eventually the project is getting delayed. And let's say it went into the arbitration or before arbitration. Now, what happens is like the contractors submitted the performance bond, which should be open-ended bond. Now, by having this, by entering into the dispute, the contractor's bank facilities is now, it's the contractor's bank facility is locked. Now, to have the new projects to obtain, to enter into the new projects, definitely he required more bank facilities. Also, the contractor has incurred the lots of cost because of the cash flow impact. He will also have some impact on the other ongoing projects, definitely, because the cash inflow is stuck. So this definitely will have an impact on the other project. Now, the poor contractor, which definitely in this forum people will know, the consequential damage is very much difficult, for any party to prove and to get the relief from that. Now, by having the interim relief, this will help the contractor at the early stage to maybe to release his bank guarantee, or if arbitrator feel that the contractor is maybe entitled for out of say 100 million 50 million, so with interim relief also, if they will able to release some 30-35 million, which is definitely helpful for a contractor. Now, the institutions arbitration the institutions which will have these kind of rules, which will help which will, let's say, consider the FIDIC form of contract, which consider the interim relief, is definitely a very strong institutions, and which I believe in my future I will consider this kind of institution in the arbitration clause, which will which I can foresee the problems which may occur in the future, and based on that I will advise or select this kind of institutions. The third case is again Oriental Insurance Company Limited versus now Beam Power and Steel Private Limited. In this, the Supreme Court held that the arbitration clause must express the intent of arbitration. Now, this is another very important case. And when I landed in the UAE, I have seen many contracts which has been drafted in such a way that, let's say, seat of arbitration is something, let's say, London. The institution is something, and the parties are from the different world. And even in the arbitration clause, it mentioned that if the dispute occurs, it may resolve through arbitration. So these are such a poorly drafted clause, which will definitely have a question on the validity of the arbitration clause. And that's the reason that we should, while drafting the contract, understand what is the validity of that arbitration clause, where the seat will be, what institution we should select, what are the time frames of that institution are very much important. With this, now let's understand another two cases of Dubai or UAE. Now, UAE Court of Cassation case number 1308 of 2020. The case detail is the court determined that incorporating FIDIC condition by reference does not constitute a binding agreement, binding arbitration agreement unless the arbitration clause is explicitly mentioned. Now here what happens is, like many many people, I don't want to mention the designation, many people are advising in such a way that they are giving a power to the engineer that whatever his decision or his determination will be binding. And further, they also mention that the arbitration clause also is binding. Now, definitely, this kind of the reform has to be considered when we are considering the institutions. That what power and on I mean in a response that, for example, in this case, what the impact was that Arbitration Institute have upheld their model clauses and advised parties to include clear and specific arbitration agreement in their contract. The next clause is again a very famous topic in the construction industry, which is the case is Cassation Judgment 472 of 2021, where case said that the case is the court clarified that distinction between lump sum and remeasurable contract in construction, and it held that a lump sum contract, the contractor cannot demand an increase in the pricing unless there is a change in the design or variation. Now, definitely, some people who are not aware what is the difference between, means they understand the difference between lump sum and remeasurable, but there are few clauses which has to be considered, which does not give automatic rights to the contractor to increase the price because of for example, the inflation. And that's the reason sometimes we when we are drafting a contract, we should consider this kind of clauses which help us to resolve the dispute then and there only, because of these small disputes which looks very small, but it creates so much impact on the project, on the parties, that it lose faith, it lose trust, and eventually parties are unnecessary entering into the arbitration. Now I have worked it out, and these factors normally I consider while drafting the contract and considering I mean, I consider these factors when I'm drafting a contract and selecting the institutions for arbitration. Before going to the factors, I would like to give you one example where I used to work on an international airport project, and the parties, the project was in India, and parties are from the different world. For example, the roof contractor was from USA. The facade contractor was from Philippines. The landscaping contractor was from the UAE, and it was so difficult for us to negotiate with them to to have one institutional arbitration in the contract. So these are now the following are the few factors which helps me to explain, and it helps me during the negotiation with the parties, that why we should consider a specific institutions, okay, for the arbitration. The first one is the reputation and track record. That's the reason I have gone through these legislative reforms which UAE, India, and the cases which I had referred to, okay, is required. So whenever there is negotiation occurs, I took these cases, I took these legislative reforms, and it helps me to come and sit on the table and understand which institution has a reputation and a track record, which is definitely internationally recognition and have credibility and enforceability of the award worldwide. I mean, the New York Convention is one of the a part for that, and the trusted history, and this institution also has impartiality of arbitrators. The next is definitely rules and procedure, which should be very clearly drafted. Now, considering that India is also coming up with so many reforms, so I'm 100% sure that India will also have, very, I mean, the institutionals which has, from the lesson learned, enhance the rules and procedure in such a way that will make the contractors and employers' life will be, a little bit easy. So the rules and procedures should be clear, should have clarity and neutrality of institutional rules, availability of expedited and emergency procedures, for example, the interim relief, which I have mentioned, and flexibility and transparency in the process. The third one is another one important factor is the cost and fee structure. Definitely, if the parties are in UAE and if they consider the LCI and the seat of arbitration is in London, you can imagine the cost of that arbitration. Yeah. So that's why this is another factor which we should consider during to understand or to consider the institutional arbitration. The administrative fee and the arbitrator's fee, the cost predictability and the budget control, and comparison definitely we should have with another alternative institutions. Then the another important factor is the administration support, efficiency and responsiveness of supporting team, availability of the case management tools, and a global presence. The next one is geographic and legal consideration, as I mentioned just now, that legal framework at seat of arbitration, enforcement under the New York Convention, and political stability and local neutrality. The next one is industry-specific expertise, the sector-focused experience. For example, for the construction related, if you ask me that, the DIA, definitely this factor has 100%, uh, consideration for me, considering that the number of architects, the number of expertise of those arbitrators are with DIAC. Okay, so and availability of those technical and specialized arbitrators. Now, definitely it will be a tribunal arbitrators, and during the construction itself, when you understand that the dispute are so intense that it cannot be resolved amicably, you have to start working on the the appointment of the arbitrator itself. Now the next one is again, which is because now we are moving in the world towards the AI and all. So innovation and technology is one of the important factor. Online case filling and management, support for virtual hearings, adoption of advanced tools such as AI and the secure platform is one of the important factor which I believe should be considered during the drafting of the contract to understand which institution is best for that project. With this, I would like to thank you to Mr. Inbavijayan and Kovise team, my friends, mentors, and in the last, definitely my family. On the weekend, they are allowing me, for this wonderful session. And again, people ask me that, you are a civil engineer, you are a contracts manager. Do you, means you have done the construction law? Do you feel that it's a helping you? Shall I spend near about another 60,000-70,000 dirhams to become a master's? So definitely, my strong recommendation is yes. And from this little bit presentation, you will understand that despite I am not from the legal background, despite I have genes that my grandfather, my uncles, and all that are lawyers, that a contracts manager is a foundation, for the arbitration case which is going to be resolved in the arbitration. And if contract manager understand that how that arbitrators are going to review, how the institution is going to be reviewed, he will prepare and record those contemporary records in a such a way that it helps the company to win that arbitration without having much challenge. With this, uh, I would like to thank you, and I look forward to meet you all in the UAE.
Thank you, Engineer Akash. I'm very happy to address you as Engineer Akash, even though now you are much into the contracts. What the takeaway from Engineer Akash presentation is that handle with care. That's the quote, what I feel. And interestingly, the forum shopping, what has been suggested by Engineer Akash, is entirely on the disputes to be taken only to arbitration and ADR, not to the traditional courts. And being the model taken from the FIDIC, most of the contracts, whether it is applicable in the UAE or even in India, depending upon the Indianization of the contracts, the recommendation is the dispute resolution clause has to be leading to arbitration. Very interesting note. And we are very happy from KFCRI to hear from a domain expert suggesting parties to choose only alternative dispute resolution as the best mechanism, with certain odds are there, like the cost, when it comes to choosing ad hoc or institutional arbitrations in institution, which seat, all these are given to the parties to take a call. But the time funnel reaches to the destination ADR. Thank you, Engineer Akash, for insisting on that particular point. And from KFCRI, wholeheartedly, we thank your valuable weekend time, compromising with all the commitments with your family and your inner circle, and sharing your thoughts. Thank you.
Pleasure is mine. Thank you so much for having me on this forum.
We regret to inform you that our next speaker is unable to join the webinar due to unforeseen circumstances. However, he has kindly shared his presentation, which will be delivered by Mr. V. Inbavijayan. and this will be followed by closing remarks. Thank you for your understanding and continued participation. Over to you, sir.
Thank you, Sipi, for facilitating this particular presentation, which is by Dr. Juan Manuel, full professor of international law, attached to the CRT University, Uruguay, and obviously the Secretary General of the Permanent Review Tribunal, that is MERCOSUR, a trade arrangement in the Latin American part. Can you move on to the next slide? When it comes to investment treatment in MERCOSUR, there's a very interesting factor in the Latin American region. This happened to be a cooperation and facilitation protocol, intra-MERCOSUR, in the year 2017, signed by member states like Argentina, Brazil, Paraguay, and Uruguay, which also have been ratified by 3 among those 4, Argentina, Brazil, and Uruguay, which came into force in 2020. What is the objective? It is the protocol which seeks social responsibility of investors and the contribution to sustainable development. Anyway, the GSADR tribunal, and they had a theme, exclusively taken 4 themes from the ESG goals, and this protocol also is on that line. It do promote transparency and promotions of investments in the member states. It guarantees the inherent rights of the states to rule their respective sovereign principles. Can you move on to the next slide, please? Who's an investor? Every region has a different meaning or understanding of this term investor. When it comes to MERCOSUR, the term investor, it is understood to be juridical or a physical person. They can be a public or private company, but it is through the commercial societies, a single owner or a JV. The nationality of the investor is not a specific requirement in this protocol. That is very important. The investor might also come from a different member states. Further, looking into the scope of investment, it is all about 5 key elements to be fulfilled in the protocol, like capital commitment, long-term interest, risk assumption, the protocol which is applicable to investments before or after its entry into force, and the economic benefit expectations. Can you move on to the next slide? What is the protection given to investor under the MERCOSUR arrangement? It is covered by a due process of law, the basic principle of rule of law, under reciprocal treatment. The reciprocity is there, but it's a good take. Second, the protocol does not cover the equitative and just treatment, nor even the protection and the security treatment and the pre-establishment stage. This might be too technical, but this happened to be the component of the MERCOSUR, as investment arbitration lawyers and Global South arbitration institutions, which are much active in investment disputes, would consider it to be quite a significant understanding of this protocol. This also guarantees a treatment no less favorable than for local nationals and their investments, and no less favorable to other foreign nationals as well as their investments. It is obviously understanding of nil discrimination. To add on, the protection to investor protocol excludes other substantive rules and dispute settlement mechanisms. Here, one unique protection, what we can find in MERCOSA is the indirect expropriation, which is not covered by the protocol. Can you move on to the next slide, please? What is the applicable law? According to this protocol, international law is applicable when granting or settling a right therein. It could be also said that international investment laws having specific standards from both practicing or practice prevailing in ICSID, that is the International Center for Settlement of Investment Disputes, and the Permanent Court of Arbitration Tribunals might be useful to it. However, the protocol mentions that no other substantive rules can be applied, which constitutes a contradiction. The final understanding on the applicable law is that if we are in the process of investment, particularly the investor, the protocol and its rules are applicable, well set, well structured. Can you move on to the next slide? There is a interesting slide here, which has a lot of significance why this question mark is put upside down. I was happy to hear from Dr. Juan, and that eventually you can see here what an investor can do to claim from arbitrary state measures or claims for damages. It is nothing but a protocol which manages investor-state controversies, first through an amicable solution. The objective of that particular interstate commission which deals with or which creates an amicable solution is to prevent the dispute not to be escalated in the normal course. This protocol also offers a consultative stage to the private sector. Neither this commission nor the consultative stage have a detailed ruling on how to proceed at that point. It's all a recommendatory one wherein the measures of claims or damages, if arise in an arbitrary manner, how to deal with. Can you move on to the next slide, please? Interestingly, the rider what has been shared by Dr. Juan is that the protocol has no reference to nationality, but it is only referring to investments. And this protocol excludes the following subjects from a potential application of the conservative Olivos protocol, namely corporate accountability, corruption, environment, health, labor, and the measures on investments widely and extension, which is all possible. Can you move on to the next slide? What is the significance of arbitration in a MERCOSA, particularly the protocol? Here, dealing with claims, 15 days of direct negotiation, that is between the states where the investor come and the host state. The political stage before the common market group or a potential arbitration proceedings. 2 layers are there. Anyway, the first step is facilitating amicable solution. The next would be the traditional dispute resolution mechanisms, particularly arbitration. When you move on to the arbitration proceedings, in such claims. It recommends the ad hoc tribunals. The convenient one is 3 arbitrators from the list maintained by the MERCOSA. It can also sometimes with 5 arbitrators as a second instance, or if the parties agree for it. There might be compensatory measures imposed by the state in the case of breaching of enforcement of the awards or non-compliance of the awards. Very interesting features on the MERCOSA, which has been ratified by 3 countries, even though signed by 4 member states. Can you move on to the next slide, please? There can be private claimants like companies and investors. Similarly, the direct negotiation as well as the political stage before the common market group. The note, what has been given by Dr. Juan on the research on MERCOSA is that neither company nor investor are not involved in these proceedings. That's very unique. And the company or the investor are not literally involved even in the arbitration proceedings. Quite unique. And we had to look upon how it is going to materialize in the future. I think we are in the end of the slide. We have one more, or can you move on to the next if it is available? Fine. Thank you, Juan, for sharing this valuable PowerPoint presentation. And when at the time of Juan accepting to deliver his talk, he was very particular to mention about these MERCOSA countries, particularly Paraguay, Uruguay, the recent development in arbitration. Uruguay also is very unique on having 2 regimes for arbitration, one dealing with domestic arbitration and another dealing with international arbitration, similar to some global south jurisdictions like Singapore, where we have 2 legislations exclusively segregated for the respective arbitration categories. Hope with these inputs, we are very happy that a wholesome understanding of major jurisdictions in the global south as a consolidation we have just shared with all of you. Thank you for patiently hearing this part or the final presentation for this 24 hours event. And we do have certain formalities to follow. My colleagues. Yes, our entire team is here, and the initiative, what we planned and what we have reached to this level, which is going to be the round-the-clock virtual experience and being the first Congress of ADR practitioners and institutions in global south countries. And our satisfaction is unmatchable. We are very happy to inform that there were more than 800 registrants for this event, depending upon the jurisdictions. In an average, around 100 participants joined. And it was a real wonderful experience. What we had, the expertise in KFCRI on all the global south jurisdictions has now been shared to the users and potential stakeholders in future arbitrations in this jurisdiction. Can you just scroll further? As a repetition, this is a launching pad for the GSADR Alliance with multiple other aspects like the Chennai to be a pulse of ADR in Global South, bringing in or the building the ADR institutions and a 24/7 ADR services. Can you move on to the next slide? It is our own satisfaction wherein the founding members are really happy that this has been shaped, which we planned 5 years back when the COVID pandemic came and we couldn't take it forward. But now it has become a reality. And at this moment, I thank Madam Surya Narmada, the founder of the foundation, Kovise Foundation, for giving this platform, which was created in 2016, KFCRI, under the initiative and support by the founding members, Mr. G.S. Swetan, Mr. Shahrukh Kumar, Mr. Shanmugha Dev, and Ms. Sri Nikila. Thank you, the wonderful minds which at the quite earlier stage joined and made this platform created for us, the present organizing committee, to take it in a very successful manner. Can you move on to the next slide, please? Yeah, this is the team which has done this magic. That's what I can say. And I'm very happy that more than 21 hours, they are just on their seat, facilitating this wonderful event. Not only this event, the preparation, which happened more than a month back, the continuous follow-up, the research, and the function as such. And I have to thank each and every one, starting from Mr. Sippy Wist, Ms. Soundarya, Ms. Shakti Priya, Mr. Kirti Vasan, Mr. Devdattan, and Mr. Pranav. All have contributed in a manner wherein they are going to be the future of arbitration, not only in the Indian context, but across the globe, particularly to begin with the Global South countries. Thank you for the entire organizing committee who have made the thoughts of the founding committee members. And now you are going to be the front runner of this task, what we have started just today. And I'm very happy that all of you have literally compromised your family, your friends, your vacation, particularly month of May being a vacation for practitioners, legal practitioners in southern part of India. And I'm very happy and wholehearted thanks to all of you. Can you move on to the next slide? Coming to the well-wishers who happen to be with us as wonderful stars, we can say, in the inauguration, with Datuk Sundar Raju, who happened to be a mentor for many Asian arbitration practitioners, Mr. Vinod Solomon, who was instrumental in this particular event to happen by providing the SICKI Center for ADR as a venue partner. Not only that, and sharing the very objective of creating the SICKI Center and partnering with KFCRI and facilitating this wonderful event to happen for more than 21 hours. Literally, it is almost reaching 24 hours. Along with him, I thank my well-wisher personally, as well as for the institution, and presumed to be the man behind institutional arbitration in India, starting his career in India, later moving to Singapore, building the Singapore International Arbitration Center as its former assistant registrar, and then getting back to India and continuing his efforts on developing the India International Arbitration Center, and particularly supporting KFCRI in this initiative. And finally, in the inauguration, we had a wonderful, dynamic young lawyer and arbitration qualified professional who is behind supporting all our efforts in the promotion of KFCRI, particularly institutional arbitration in this country, as well as across the Global South jurisdiction. Thank you for all the speakers in the inauguration, and hope you all would be with us with our wonderful journey. Can you move on to the next slide, please? Coming to the speakers, we are happy to have Golda from Papua New Guinea, Professor O from South Korea, Mr. Harish from Nepal, but technically in India right now, Ms. Andrea Orta from Mexico, Mr. Edwin Nemesia from Mexico. Can you move on to the next slide? Ms. Peng from Schengen Court of International Arbitration, Mr. Samisa, presently in US, having a wonderful promotion of ADR, particularly building the platform for global arbitration bar. Mr. Arif Edison of INIAC, Indonesia, Mr. Bivan Narin Singh from Trinidad and Tobago, presently facilitating from Peru, Ms. Begum from Kyrgyzstan, Ms. Dilber from Switzerland, having a perspective of Global North success story for the Global South, Mr. Jake Luther, along with the researcher, Mr. Roll from Sweden, particularly the SEC Arbitration Institute, sharing the success story and facilitating the seat policies for the Global South. Honorable Mr. Justice Priyanta Jayavardhane, Mr. Ilyas Ganam from Lebanon, very interesting SIAB tutor. Mr. Henk Low from South Africa. Datu Mary Lim, I have to thank her personally to motivate this event a couple of months back itself when she was here at the KFCRI hearing facility. Ms. Linda Banga from Kenya. Our founding member, Mr. Shahrukh Kumar. Ms. Hafa from Nigeria. Mr. Pascal and Laura from UAE, sharing the perspective of UAE as well as Saudi Arabia. Madam Madeline Kimi from Tanzania. Mr. Alexis Murley from Mauritius. Mr. Jana Pablo from Philippines. Mr. Abdullah, technically from US, sharing the development of arbitration in Jordan. Mr. Fola from Nigeria. Mr. Juan Camilo Bolivar from Colombia. Judge Andrea Palma from Brazil. Professor Jose from Peru. Ms. Tanya Godard from AMCC Barbados. Professor Nathalie Najjar, part of KFCRI from Lebanon. Mr. Samib Kanal from Nepal. Mr. Juan Manuel, even though we couldn't take him on the presentation, but thanks for sharing your PowerPoint. Future, we are going to have you not only virtual, but also, if possible, physical. And finally, our engineer, Akash from Dubai. Thank you for all the speakers. And very interestingly, the supporting members, the entire list, starting from our non-technical supporting member, Mr. Silambarasan, and the entire team. If I have just left anyone, just excuse me. And I'm very happy that each and every one who literally started as interns, not just a month or a couple of months earlier, for the last several years, associated with KFCRI, who made this event a reality. And there are some presently some interns who also were physically present in the hearing facilities, wherein their support, even now, they have spent more than, each and everyone has spent more than 8 hours. Some even the entire sessions are with us. I couldn't express the words for their support, but as an institution, we all are going to see the GSADR Alliance to effectively become the future. Thank you, and thanks for all the supporting members. No doubt, anyway, I also have to move forward to thank the knowledge partners, and everyone is evident here. I am not very, as a repetition, I should not mention, this logos shows their uniqueness, whether it is going to be outside the Global South or it's all within the Global South, or excellent support what he have given. Can you move on to the next slide? Yes, these are the pillars for the Global South ADR Alliance, which is going to be making the 24/7 as a reality in future. Can you move on to the technical partners and supporting organization? We thank the entire the K team. You can say it's traditionally we call the very success story of South Korea being the K-pop. I feel the success story of GSADR is going to be the K team, whether it is going to be KFCRI or Co-Global or Kovise Foundation or Kovise Ecovacity or Kovise Agro or Kovise Chamber of Agriculture. Can you move on to the final slide? Yes. A final say for our venue partner, the Southern India Chamber of Commerce and Industry, for given the wonderful opportunity to take the entire facility to do the event, the 24 hours event, the entire staff members of SICI giving us this opportunity, and finally facilitated by a media partner, SEC Arbitration Institute. Thank you, and I request my colleagues to share their views within a brief manner. Please, my colleagues, please start.
To start with, this is a wonderful, one-of-a-kind event organized by KFCRI with the leadership of Mr. Inbavijayan and the founder of KFCRI, Ms. Surya Namada, who gave us a wonderful opportunity to look into the different perspective of arbitration and different arena of arbitration, to be more specific. Being a young arbitration practitioner, I wonder, like, there are few number of the arbitration institutions which are tight holes. Namely, like there are more, if I'm not wrong, four to five institutions which are strongholds. But the idea of bringing the global South countries to become one of the strongholds, giving a tough competition to the other part of the world is something different, which is unique. So it was a great idea and initiative by Mr. V. Inbavijayan and the team of KFCRI, and I'm very much happy to be the part of the organizing committee organizing this wonderful event and one of the kind event. Thank you for the opportunity, sir.
So being part of the organizing committee for the inaugural Global South ADR THIRUNAAL has been a truly enriching experience for me, and coordinating with practitioners, ADR practitioners and institutions across all time zones and Global South countries for a 24-hour event has highlighted not just only the reach of ADR, but also the collaboration we have with the Global South. So I thank Inbavijayan sir and Narmada ma'am for this opportunity to contribute and be a part of this initiative, and proud to have witnessed also a meaningful conversation that will shape the future of cross-border dispute resolution. Thank you.
Hi everyone. So it is truly an honor to be a part of this organizing committee. This initiative is, like everyone said, it is really a one of a kind event, which was the initiative of the visionary Mr. Inbavijayan sir, and it was really a great experience for us. The amount of research work which was put into helped us gain a lot of knowledge about the international arbitration practices. And thank you, sir.
Yeah, so good evening. So, as my colleague said, it was indeed a tremendous journey of a path-breaking initiative. And at this point, what I would like to say is like this could be considered as a yield or a result of a huge or a tremendous amount of work that a lot of people, a big group has put together. And I would like to take this opportunity to thank not just obviously foremost Improvision sir as well as Surya Narmada ma'am, but also CP Fish sir, Saundriya ma'am, Shakti Priya ma'am, and also Kirti sir, that I'm relatively a new member to this family. So it is more of a family for me. So thank you so much for accommodating me and letting me also be a small part of this great initiative. And I sincerely pray and hope that this initiative reaches the aim that it is sought to be reached. Thank you so much.
Hi everyone. I would consider this as a personal milestone for in my career, and this is an initiative, is a collaboration of the whole team and not a single individual or anyone else. This initiative is the idea which has grown into life by the visionary Mr. Inbavijayan sir and our founder Surya Narmada ma'am. And I would like to take this opportunity to thank CPVCist, Saundarya, Shakti, and Devdattan also. As a young arbitration practitioner, and this is an arbitration opportunity to connect with the peoples and get insights from the peoples of the same knowledge and same insights who can help us gain the knowledge through the webinars. Thank you.
Yeah, thank you, my team members. Now, on behalf of my entire team members, we invite the founder of Kovise Foundation to mention about very interesting the ideology, the plan, the execution, and now the success story. I welcome Mrs. Surya Narmada to share all what happened and what we are now here.
Dear participants, thank you one and all. Actually, a heartfelt thanks for you all and the people who worked to bring this program into this much success. And our our heartfelt thanks to the speakers. Okay, 35 speakers from around the world, and the efforts our team members have put for this is a tremendous one. And at this juncture, I like to thank one and all to make this event a very successful one. And it's not okay. The event is we can have that the event is a successful one, but it's only the starting point for the Global South ADR Alliance program. So this is the first step we have put today, and in the coming years, I think we will be flourishing ahead, and this alliance will become a big network of arbitrators with various sectors, the people from various technical arbitrators, and also one of the main objective is that, as Shahrukh Kumar told, our main objective is that we have to go globally as an arbitration forum, and at the same time we have to go to the grassroots level, to the rural communities in each and every part of the world. This arbitration awareness has to go to that way, because arbitration and other area system are even from the layman language, we can say it is one of the major dispute resolution mechanism which can settle with a win-win situation. That is the golden handshake moment we can have when we undergo the process of arbitration. So arbitration and mediation as dispute resolution mechanism, the layman and the clientele has to get the awareness in the arbitration and mediation. Thank you. And once again, my heartfelt thanks to the participants and the organizing committee members. Thank you.
I think we have reached the end of this wonderful webinar on the first ever Global South ADR Thirunal, and hope this event is just a beginning for, as founder said, it's just a stepping stone, the first stepping stone in the big dream. And let's make this event a wonderful event, an annual event, in fact, in the coming near futures.
Thank you.